once I'll be released.
Okay. That's if they're able to post that bond, then you will in fact get released on these charges. I just was asking about the place to stay. It's in the Fulton County area?
Yes, sir. It is.
Oh.
Same address I've been had since I was a little boy.
Well, all right. That's good to know. And I'm only asking because if you do get out, we're going to need to be able to track you down to let you know when your next court date is. And we do that in part by letting Ms. Rios know. And if she has good contact information, she can reach out to you. But we also always mail something. We're old school here in the court, but we will mail something. And the address I have for you is, I actually have two. One is in Albany and the other is on Beecher Road in Atlanta.
Albany was when I did my first time and I went to like a halfway house my last year. So that was just when I was incarcerated before. Well, I've been at 2256 Beecher Road since I've been in the third grade.
Okay, wow. Okay, the address I have is 2256.
Yeah, that's it.
Okay.
I've been there since the third grade.
Since the third grade, that is definitely home for you. All right, well, I hope you are back there soon. Ms. Rios, anything else we need to do in connection with Mr. Shorty's case? Ms. Dilligard?
No, Judge.
Okay, so Mr. Shorty, you're going to wrap up your time where you are. Then you'll be back at Beecher, and Ms. Rios will be working with you on your case, okay?
All right, thank you, sir.
You bet. All right. Thanks, folks from GDC, for getting us Mr. Shorty.
All right, y'all have a good day.
And schedule. Okay, Ms. Rios, we had called the first four positions. Mr. Terrell is here, but in custody. Is that your case or Ms. Woods or not sure?
It's mine, and I did file a waiver, so we're good about him.
Okay, do you need him brought out?
Oh, he's here. Oh.
Is he up?
Yeah, he's up.
He's up. I'm happy to tell him why
He's already here.
Okay. Do you need to handle your situation there? Okay, that's fine. Mr. Rhodes hasn't shown up. Jason Rhodes. I don't know if that's yours or Ms. Woods.
That would be Ms.
Okay, I'll let her know that. Ms. Stone is here. Would that be your case or Ms. Wood?
She is my case, and I did file a waiver on her too.
Oh, you did? Okay, that didn't make our list. Have you met Ms. Stone before?
Yep, Ms. Stone. Not in person, but we've talked with them.
Okay, great. Then let me chat real briefly with Ms. Stone and we can get her on her way. There's the waiver. All right. And a change of address. So Ms. Stone, I've got a Oakland Drive Lane. That's not a good address for you? All right, well, let me look at the other one that may not have made it into the system yet. How about Springdale Road? Okay. Hopefully the system updates that soon. Ms. Rios has done what she needs to do by putting it in there, into the system. So you are all set. You just need to stay in touch with Ms. Rios. She's going to get discovery in your case and want to talk to you about what the case is about and what her thoughts are about how to move forward, okay? Do you have any questions about anything? No? Nope. Ms. Rios, do you need Ms. Stone to stick around?
No, Your Honor, thank you.
Okay. Thanks for being here. All right, is it Terrell or Terrell? Terrell, Mr. Terrell, I'm Judge McBurney. Your case has been assigned to me. And Ms. Rios, your lawyer who's seated right there at the corner of the table in front of you, has already filed a waiver of arraignment on your part, meaning she entered a plea of not guilty for you. The prosecutor on the case will be getting discovery to Ms. Rios, and then she will come see you to talk to you about what's in there and what's not in there and make a plan about how to move forward, okay? You got any questions? You good?
Yeah.
Okay, I just wanted you to know why you got brought over, but turns out Ms. Rios had already done a waiver, so we don't need to do the arraignment. But when you come over next, it'll either be because there's some motion that's been filed, or you and Ms. Rios have decided to work the case out, something like that. Are you at Cobb?
Yes, sir.
Okay, all right, any questions about anything? No? All right, thank you, sir. Ms. Wood, we'll get to Mr. Mitchell in a minute. Jason Rhodes, so I'm going back to the plain arraignment calendar. He's not here.
I was expecting him on Zoom, but I will reach out, Judge. You might have told me 9:30.
Okay.
But I have a good contact, so I'll.
Great. If we can make him appear virtually or in person, that'll check that box. And then Mr. Williams is here, seated behind you all, and he says he qualifies for appointed counsel. So I don't know if position 4 would be a Wood or a Rios case.
I will speak with him, Judge.
All right. So Mr. Williams, when we take a break, Ms. Wood, who's right in front of you, is going to talk to you. Do we want to go forward with Mr. Mitchell right now?
Yes.
Okay, let's do that. Ms. Dilligard, are you handling that? I know we're bouncing around, but I promise we'll stop once we've dealt with the GDC folks, but they've been good to get people online. We only have one more after Mr. Mitchell, and she's not online yet. So we'll turn to that when we can. So let us add Mr. Mitchell. Mr. Mitchell, can you still hear me?
Yes, sir.
Great. Well, let's get you on the record. This is 14 SC 131542, State versus Jesse Mitchell. Mr. Mitchell is appearing virtually from Wilcox State Prison. He is represented for purposes of this revocation hearing by Ms. Wood, who is up at the podium. And let me, if you don't mind moving the screen a little bit so Mr. Mitchell can see you, that would be great. Mr. Mitchell, the allegations in your warrant, and I told you this before, we just weren't on the record, so I got to repeat them, are that in September of 2019, you committed a new crime of possession of a firearm by a convicted felon in Clayton County. So that was almost 5.5 years ago. And then in October of 21, you committed a new offense of fleeing or attempting to elude a police officer, also in Clayton County. And then there was a technical violation that you didn't complete something called the right way, wrong way program. I'll tell you the more serious allegations are those new offenses. They're not so new anymore in Clayton County. Ms. Wood, do you know what happened with either of those?
They're still pending, Judge.
Still pending. Have they been indicted?
Yes.
Both have been indicted. Okay. All right. And Mr. Mitchell is in GDC custody for what?
He is in custody there for a Fayette County case. I can't find him on the DOC website, but he's obviously sitting right there.
This is violation for having violated practice.
Meaning these same two Clayton County cases got them violated in Fayette?
Yes, sir.
Yes.
Yes. Okay. So you are a multi-jurisdictional guy, Mr. Mitchell. I guess you've got this old Fulton case from 2014. You had something from Fayette, and you got these Clayton cases. How much time got revoked?
Yes, sir. A year, and they terminated the rest of the probation in Fayette County.
Okay. How much time left is there on your revocation?
I have a release date set for June 16th of this year.
Okay.
Yes, sir.
And is your sense that that is the earliest and the latest you could be released, or you might be released earlier for good behavior?
That is the maximum release date.
Okay, so it wouldn't be any later than that, but it could be in May.
Possibly, God willing, that'll be perfect. But it's set.
Okay, I want to be real clear. I'm not advertising anything like that. I have no idea what'll happen. You just know your max release date is June 16th.
Yes, sir.
Okay, got it. Ms. Wood, is Mr. Mitchell admitting to these allegations or stipulating for purposes of the hearing? What's the plan?
We're admitting, Judge, and our plan is, I spoke with Officer Simpson, probation's recommendation is to revoke 6 months. It sounds like he's already done that. I would also ask the court to maybe consider terminating this case. It sounds like he's gonna go directly into Clayton County custody once he's done with Department of Corrections.
Are there holds from Clayton? Do we see that, or we just know that's his next destination?
He doesn't have any warrants.
Okay.
So as far as, he may go to claim on a corporation order.
Okay.
As far as any warrants.
Okay. My notes that I suspect came from you say there are only 10 months and a couple days left on this case anyway.
We're recommending.
Okay, so revoke 6 months and terminate.
Yes, Judge.
All right. Ms. Dilligard, have you had a chance to look into Mr. Mitchell's situation?
Yes, Judge. The state's stance is to revoke 6 months and to terminate the balance.
Okay, seems unanimous.
Yes.
All right. Mr. Mitchell, how long have you been in? When did you go in?
I was arrested in court actually July 27, 2023, and I've been incarcerated since then.
Wow, but that's more than a year. I thought you only had a year revoked.
Yes, sir. Because of the hold, I actually spent like kind of extra time in Clayton County, and once I was bonded out, I was sent to Fayette County to deal with the revocation there. And once I was there, they kept setting the court date off for months at a time, so that it kind of prolonged the situation. So that is why it stretched out to how far it has gotten now.
Got it. Okay. Do you have any questions about what everyone is recommending, Mr. Mitchell? The revoke 6 months, but you get credit for time served, and then we terminate the balance, which means if that's how we go forward, when you are finally released, whether it's on June 16th or it's earlier, you're done with your Fulton case. You're not on probation in Fulton. And it sounds like you're done with your Fayette case. You're not on probation in Fayette County, but you still have some business in Clayton to take care of.
Yes, sir. That is correct.
Okay. Anywhere else, or is just Clayton?
Just in Clayton County, just, some mistakes I made when I was a couple years younger. I learned from my mistakes. I'm ready to do better and just striving to become a better man for myself and my family, as well as society.
Where will you stay when you get out? What county?
Possibly in Fulton or Clayton. I'm not sure as of right now.
Okay. All right. Well, if you don't have any other questions, Mr. Mitchell, I find that you did violate the terms and conditions of your probation by getting arrested and indicted in 2019 and 2021 for these different offenses in Clayton County. Those are open cases, and you will work through those when you are released. I will revoke 6 months of your probation and terminate the balance. So as previously stated, when you are released from GDC custody, you don't need to worry about reporting again on the Fulton case. Any questions about any of that?
No, sir. I really appreciate you guys for your assistance.
Okay. Well, you're very welcome, Mr. Mitchell. I hope that you have turned a corner. Life can be complicated. You've been out of commission for a long time. I hope you have kids.
Yes, sir. I have a 3-year-old son.
Wow. So he has turned 3. What, did you last see him when he was 1 or something?
Yes, sir. Right before he turned 2.
Okay. Well, you need to get out and be there for him, okay?
Definitely, most definitely.
All right. Well, I hope that works out well for you. Ms. Wood, anything else on behalf of Mr. Mitchell?
No, Judge, thank you.
Ms. Dilligard?
No, Judge, thank you.
All right. Thank you, Wilcox State Prison. Mr. Mitchell is free to head back.
Thank you, Your Honor. Have a good day.
You too. All right. Ms. Torres is on now, our final GDC person. She's position 3 on the revocation calendar. It's a little different than what we normally see. She filed a motion to revoke or vacate her probation. It may be, we'll get her on and hear from Ms. Simpson. I don't know that we need to do anything to give her what she wants, given how much time she has remaining to serve in GDC custody. But before we get on the record with anything, I wanted to make sure she had a lawyer to speak on her behalf.
I know Ms. Rios had worked on this, but it sounds like something I can stand in for.
Yeah, she emailed me yesterday
Okay.
about her, and actually she was gonna be the same case as Mr. Mitchell.
Okay. Ms. Rios emailed you yesterday?
Yes.
Okay. Okay. Well, let's get Ms. Torres on the screen. Whoops, she just moved. There we go.
Good morning, Your Honor.
Good morning. Are you Ms. Torres?
Yes, sir.
Great. I'm Judge McBurney. It's nice to meet you.
Nice to meet you too, sir.
I am in receipt of your motion where
Yes,
you
sir.
asked to see what we can do with the remainder of your probation.
Yes,
And
sir.
let's get on the record in your case. It's 11 SC 100718. So it's a
Yes,
case from 2011. And the notes I have suggest that you've got 1 year and 2 months basically left on your probation. So that was a long probation,
Okay.
but it's almost
was.
done. 1
Thank
year and
God.
2 months.
Yes,
Ms.
sir.
Torres, tell me why you are in prison right now. For what?
I'm here from Fayette County.
Everyone's in from Fayette today.
Yes. Oh, Lord. For destruction of government property, which was the video camera in the police car, and driving with suspended license. And so they put me on probation. I violated the probation.
Why did you have something against the video camera in the police car?
I didn't actually. It's just day before Valentine's Day. I did not want to go to jail. That was just,
All right.
but yeah.
How long is the sentence that you're serving right now?
Okay. Fayette County, Judge Cruisinger revoked all my probation, which was 3 years and 11 months to serve. My TPM is January 2026, but I have 8 pick points, which are frozen right now. They haven't actually applied them. So God willing, I should be able to parole out in either May or July of this year.
You sound like a veteran of the Georgia Department of Corrections. I understood very little of what you just said, other than that if you don't do well in your remaining months, you're stuck there until January of 26.
Right. Yes.
But if you do all right, then you might get paroled out as early as next month.
Yes, sir.
Okay, got it. But your max is January of 26.
My maximum release date is 2028.
Oh, 2028?
Yes. My TPM is January of 26.
Oh, okay.
The tentative parole month.
I have a translator here in court, so
Okay.
we're good. All right. So if you did really poorly in custody, you're there until 2028.
2020, yes, sir.
All right. Okay. Ms. Rios, Ms. Wood said you had done some thinking about this case.
Yeah, I haven't been able to talk to Ms. Torres, but I did reach out to Ms. Simpson, and we talked about, she said she was gonna revoke 6 months and then just let it, so it all be running together. And I think she said, what did you say, revoke 6 months and terminate?
Yes.
Just given the age of the case. Let me ask you this, Ms. Torres, if you get out next month or in June, will you still be on probation out of Fayette, or because you're really, or will you be on parole for a few years?
I believe it's parole.
Okay.
She terminated all my probation, so I'll be on parole.
Okay. Is that your understanding, Ms. Simpson, as to what would happen? And I know parole and probation are different, but is the math sort of the same? If this judge revoked, it's not exactly right, but 3 years, and Ms. Torres does 9 months of those 3 years and then is paroled, would she be on parole for 2 years and 3 months to get to that full 3? She's just not in custody. Okay, so there's supervision involved if we close our case out.
Yes,
This
sir.
Fayette. Got it. Okay, excellent.
Yes, sir.
Ms. Dilligard, did you look into Ms. Torres's situation?
Yes, Judge, and I spoke with Ms. Simpson prior to, and we're in agreement with the recommendation of revoking 6 months and terminating the balance.
That seems to be the theme for today. Okay. All right. Ms. Torres, when
Yes,
you
sir.
get out, where is your home base? In what county?
It'll be at a friend's home in Sharpsburg, Georgia. I don't
And
know. I'm not sure what county that is.
It's south of here. It's not in Fulton.
No.
Okay. Okay.
It may be Clayton. I'm not Sharpsburg. I'm not really sure.
Okay. That's all right. It's not Fayette either.
No, sir. I
Okay.
don't think it's Fayette County.
All right. Well, if you don't have any other questions, Ms. Torres, I am inclined to revoke 6 months of your probation. It's 11 SC case because of your revocation in Fayette County, and then terminate the balance. So
Okay.
we're basically closing out your Fulton County case so that when
All
you
right.
are released, either soon because of your points that are frozen
Yes,
or
sir.
on your TPM,
Yes, sir.
you will be on parole out of Fayette, but not on probation out of Fulton. Does that make sense?
Yes, sir. Thank you so much. I appreciate it.
Okay. Anything else, Ms. Rios?
No, you're right.
Ms. Simpson, do you have what you need to do a revocation order? Okay, the basis is the violation of probation in Fayette, I guess. Okay.
Yes, sir.
Works for me. Anything else, Ms. Dilligard?
Nothing further, Judge.
Okay, all right. Well, I like the headsets they give folks at Arendelle.
Yes, sir.
That works real well. They need to do that at some of the other facilities.
Yeah, I like them too, but not this facility. I
Yeah.
like them better when I'm out.
All right, Ms. Torres.
Thank you, Honor.
All right,
Thank you,
good luck
Honor.
with everything.
Thank you so
Bye.
much. Have a good day.
All right, you
All
too.
right. Thank you.
And Judge, if we could turn back to Ms. Stone that we just finished on the plea and arraignment count.
One second. Yes, Ms. Stone, position 3.
I'm trying to figure out what makes this a complex case.
Maybe is count 4 a misdemeanor or
The computer theft?
computer theft? That might be it, and that's probably one that we need to put onto non-complex's list of offenses. I'm happy to be working with Ms. Stone, but I'm also happy for non-complex to sort of fulfill its function.
I was just curious. Thank you.
No, it's a great question. Let me look. I bet that's what it is. I'm gonna write that down. We're having to amend some of that non-complex stuff soon anyway to remove the second or subsequent possession of a firearm by a convicted felon, because apparently your office, and maybe the law, but it creates a logjam because the offer is like 5 to serve, and we'll take those cases. 16,993. All right, I appreciate everyone's patience, as we took things a little bit out of order. So you'll let us know about Mr. Rhodes. Great. And then Mr. Williams, you'll talk to Mr. Williams during the break. Continuing with our, calendar here, Craig Daniels. Hey, Mr. Daniels, I think your lawyer is not gonna be here till later in the morning. Mr. Manciagli represents you, is that right? Right. He does need to get here. You should want to be patient because I think we're working on getting the ankle monitor off you. Ms. Nix, I think, is handling that case. Ms. Clark, this wouldn't be yours. This would be Ms. Nix's case?
Yes, Your Honor.
Okay. So I'm not going to forget about you, but it may be that we don't handle your situation for a little while. If you can get, pardon me? Okay, if you can get Mr. Manciagli here sooner, that's great, if you know how to reach him. Okay, and just let us know his ETA. Miranda Parks, I know you did a waiver, but I don't know that Ms. Parks was excused. Ms. Rios?
She's here.
She's here, great. All right. Hello, Ms. Parks. How are you?
All right, how are you?
I'm also all right. Let me look up your case so we can type in the number. How did you know to be here today, Ms. Parks?
My lawyer contacted me.
Okay. Looks like a change of address was filed. You're now at Grand River Road?
669.
Okay. Is that a house or an apartment?
It's a house.
All right. Yep, that's in the system now too, which is great. And as for your bond, you're supposed to stay away from some address on MLK.
Yeah,
Okay. You're still doing that?
yeah.
And no contact with Teresa Nelson? Good. That's it. So, your lawyer will get discovery soon. Ms. Rios will get discovery, and then she's going to want to meet with you to talk about what's in there. It'll be body cam footage if that exists for your case, and police reports, et cetera. And then you and Ms. Rios will figure out a way to move forward.
Okay, thank you.
You bet. Just before you go, Ms. Dilligard, it looks like this is a Ms. Charles case.
Yes, Judge.
Anything I need to know from the state?
So Ms. ADA Charles is in a bond hearing in Judge Farmer's courtroom this morning. And so she did email me to let me know that she served discovery with Ms. Rios yesterday, and there's nothing further to announce on that case.
Well, all right. Be on the lookout for discovery. You saw it. All right. Do you need Ms. Parks to stick around? All right. Thank you for being here, Ms. Parks. You're free to go. You bet. Danikia Mann was excused, but just in case she's here. Nope. All right. Ms. Clark, your case?
Yes, Your Honor.
All right. You'll get discovery to Ms. Wood?
Yes, Your Honor.
Great. Crystal Alexander.
Good morning.
Good morning. How are you?
Oh, well, thank you for asking.
All right. So I was okay with Ms. Parks, but I'll upgrade to well with you. So I am well. Let's figure out, did you hire an attorney? Do you need an attorney? You need an attorney appointed? Who would that be from our desk of defense attorneys? All right, Ms. Alexander, Ms. Wood is going to talk with you, and then we'll talk, all four of us, meaning the prosecutor as well, so I can make sure we've got a good address for you and just go over your bond conditions again with you. Okay? So we're going to take a break in just a minute once I get through calling this calendar, and Ms. Wood will meet with you.
All right, thank you.
You bet. Courtney Dillard. We have a few people online. I'll make sure she's not online. Courtney Dillard. Nope. All right. Has anyone, Ms. Wood, Ms. Rios, any contact with Ms. Dillard? All right.
State request the bench warrant, Judge.
Okay. It's not a particularly old case. All right, bench warrant it is. Mr. Hassan. Is Justin Showalter, he's with your office?
Yes, he would be mine, but I haven't had luck getting in touch with him.
Okay. Bench warrant?
Yes, Judge, please.
All right. We just dealt with Mr. Shorty. And then Mr. Johnson, Alburn Johnson, he was excused. His lawyer filed a waiver. Mr. Pierce, we'll bring him out in a minute. Let's get through this. Do you know if Mr. Abate is going to be here?
I'll reach out to him. Right.
Okay. I mean, they're in trial still. I don't know if the defendant is still testifying in that case or if it's closings now.
I know Mr. Abate will be here this afternoon, Judge.
He better be.
Yes.
And we can handle Mr. Pierce's situation then. I'm giving him his discovery. We're arraigning him. But Mr. Pierce being Mr. Pierce, someone from your office should be here for that. He represents himself now. But there's no, I mean, if he's in the middle of something, we're okay. Is Pierce up? Yeah. Okay. All right. Aaron Nolan.
I also filed a motion to set his bench warrant.
Yep. Have you talked with Ms. Dilligard about that?
Have not.
Let's chat about it.
Okay,
What's
what's
do you know why he?
he missed because he says.
Is there anyone in court whose name I didn't call? Nope, you're all here for some other case or I called your case. All right.
Your Honor, also, I asked the deputy to keep Quantavious Terrell only if you would entertain me arguing much this is at the bench warrant. I did not file it until this morning because I thought the bench warrant was on his unindicted case, but then that case got dismissed. And then I looked in the system and it seems like he also had the bench warrant in this case, which I did not catch.
You're still talking about Mr. Nolan?
Yeah, sorry.
No.
I was saying also, if we could go back to Quantavious Terrell.
Oh, Mr. Terrell.
Yes, because what's holding him in now should only be the bench warrant. In this case, I thought he had the bench warrant in the other case, but if that's not true, and the other case was
Dismissed.
And so this is the only thing holding him in. I was discussing with Mr. Gilligard about it, so it seems like if we could have both hearings on the other side.
Okay, so I miss her. I thought you said we needed Mr. Abate for that. Like that he's welcome to be involved with that one. But all right, so we'll bring Mr. Terrell out in a minute to talk about setting aside a bench warrant. And then Mr. Nolan, are you gonna do a waiver?
I've already filed a waiver for Mr. Nolan.
Okay,
So I've already explained that, only thing we discuss is you see his bench warrant get set aside.
okay.
And Judge, for Terrell, that is 88 Charles' case. I just texted her to see if she could give me what her stance is on that since we.
Oh, position one, the aggravated assault. It's a family violence one.
Judge.
Okay, all right. And we can do that later. If all she's doing is a bond hearing in front of Judge Farmer, she'll be free soon enough. So we could handle Nolan. We've got all these revocations to do. So I'm happy holding off on that.
So she says a bond hearing in Farmer and a multi-purpose in Carnesal at the same time.
I don't know what the second one is, but she's in high demand.
Yes.
We'll take care of Mr. Terrell this morning. It just doesn't need to be the next thing we do. And if she can't make it, I'm sure you can handle it now that you've handled the murder trial. And made it on TV.
Yeah.
Pretty amazing. You're gonna feel kind of in the boondocks out here. We don't get TV like that, so. Let's also figure out who's handling things on the revocation calendar. Ronquel Green.
He's mine, Judge.
All right. Have you and Ms. Dilligard spoken?
No, I will do that during the break.
He has 4 revocations. 2 are on the calendar, but Mr. Green was super busy back in like the 2010. They're all old. There's nothing new, but they all have 5.5 years left.
I saw he also has a production order to return to a different jurisdiction, so I think we'll be able to work this out later.
Okay. We dealt with Ms. Torres. We dealt with Mr. Mitchell. We've got Travion Williams.
I just need to talk to Ms. Dillard. I reached out to Ms. Simpson about it, but, we're on like two far different things.
Okay, we'll talk, and at a minimum, we'll bring Mr. Williams out, and if we need to have a evidentiary hearing, we can do that. What is it? He has new charges. They're not so new, but okay. Got it. And then Mr. Alexander.
Mr. Alexander, I would be asking for a reset, and I do need to explain that to him. I'm looking for a program, and Ms. Ross, I think it was Salvation Army, but they still need to interview.
He's not gonna go. You should do what you think is best. I want you to also manage Ms. Ross's limited resources. But Mr. Alexander, I know well from, I can't remember if it was drug court and that didn't work. I think it was. And then programs again and again that he doesn't go to. I'll certainly give you that time because he's got time to spare. But I just want you, as Ms. Ross is saying, hey, I've got 10 things on my plate. How do you want me to prioritize? I don't know that she's, and you are going to get a lot of traction.
Drug court?
Yes. Yes. He's in a rut, drugs and shoplifting again and again and again and again. He's, and we'll talk about it with him here. And I'm happy to give you time to do that because you may want to present something other than what the state's going to be asking for, which I suspect is not a program. But even if they ask for a program, there's someone else who'll probably be thinking no to a program. So you're just coming in on the tail end of Mr. Alexander's storied career here. And he's got two cases. So, all right. He has 3. Okay. Yeah. All shopliftings, probably all were in drug court until he got kicked out of drug court for shoplifting. All right. Those are our 2 morning calendars. So why don't I let you guys talk with a few people here and inmates, and I will come back out once we're ready to do our bench warrant set aside arguments or any of these revocations. I'll be right back there. And if Mr. Abate makes it here, you can also do Ricky Pierce. Ms. Clark, what do you have? I don't mean to keep you stuck here.
Position 12, it was that an excuse because of the waiver, Alvern Johnson?
Yes, Mr. Jones got the green light to excuse his client.
Okay.
That's it.
Okay, so I can make this happen.
You got stuff on the afternoon calendar?
Yes, sir.
Great. I will see you then.
All right, thank you.
Bye-bye. All right, I will. Hey, Ms. Stone, can you unmute for a sec?
Yes.
Hey, good morning. I'm Judge McBurney. I saw your chats and I'm not finding the case. Can you tell me what the case is so I can either let you go and let you know when you should be back or?
I think it was Wade. She was excused. Tamika Man was excused. Her daughter, which is my granddaughter, Michaela Man.
She's the paternal grandmother of the victim child
In what case?
in Danica Man, position 7.
Oh, Danica Mann. Yes. So, yeah, Ms. Stone, Ms. Mann's lawyer, who you saw on the screen for a moment, Ms. Wood, she waived arraignment for Ms. Mann. And because we are able to find Ms. Mann, she's not someone hard to find. Ms. Mann was excused from showing up because all we would have done today was say, all right, you know the conditions of your bond, you know how to reach your lawyer, et cetera, and they do know how to reach each other. So the next step in this case is that Ms. Clark, who you can see on the screen there, she just waved, she's the prosecutor, and her victim witness assistant will be in touch with you if you're the point of contact for the child. The next thing would be, we'd be in court if there are any motions that are filed, like a motion to suppress or something like that, or for what we call final plea, which would be the last day for Ms. Mann to resolve her case with a plea where she'd have the right to withdraw her plea if she didn't like the sentence that she got. That's a little ways down the road, so it may seem for the next couple months like nothing's happening. But what's happening is that Ms. Wood, the defense attorney, is meeting with Ms. Mann to go over the discovery, and they're strategizing, deciding, is this a strong case for the state or is it not a great case for the state? And then that'll inform their decision. Boy, we better try to work it out, or what's in the best interest of the child, et cetera. But every time there's a court date, you ought to be receiving notice if you're the primary How did you know there was court today?
I was contacted by someone from the courts.
Good. That person or a colleague of that person will continue to contact you each time there's a court date. But there aren't many left. Again, there would be one if we're arguing motions. Otherwise, it would be final plea. There'll be a scheduling order entered in the next couple days. And if you call the person who called you, that person can look on the computer to give you those specific dates when we would next be in court, if that helps you plan, because I'm sure you've got other things you need to be doing as well.
Yeah, I took off for work.
Okay. Well, I appreciate you doing that. It's always important for members of victims' families to stay plugged in. I'll tell you, as the judge, it helps me to get more context. I'll always listen to what a prosecutor has to say, but Ms. Clark is always going to be one step removed. She's not family. She's an advocate, but she's not family. And so hearing from you at the appropriate time might help me better understand how your granddaughter's doing. And that's important to me. So I encourage you to stay involved. Hopefully we won't make you have to take too many more days off work, okay?
I don't mind. I'll do anything for my granddaughter.
Okay, well, she's fortunate to have you. Do you have any other questions, Ms. Stone?
Not at this time, I don't.
Okay, well, thank you for joining us. And that victim advocate will certainly be in touch with you again when another court date is approaching.
Okay, thank you so much.
All right, take care.
Mhm.
is the background. I got her down to her.
All right. What are we ready for?
I have an announcement. Okay, we'll see.
Okay, off our plea and arraignment calendar.
Yeah.
How about Jason Rhodes?
He did not answer and did not respond to my texts.
All right, so we'll do a bench warrant, but since you have had contact with him, if you can navigate him into court one of these days, we'll talk through that. Mr. Williams, he's still here. Ms. Wood, your case.
I am working on the waiver right now on the file. I've spoken to Ms. Dilligard. I think this will be one that will resolve fairly soon.
Okay. All right. That's not it. Mr. Williams, I've got an address on Jonesboro Road. Is that a good address for you? You don't live on Jonesboro Road anymore? Okay. Ms. Wood, can you see, maybe you have a different address?
He has a notice, so I know we got, I do have his address, so I'll update it.
Okay, that'd be great. The docket sort of, oh, there it is. Order for bond. Hello?
You can see only her, one other person in her department.
Whoops, that's Ms. Nelson. Awkward. So, Mr. Williams, your bond is kind of old, but it still applies, and you are supposed to stay away from an apartment on Dodson Drive. You're still doing that? Okay, and then there's a Yolanda Williams you're supposed to have no contact with. Is that someone related to you? Okay. Is that someone that you have stayed away from? Okay. If that needs to change for some reason, because it's your child or your spouse or your brother or sister, talk with Ms. Wood and we can have a conversation with the prosecutor and me, et cetera, to see if we need to modify your bond, okay? All right. Ms. Wood, does his notice go to the right address?
Your paper.
I can look it up too.
Yes, it's 5509 Rosewood Place.
Okay, that's odd that it didn't show up in the system, but he's getting notification. If you do a change of address anyway, please. All right, so Mr. Williams, Ms. Wood has entered a plea of not guilty on your behalf, and she'll get the address updated in the computer system. You'll get notice in the mail, but Ms. Wood will probably reach out to you as well when you next need to come to court. What'll probably happen next is she'll want to meet with you to talk about the discovery in your case, which will be heading her way soon. Do you have any questions about anything? All right, Ms. Dilligard, anything on behalf of the state? Is this your case?
Yes, Judge.
Okay.
I'm gonna look into possibly sending an application to diverge.
Okay. Sounds good. Keep me posted. Ms. Wood, do you need Mr. Williams to stick around?
There.
All right. Thanks for your patience, Mr. Williams. You're free to go. Mr. Daniels, still here. I know that your lawyer confirmed he can't be here till a little after 11.
Yeah, that's fine.
Okay, great. Stick around. We dealt with Ms. Parks and Ms. Mann. How about Crystal Alexander?
She's mine, Judge. I've spoken to her. We've exchanged contact information and I will file over today.
Okay. Ms. Alexander, I have an address of Concept 21 Circle.
That's correct, Judge.
Great. If you move, make sure you let Ms. Wood know so we can update that. And your bond says you're supposed to stay away from some place on Hamilton Holmes Drive.
Great, you're.
Okay, and stay away from someone whose last name is spelled Nissir.
Okay.
Sounds like you're doing that. Okay. Then you are all set. Ms. Wood will be in touch with you once she gets discovery. Do you have any questions about anything?
No, sir.
Okay. Ms. Dilligard, anything from the state? All right, Ms. Alexander, you are free to go. Thank you.
Thank you. Y'all have a great day.
You too. Courtney Dillard is still a no-show. All right. How about, oh yeah, Mr. Hassan also. No, Mr. Hassan. We dealt with Shorty and Johnson. Mr. Pierce, we need Mr. Abate, so that may be this afternoon. Do we want to handle Mr. Nolan's situation now? Okay.
And, we also have family here for Mr. Terrell.
Okay, well, we can do that next, and that'll close out, other than Mr. Pierce, the arraignment calendar. Mr. Nolan, I'm Judge McBurney. Nice to meet you. You are here today because you missed court in December, and I signed a bench warrant that somehow caught up to you. And Ms. Rios, your lawyer, wants to have a conversation today about setting aside that bench warrant. It looks like you already had a bond in the case that you clearly made in, looks like maybe November of last year. And she'd like that to be reinstated. So I'm going to hear from your lawyer and the prosecutor, and we'll figure out what we're going to do. And in explaining what's going on, Ms. Rios, tell me, I think you said there was some other case, but that was dismissed.
Oh, that
or-
was Mr. Terrell.
That's Mr. Terrell. So Mr. Nolan, he may have some state cases. I see some CR numbers on here, but this is his one Superior Court case.
Yes, that's my understanding.
Okay, so what happened?
So he got notice 3 days later. So his child was just born.
In
Yes.
February, and then I'm also going in and out the chiropractor office because I have a case with the dentist law firm. I almost got killed by a tree that fell on me while I was in my car, and I also been back and forth in the hospital with my baby mother. Her name is Brianna Phillips, and I got another baby mother on the way, named Alexis Riddle. So I've been like kind of back and forth trying to handle everything. The court date came like 4 days later. Then I got the indictment in February. Then I got another court case. So it bounced from East Point to state court and then to Superior Court. So when I got the court case in February, it was about like 5 days later whenever they rescheduled it, I think. But when I got the paper, I tried to call around to see, and they said I can't do like a makeup day, and I never got into the makeup day because I was arrested on a warrant.
Okay, and you may be referring to maybe some of your state court cases as well, because there are no February dates here.
It said it was set for February 8th, the last court date that I received about this case. It said it was set for February 8th, and then I called around, was trying to make sure, and I couldn't get a hold of nobody. I didn't know what was going on because it moved from three different like courts.
Okay. I'm looking at your 2 state court cases. So you've got a simple battery case and an obstruction of officers case, but none of those have a February date. Those all happened in March of this year.
I think I got indicted or something. You guys sent me some paperwork for February 8th, but I got it like on the 14th or something like that.
Okay.
I don't know what I got for February 8th though, but I know I had got the indictment paper. I got that in February also. So everything was sent out late.
Okay. I don't know why you get the indictment. Indictments don't get mailed out to folks, but I believe you that you got it, but that's odd that that would come in the mail to you. And again, there's no February date, but I'm hearing you. You got a lot going on. It sounds like a couple of mothers of children and whatnot. And you've got these 2 new cases in state court as well. So I'm curious if you know, Ms. Rios, what's behind the state cases, because as I'm looking at the docket, it won't let me open the accusations. It kind of looks like while Mr. Nolan was on bond in this case and in bench warrant status, he got arrested maybe for 2 different things. But I don't want to get into the facts of those cases, but I'm interested in the procedure of those cases. It matches up that in this case, Mr. Nolan had a first appearance and the judicial hold was lifted or the case was reinstated on that same March 3rd date, which is the day the accusations were filed in state court for the misdemeanor obstruction and the simple battery.
I have to look into that. Honestly, I'm not sure what's going on with those state court cases.
Okay.
But I don't believe that it seems like he's been trying to get in touch with someone to make sure he comes to court. He didn't have anybody's contact number. Now he has my contact number. I gave him my Google Voice number. We would be in touch. I don't believe he would miss court. He has a child. He has a 9-year-old child and a newborn, right?
Yeah, I got a newborn from last month that was just born on February 26th. And then I have a newborn coming like this month. So.
Yeah, you got to work on that family planning part.
Yeah.
And he was working at AutoZone, but now he works at Waffle House and Big Game. And he goes to Atlanta Institute for Music to get his master's in music production. And so I'm asking that he be released so he can continue with school and continuing to provide for the newborn and getting ready for the other newborn.
Next newborn.
And his 9-year-old daughter. I will make sure I text him all the information with court dates. He has my number. He's given me a good contact number to call as soon as he gets released. I also have the address that he will be living at, so make sure the mail goes there.
Okay. What's Bit Game?
The Big Game is a restaurant. It's by I think North Avenue. Yeah, it's North Avenue, and it's a real fancy restaurant.
Okay, and what do you do there?
I prep cook.
Okay, and what do you do at Waffle House?
Waffle House. I'm a cook.
Okay, so you cook.
Yeah.
It's called Big Game?
Yes, Big Game.
Okay. Let me hear, please, from Ms. Dilligard, her thoughts about setting aside the bench warrant and what she's been able to see is going on in state court.
Judge, so it sounds like there possibly was a notice issue. Seems like he might have gotten notice after the court hearing. I'm not really following the dates that he stated. However, it sounded like he was busy trying to figure out how he can come to court while also busy picking up new cases while in bench warrant status on this case. Judge, also when just peeking at his GCIC, I saw some previous FTAs that were concerning to me. And so I kind of battled with this one because I don't know if notice was good, but however, I have concerns about him showing up to court due to his previous FTAs. Also the additional cases that he picked up while on bond in this matter. So the state's gonna leave this in the court's discretion, but I did want to make those notations for your attention.
Okay. Mr. Nolan, what address were you at, or what would have been a good mailing address for you last year?
Last year, it was 2995 East Point Street.
Yeah.
Apartment 127, 30344. Now it's 877 Virginia Avenue. It's still a good mailing address because that's my P.O. box. That's why I still receive the mail from.
The one on East Point Street?
Mm-hmm.
Okay.
Yeah, and I was like trying my best to check it every day, and I just didn't get anything until after the court date was over.
Okay. All right. So here's what, anything you want to add, Ms. Rios? I'm going to poke around a little bit more on the docket as to the two state court cases. They won't let me open one file, but I'll get access to that. Like Ms. Dilligard, I'm pulled in two directions. It looks like the notice that was sent out was half right. It was the East Point Street, but it didn't have the box number or the apartment. So I'm seeing what got sent to you.
Okay.
It's got your name and it's 2995 East Point Street in East Point, Georgia, but it's missing that piece.
Yes.
Which would explain why it took a while to get to you.
Okay.
It may well have come late because that's just like a mailboxes, et cetera, or UPS store.
It's a mailbox I pay for.
Okay. That a mailbox you pay for, like this is someone's house and you pay to get money there?
No,
it's a P.O. box.
It's a P.O. box.
Okay.
Yeah, it's where I actually received my mail because, I was moving from place to place.
Sounds like you were very mobile. So that says to me, you didn't get notice. But then we've got what was going on in March, which has nothing to do with whether you came to court. I'd be worried about that, even if in December you had shown up for your plea and arraignment, that while on bond, you got picked up for other charges. Right. So I'm gonna look at that, and if I'm comfortable that the state court situation isn't particularly serious, then
I can actually speak on it if you want me to.
Yeah, so you should talk to Ms. Rios about it, and she may want to get something to me after she filters through that. And of course, she'd share it with Ms. Dilligard as well. But you can talk to her about that. But those are the two, just so you know, those are two things I'm balancing. It looks like we had an incomplete address, not your fault. But then there are these two new cases you picked up in state court in just last month. And that is on you as opposed to that. So I'll balance those, and then I'll certainly let Ms. Rios know. I don't have a way to let you know directly, but she'll let you know what it is that I'm going to do.
Okay.
In the meantime, are you waiving arraignment, or have you already done that?
Filed a waiver.
Oh, let me go back to. Yep. Okay. So we'll get a scheduling order out. That'll get you the discovery in this case. And then Mr. Nolan, you and Ms. Rios can start moving things forward. Let me check one last thing. So the address now in the system says 2995 East Point Street, apartment 127.
That's correct.
Good. That's the right.
That's the correct one.
Okay. All right. Should it say apartment or box?
It could say apartment or suite.
Doesn't matter. Just 127 is the magic.
7.
Okay.
Yes.
All right. 30344. So that's been fixed. And things in the future should get to you. Plus, Ms. Rios knows how to reach you. Do you have someone on the outside who is a good contact? It sounds like there's several ladies in your life, but someone who won't hang up on Ms. Rios when she said, "Hey, I'm trying to find Aaron."
I gave her my mother's number.
Okay. Hopefully mom will take the call.
Yeah, that's the number.
All right. The child who just arrived is a boy or a girl?
It's a girl. Her name's Alana.
Alana. You haven't met Alana yet? No. And then the child who's about to arrive, do we know a boy or a girl?
I don't know yet. She's trying to surprise me.
Okay. Well, it will be a surprise either way. How are the two moms getting along with each other?
Well, the other one just she's like on the other end, and the other mom wants to meet the other mom, but they haven't met yet. So
All right. It might be a good idea to
yeah,
keep them apart for a little while.
because she's kind of mad that I'm having another baby.
I could understand that, but that's something you'll get to navigate one way or another. Ms. Rios, anything else on behalf of Mr. Nolan?
No, Your Honor.
Okay, Ms. Dilligard?
Nothing further, Judge.
Okay, anything from DCS? All right, Mr. Nolan, I'll let Ms. Rios and Ms. Dilligard know soon what I'm doing, and then Ms. Rios will let you know.
Okay. Thank you.
All right, I think that's it for plea and arraignments. Oh, no, Mr. Terrell. Let's bring Mr. Terrell out. And it's Mr. Terrell who had a case that you thought the bench warrant was on, and that case has been dismissed.
Yes, Your Honor.
Okay.
Because the officer didn't show up, so it might.
Oh, that kind of dismissal.
Yeah.
Okay. The kind of dismissal where that case will come to us once it's indicted.
That's what it was.
We're ready for Mr. Terrell again. Hopefully he's still up.
You go probation?
Hey, Mr. Terrell, you're back. We're going to talk about a bench warrant in your case. Let me see what happened. So you had plea and arraignment here in September, and you didn't show up. So I signed a warrant, and then I guess you got arrested again, or came back at least to Fulton County in February of this year. So I'm going to hear from Ms. Rios about what was going on. I'll also hear, Ms. Dilligard, are you okay handling this?
Judge.
Okay. And I'll hear from the state. So Ms. Rios, tell me what you understand was going on.
Yes, sir. At the time that he missed court, he was homeless. Now he has a place to stay. He'll be staying with his grandfather at 2415 County Line Road, Atlanta, Georgia, 30331. The mother of his unborn child is here, and his girlfriend is here. And so they
Are they sitting near each other?
yeah. See, they came in support and they're working together.
You guys need to help out that Mr. Nolan guy, how he's going to navigate that. Yeah.
And so they verify, and I have the girlfriend's number, so I will be communicating with her about court dates. He has a stable address now, so he didn't get the notice because he had nowhere to get the notice before. So I'm asking for the bench warrant to be set aside so he can go back to doing DoorDash and Uber Eats and providing for his child on the way.
Mr. Terrell, is this your first child that's coming, or do you have other kids?
No, sir, I don't have no kid beside the one that's on the way.
Okay. Do you know if it's a boy or a girl?
Supposed to be a girl.
Supposed to be, like that's what you're hoping, or a doctor told you?
Exactly what it is.
You're hoping.
It is a girl.
It is a girl. It's exactly what it is. Got it. Is that your understanding? Girl? Okay. I am looking here to see what was going on. Mr. Terrell. Yeah, it looks like, did you used to have an address on Jones Avenue?
I don't know what that is.
Okay. For whatever
I
reason,
don't really know the street name.
Okay. It got sent there, and got returned to the court as undeliverable. So it sounds like the notice that went out, never got to, check that one more time. Oops. Yeah, I don't know why, but in the system, the address originally was this 1110 Jones Avenue, which is not even a good, not just for Mr. Terrell, but that's not a, what does it say? Not deliverable as addressed. So he did not get notice. Is there a probation issue? I've got a PV warrant listed here.
They sent it to you, Judge.
Okay, by in some other courtroom?
Yes, Judge.
Okay, did you get revoked? What happened?
2 months and 18 days.
Okay, so you still have some time to serve? Oh, he served the 2 months, 18 days.
Honestly, he must have received some credit because he's done with us.
Oh, okay. All right. Oh, this old case. Your bond or this is interesting. Your bond order says to stay away from the address where we mailed your notice, which is not a good address anyway, and you're not even supposed to be there. So we sent your notice at a place where if you were there, you would have been violating your bond order. That doesn't seem to be your fault. You're also supposed to leave a guy named Theodore Wilkins alone. Does that name ring a bell? That's a yes? Okay. When you get out, are you able to stay away from Mr. Wilkins?
Yes, sir.
Okay. Ask her, sometimes that's like it's a relative and you might be going to your grandpa's house and Mr. Wilkins would be there because he's your cousin, but he's someone you can stay away from?
Yes, sir.
Okay. All right. Ms. Dilligard, anything you have to add to this situation?
Judge, no, I'm just notate that it sounds like there wasn't good notice in the case, and so it's not objecting to setting aside bench warrants as long as he has a good address on file and it's, and PD Rios is confident that she will have communication with him in the future. I did look at the warrant to just look into it a little bit deeper. It's flagged as a family violence case, but just reading the facts of the case, I believe it will still be mine.
Yeah, Mr. Wilkins is listed as basically a roommate.
Yeah.
And so whatever happened in September of 21,
Maybe between, like a stepfather, stepson relationship.
Okay.
I believe that this case will stay with me.
Okay.
But yeah, that's my stance on the bench where we have no objection due to the no good notice in the case.
Got it. Well, we got the new address of County Line Road in the system. Ms. Rios knows how to reach you. Do you have a phone number of one of the young ladies here?
Yes, and she's.
Girlfriend or a mother of child?
Friend.
Okay. All right. You lead an interesting life, Mr. Terrell. I will set aside the bench warrant. You ought to be released, if not today, then tomorrow. If you're still in by late tomorrow, call Ms. Rios and she can let me know and we'll figure out why you're stuck. Now, if you've got a hold from somewhere else, I can't fix that. But if the only thing keeping you in is this bench warrant, that'll be gone today. Okay?
Yes, sir.
Any questions?
No.
Do you understand you're staying at your grandfather's house? There are all these nice ladies here for you, but your home is your grandfather's house.
Yes, sir.
That needs to be where folks can find you.
Yes, sir.
Okay. All right. Any questions? You're good to go?
Thank you.
You're welcome. When is the child due? May. You ready? Yes. When in May? Early, late?
Supposed to end around his birthday and my birthday.
Okay. So you got a little while left. Good luck. Keep him out of trouble between now and when he resolves the case, all right?
Yeah.
Good luck. All right, should we bring out any of our revocation matters? I think that's what we've got left for this morning. Mr. Monsiagli just showed up, but he's the lawyer. This is, I think, for Ms. Clark's. It's a special unit case. It's Ms. Nix. Ms. Nix will need to get here, but that's not you. What did you want to do?
I can make an announcement on positions 1 and 2, Ronquel Green.
Okay,
This is actually gonna be handled by John Melnick,
by whom?
Jonathan Melnick.
Okay,
And I've been emailing.
as in
with him.
retained by.
Yes.
Okay,
And I've been emailing with him. He has asked me to ask the court for a reset. Mr. Green has a court date in non-complex on April 18th. So I think it would probably then they're the charges that are, okay, yes. So it's all intertwined. So if we could reset this to some date after April 18th.
sure, but the basis for the warrants was, it says Clayton County. Maybe they're just mistaken as to.
There's other,
The charge that you bring to you.
okay. Oh, I got you.
He has a
My bad.
whole bunch of charges out of Clayton. I mean, it's one incident, but it's many counts out of Clayton from around Thanksgiving of last year. That's all that I saw on the warrant, but maybe I didn't go to like page 3 of the warrant.
I think I might have gotten my wires crossed, Judge. He does have a non-complex case that's,
He may as well. I'm not saying he doesn't, but that's not the basis of the warrant yet.
yes, Judge.
But either way, Mr. Melnick is handling that.
Yes.
Are we setting it down so Ms. Dilligard can have the right people here for an evidentiary hearing because the sides are far apart? And I ask only because we can make it a 3-step. This is step 1. He's here and we'll reset it to get his retained attorney here. But if the state is asking for some time because of Mr. Green's history and the fact that these allegations are kind of more of the same, and Mr. Melnick was thinking it's a, why isn't it time served? Then we'll have yet a 3rd date where then it's an evidentiary hearing. So I don't know if you and Ms. Dilligard had initially talked about numbers.
I know what their recommendation is. I assume Mr. Melnick is not going to like it.
Okay.
But I don't know that he's had time to process it. I did just email it to him.
I think we'll set it down for an evidentiary hearing. It's going to be far enough out because it will be after the 18th.
Perfect.
That way we can just do it in one fell swoop.
Makes sense.
Okay. I'll explain that to Mr. Green if you want to bring him right to the door.
And Mr. Gray does have family here, and I.
Great. Okay. We'll have him step a little away from the door so you all can see him. And Ms. Dilligard, you may, time permitting, want to coordinate with Ms. Simpson to see if there should be an additional petition or warrant related to the non-complex case as well. Because you may decide that's an easier one to present because it's local and not Clayton, but that's up to you. Hey, Mr. Green.
How you doing?
I'm doing all right. I'm Judge McBurney. Your revocation matters are with me. I think your cases were probably Judge Downs cases. They're old cases, but you got a bunch of probation left. And we didn't realize you had hired Mr. Melnick to help you maybe with your new case you have in our non-complex division, but in particular with these revocations. So he did not get notice to be here. I know you spoke with Ms. Wood, who is another defense attorney, but who will not be your lawyer because you've hired Mr. Melnick. So we're going to set this down for another date after you. I think you have an appearance in non-complex coming up in just a couple weeks. And we'll let that happen and then make sure we can get Mr. Melnick here for the revocation hearing in connection with, I signed 4 warrants for you because you have 4 different cases from Judge Downs for which you're on probation. Okay?
I wasn't sure was he paid for this or just for that? But it might just be paid for that, and I probably need lawyer for this.
So what was I know Ms. Wood and Mr. Melnick have been communicating.
I talked to Mr. Melnick after I talked to Mr. Green, so he is going to be in this case.
Okay, so you're in with Mr. Melnick. He will cover that stuff. we wouldn't be able to do it today anyway. I don't want you to think, dang, because Melnick, I have to delay it. Ms. Wood had initially on your behalf asked for an evidentiary hearing. In other words, the state has to prove up what's alleged here, which is that in November of last year, you got arrested in Clayton County for a bunch of different charges. And of course, you're entitled to have the state prove it up. Today wasn't for that. It was to see if this is something that can work out, but the two sides are pretty far apart. So we're bringing you back regardless of who your lawyer is, Wood or Melnick, so the state can try to prove what's alleged here. They'd have to bring in an officer or officers, and they'll do that. And it's like a mini trial, no jury, it's just in front of me. And if the state meets its burden, then I find you violated your probation. Then we talk about, all right, so what? What are the consequences? Okay? But it will be Mr. Melnick handling that. Okay? So you'll be back in court in just a couple weeks in connection with the new charges in non-complex. And once that's happened, we'll get you here in 8D for the revocation hearing. All right? And there's family here for you, just so you know. I don't. We didn't know about Melnick, so we'll figure out his schedule as well and make it happen. Okay. Thank you. Thank you, Ms. Wood. We did Torres, Mitchell. This Torres reminded me a little bit, but in a more stable way, of Hanholt. Did you feel that?
Yes, Judge.
Yeah. Yeah. They should meet each other. They're in the same place.
Oh my God.
Can see Hanholt with that headset on. All right. Mr. Williams is next. Ms. Rios, are we going forward with that? All right. We can bring him out whenever you're ready. Hey, Mr. Manciagli, how are you? I will let, you're here a little early, which is great. I think we need Ms. Nix here, who's on the other side of the equation. And your client's here. He's been here, he got here at 9:30 or 9. He's been here ready to go. So let's see if we can get Ms. Nix here. All right. Mr. Williams?
How you doing?
I'm all right. How are you?
I'm all right.
Good. We're going to get on the record in your case. It's 18 SC 16 16 16. You were charged with armed robbery and carjacking. It must have been reduced to something. And while you were on probation, it is alleged that in March of last year, so just about a year ago, you got arrested for possession of cocaine with intent to distribute, a few other things here in Fulton County. So it's what we call new offenses. That's the allegation. Obviously, that's a violation of probation if true. And we're working through how we're going to handle that. You have a little less than 3.5 years left of probation on your case. Ms. Rios, is Mr. Williams, first of all, what's the status of the arrest?
It's still an open case.
It's a CP or P, who's here? Ms. Nix. It's a CP or a PI
I
case.
believe so.
Okay.
Been indicted. I have an SC number.
Oh, well, there you go. What's that number?
I believe it's 24 FP 004989.
What were we indicted?
There you are with non-complex. So, along with an Ashante Robinson, Let's see if that is this. Sydney Gibson represents you in that case. So that's the conflict defender-ish person in, I think just because your office represents the co-defendant in that case.
Oh, okay.
So we got to work through a couple things, but that's that indictment that Ms. Dilligard found are these charges. So two things. One, we need to make sure there's not an issue with you continuing to handle the revocation. And then two, we need to think about whether really this revocation ought to sit tight and be part of the way the non-complex case is resolved. The only wrinkle is non-complex. If this were in front of Judge Dunaway, then I wouldn't handle the revocation. I'd say, I would if you all wanted to do that, but it would make more sense to have the revocation be part of the resolution of the new charges in front of Judge Dunaway. Or sometimes you've done this before. Hey, we're ready to plead to that. Could we just plead here and wrap up the revocation? That you certainly couldn't do a plea because your office, I believe, represents the co-defendant. But let me confirm that. No, Renee Rockwell represents the co-defendant.
Oh, okay.
So that twists things around. What were you planning on doing today, not knowing that it had been indicted?
Going forward and stipulating to the arrest.
Okay. All right. And was it something that was negotiated or there was a disagreement as to how it would play out?
We're asking for two different things.
Okay. I'm happy still going forward. I'm not a big fan of kicking it down the road just because we can, but you and Mr. Williams may want to talk about whether there's some strategic reason to say, let's hold off on this and see what there's a.
C1 or C2?
How do I find that out?
It should say, if it's NC1, it won't have it to say non-complex. If it's NC2, it will say, I think it will say non-complex too.
Thank you, Judge
Judge Mao.
This says NJ non-complex. Let me see. Here's a scheduling order. That should give it away. Yeah, Judge Mao. So whatever Judge Mao is, NC Mao.
You might want to handle it today.
Yeah. Was Ms. Sarafazi with your office?
Yes.
Okay, so your office briefly represented Ms. Robinson. Is it a female? The co-defendant in that case, Ms. Robinson. And then it sounds like she retained Ms. Rockwell.
Okay. 1 second.
Sure.
SLT.
Ms. Nix, have you and Mr. Monsiagli discussed the bond situation? Because he's right there if you haven't. Okay, got it.
See what he does. Okay. He wants to go forward today.
All right. Well, let's do that. So, Mr. Williams, we're already on the record in your case. I want to make sure you're comfortable waiving any possible conflict that Ms. Rios would have, and she wouldn't have it personally, but her office temporarily represented Ms. Robinson in your new case. You know what I'm talking about when I say new case? Yes. Whatever this thing that happened last March where you and Ms. Robinson got arrested. Ms. Rios's office very briefly represented Ms. Robinson. They've rolled off that case because Ms. Robinson hired someone. And you have what we call a conflict defender, so an appointed lawyer who's not with Ms. Rios's office, because you and Ms. Robinson need to have different lawyers in that case. This is not that case. So it is fine for Ms. Rios to handle this revocation as long as you're telling me you don't mind the fact that someone from her office for a few days represented Ms. Robinson in these underlying charges. You all right with that? Yes, sir. Okay, then we'll go forward. Ms. Rios, what is your recommendation in Mr. Williams's situation?
To revoke 30 days, he's been in for 30 days. And my understanding from talking to Mr. Williams is that he has been doing good on probation other than getting this case. He's been reporting and had good communication with his probation officer. He currently works like 2 jobs, security at Benton Stadium, and he also does construction work and renovation work. He has 1 child on the way, and he also has a 2-year-old. His child is due in June. So given that, and these are not, the new charges alleged are not serious violent charges. I don't believe he's charged with having a gun. So I'm asking to revoke the 30 days he's been in.
Okay. Mr. Williams received from Judge Reeder way back in 2019 a first offender sentence. The armed robbery was reduced to robbery, and he received 10 years to serve 5 years, balance probated. So we're dealing with a first offender. Are you requesting that he remain as a first offender and not lose that status?
Yes, Your Honor. The other case, he hasn't pled to the other case. So who knows, the other case might get dropped, and it's a co-defendant case too. So she might be claiming everything in the car as hers. So until that shakes out, I don't be asking for him to continue as a first offender.
Okay. Ms. Jackson, good morning.
Good morning, Your Honor.
Long time no see.
It's been a while.
Yeah. Can you share with me any criminal history information you have on Mr. Williams, which is position 5 on our revocation calendar?
Could I have just a moment, please, Your Honor?
Sure. Let me turn to Ms. Simpson. What do your records show how Mr. Williams has done on probation? The sentencing, the final disposition from Judge Reeder included language that Mr. Williams was supposed to be on intensive supervision for his first 2 years. But I see that he got paroled, so I don't know if that intensive was while he was paroled or on probation, but I'm curious what his track record is like with DCS.
According to based off the notes from his supervision officer, he's not having a problem.
So this arrest was it?
Yes.
Okay. All right. Ms. Dilligard, what's the state's recommendation?
State's recommendation is to revoke 180 days. He was in the car with cocaine and marijuana and alleged to have been distributing that with the amounts. Also, he wasn't charged with a firearm, but there was a firearm in the car after reading the facts of the case. It was in a glove compartment, so I don't know the circumstances of that, but he was in a vehicle where there was a firearm. So the state recommendation is to revoke 180 days.
Okay. Got it.
I'm ready when you are, Your Honor.
I am ready. Lay it on me.
All right, there are 4 cycles. The last arrest was March the 13th, 2024 in Fulton County for theft by receiving stolen property and possession of cocaine with the intent to distribute, and possession of marijuana with the intent to distribute, and possession of controlled substance with the intent to distribute, and possession and use of drug-related objects. There was no disposition listed in the GCIC for that arrest, and there were no convictions listed.
Okay.
Nothing.
Thank you. Mr. Williams, how long did you serve before you were paroled?
Yeah, I believe 3 years and 10 months.
Okay, a little less than 4 years?
Right about 4 years.
Okay, all right. You have any questions about anything we discussed?
Not at the moment.
Not at the moment. Okay. And when you get out, you're going to be at Guinness Road? Is that the right address? Where do you think you'll be staying?
That would be like, I'll be at Guinness Road, yes, sir. 3616?
Yeah.
Yes, sir.
What's there?
My mom's house,
Okay. And who stays there with your mom?
my husband.
Okay. And you? Okay. All right. Well, Mr. Williams, you're going to need to work through these new charges in front of Judge Mao. I think you got a court date coming up, or at least your lawyer does. It may be one of these where it's a lawyers only situation. When you get out, you're going to need to plug back in with probation. How did you stay in touch with your probation officer?
I call him.
Okay. Will it likely be the same probation officer? Okay. All right. So when you get out, you'll need to do that. I'm going to revoke 100 days of your probation for this arrest, and then reinstate the balance. You need to keep in mind, as a first offender, you are in a perilous position if you're going to get arrested for something. You can have your first offender status revoked, and that would mean that you could be resentenced. And while robbery was a lot less serious than armed robbery, it's still a 1 to 20. And you can't be given more total time than what you've already served plus whatever you'd get. But a judge could, and it will come back to me what to do with your robbery case, could revoke impose more prison time. You've already pled to that case, so it's not like you get another trial in that case. I'm confident Judge Reeder talked to you about that back when she gave you first offender. That said, that was the first time you got in trouble, was that case. And then you've stayed out of harm's way until whatever happened in March. And maybe you were riding in the wrong car, like Ms. Rios said, and your lawyer in front of Judge Mao will encourage the prosecutor to look at it that way. But you need to know the importance of laying low. Easy for me to say, but important for you to do. Do you have any questions about anything?
Yeah, you say you can revoke 100 days?
That's what I said, correct. All right? But I'm not revoking your first offender status. If we are together again because you've been arrested for something, your first offender status will be in peril. Okay? Ms. Rios, anything else on behalf of Mr. Williams?
No, Your Honor, thank you.
Ms. Dilligard?
Nothing further, guys.
All right, thank you. Was it Ms. Rios? Who wanted to have Ms. Ross? Oh, it was Ms. Rios. Okay. I appreciate her spunk. All right, when she comes back out, we'll figure out what we're doing with Mr. Alexander, and then we can turn to Mr. Daniels. I think that's all we have left for this morning. Hey, Ms. Rios. How are you?
Me?
Yes, you're the only Ms. Rios.
I'm good.
All right. Mr. Alexander,
Yes.
tell me what you'd like to do. I'll engage with him regardless, but
Well, he wants to come out because he was yelling, so we could bring him out just to explain. Well, I already told him we're gonna reset and see. It was Mr. Alexander.
all right, give us 1 second on him.
He wants to reset to try to go into the program.
Okay. And you're his advocate, so can I tell Ms. Ross we'll meet with him?
Yes.
Okay, so you are basically requesting the same, which is more time to see if there can be a program.
He really did want to talk to you about what happened with the last program.
Okay, I'm sure he does. Are you going to be requiring the state to prove up the November shoplifting? Because I'd love to avoid, it sounds like the two sides are going to remain far apart. And so one, you can have time so Ms. Ross can search for a different program for him. But do we set this down for an evidentiary hearing, at the end of which, if I find that the state proved by a preponderance that there was another shoplifting, then you're going to pitch the program? Or how do you want to do this?
He said, like, we're stipulating to the fact that he was arrested.
Mhm.
And so we can just reset for that. And
Okay.
And then.
So it's basically we'll call it a sentencing hearing is what we'll have. How much time do you and Ms. Ross want?
Let's do 3 weeks.
Okay. All right. Let's bring Mr. Alexander out, please.
Is this one? Yeah, exactly. We're dismissed. I haven't looked at it. 1, 2, 3, 4, 5, 6. This is his son. Oh, yeah. Is it in?
Hey, Mr. Alexander.
How you doing, McBurney?
I'm all right. Haven't seen you in a little bit. What's new with you?
Man, I have a lot to talk to you about. I'm serious. Like, I'm trying to be prepared to talk to you about this case. And the last time I seen you, you know, you had revocated me for like 7 months straight. I thought it was a 2-for-1 thing, but I believe I've been revocated for some false accusations, and I want to get that out the way.
Okay.
And that's the reason why I have a mother come up here so she can back me up on some of the facts I need to tell you.
Okay. Well, let me tell you what we're doing today.
Yes, sir.
And then we will be meeting again soon and we
Yes,
can
sir.
talk about it more.
Yes, sir.
Today, we were figuring out which way forward for you. And it sounds like you and Ms. Rios are both interested in identifying a different program for you to
Yes, sir.
try.
Yes, sir.
Ms. Rios has a colleague named Ms. Ross. It's a little
Yes, sir.
confusing, Rios and Ross, but they're two different people. Ms. Ross is going to come meet with you
Okay.
to learn a little bit more about your background,
Okay.
so that as she looks for a program, she finds one that's the right fit.
I got something to say. What I was thinking, so, years ago, I was in that drug court.
Yeah,
Just like, and I believe you was my drug court judge.
I was. That's how we got to know each other.
All right. Back then, this was like probably 10, 15 years ago.
Maybe not
Back
that
then-
long ago, but yep.
Yeah, it was kind of long ago.
Okay.
But back then, I wasn't ready for drug court back then. But now, at the age I am right now, I feel like I'm ready.
And what age are you now?
50.
50?
Yeah,
Did you just turn 50
last year.
last year?
Yeah.
All right, congratulations, half a century.
This year. Yeah. But I believe I'm ready for that now if I can get back in that drug court. I mean, that's still another option that I can take.
Okay,
But
so that's the kind of thing you'll want to talk to Ms. Ross about. She is particularly focused on outside programs, but
Okay,
that doesn't
so-
mean, I want to be clear, that doesn't mean that's the only option. She also can reach out to the intake team at drug court, and they will let her know what they think about you going back into drug court. So she'll do the full spectrum. And then she'll meet with Ms. Rios and the three of you can talk about what looks
What
like
option?
a
Okay.
possible fit.
that's cool.
We're not doing that today because Ms. Ross needs a chance to meet with you and then to look at all the resources she's aware of.
Yes.
When we get back together, I will hear from Ms. Ross or probably Ms. Rios and you.
Yes, sir.
I'll also hear from the prosecutor.
Yeah.
The state may have a different perspective
Mhm.
about whether a program makes sense for you or not.
I understand.
And we probably won't be talking about, you said something at the outset about, hey, some of these things in the past are false accusations and this and that. I don't know. I'm here and you're here
Yes.
because of you getting arrested in November of last year for a different shoplifting. It's a newer one. That's the basis for the revocation.
Mhm.
And so we won't need to
Even though that charge has been dropped, I still got to move forward with that?
Well, that may be something that Ms. Rios wants to share with me if it has in fact been dropped.
Yes.
But that'll all be part of the conversation. So I'll hear from the state about those charges and your background. I'll hear from Ms. Rios about opportunities for you in the future.
Yeah.
And then I'll decide what I'm going to do. Okay?
Yes, sir.
But before you go, Ms. Dilligard, was there something I noticed you stood up.
Taking a look at policies, Judge, it looks like he had another new arrest from February 27th of this year. And that case, that's not the one that was included on this revocation. He has a new case. That was dismissed at prison, but that's because an officer didn't show up.
Okay, so there are two, was that also a shoplifting arrest? Hold on.
Yeah.
Was that also a shoplifting arrest?
No, it's a possession of methamphetamine.
Okay, and that one was dismissed, officer no-show. But the November of last year is a shoplifting, not dismissed. Okay, is it just a PI case floating around right now?
It's a non-complex.
November.
Oh, it's been indicted.
It's indicted.
Okay, got it. Okay. I think I understand all these things. Ms. Rios, it's part of your work with Mr. Alexander, should think about whether he wants to resolve the non-complex case when we're doing our revocation.
Okay.
Just so he doesn't have to make multiple stops. But if that's a hotly contested case, then he and his lawyer in non-complex can hotly contest it in front of Judge Mao or Judge Brooks.
Yes, sir.
Okay, but I'm happy to package it all into one so he's got greater certainty of what's next. All right? Mr. Alexander, any other questions?
Yes, I'm not familiar about the arrest about last year, November, a shoplifting felony.
So let me familiarize you with it. What's the case number, Ms. Dilligard?
24 SD 006463.
Here you are. So you have Ms. de Villiers as your lawyer, and the indictment, you've got your arraignment in 2 weeks on that case. So it's pretty new. The indictment is new.
2 weeks, this year?
Yeah. On
Shoplifting?
April 15th, and let me just tell you what the charges are. So the allegation is that on November 21st of last year, you took ribs, steaks, and other meat items of a value in excess of $500 from Walmart.
That's been dismissed.
Well, it was dismissed. It was, but it's been indicted. It was dismissed because the officer didn't show up. You're exactly right. It was dismissed because the officer didn't show up, but the state can still indict it. It wasn't dismissed because there was no evidence. It was dismissed because there was no officer. Two different things.
Can I ask you this question?
Yeah.
Is that a felony or misdemeanor?
Over $500 is a felony.
Okay, that, like, I proved to the court that that Walmart, they charged me 4 times the amount than the original price. That was supposed to be dismissed. It was actually a misdemeanor, but they forced it to a felony.
So
I got indicted.
So Judge Brooks dismissed this because Officer Barnett did not show up, not because of felony or misdemeanor. I'll tell you this, the state can charge it as a felony if in the end, the evidence is that, I'll make it up, it was $12 of steaks and ribs, then maybe it's a misdemeanor. The issue you might have is that this is shoplifting number, I don't know that I have
I
enough
understand that part.
fingers, and that might make it a felony anyway.
They made all right, you know, I have to handle that with them because they did a crime themselves.
Okay.
Because they lied on their part, which was not true.
Okay.
But I'll handle that on the.
Yep, you'll handle it there. I'm letting Ms. Rios know that there is that case that may make sense to wrap all into
right,
one.
I got you now.
Okay.
Got you.
All right. It's good seeing you. We'll see you soon.
Okay.
Talk to you soon.
All right.
Yeah.
All right. So I think all that's left for this morning is Mr. Daniels's bond modification. And I think he's also on for plea and arraignment, and not just bond modification, so we can officially get the case moving. But let me find that. Yep, that's right. So Mr. Daniels, why don't you and Mr. Monsiagli come on up to the podium? And Ms. Dilligard, you are welcome to stay. Otherwise, I think we're back on at 1:30?
Yes, Judge.
Okay, for final plea, emphasis on the word plea. Yeah. And you may want to break bread with Mr. Dandridge.
I'm about to go back.
Okay, all right. And chat with Deputy Gordon.
Yes.
Okay. And maybe bring one of these new torpedo bats that everyone's using. All right, Mr. Daniels, let me get your case up on my screen here. Let's see.
Yeah, okay, thank you.
So I'm just getting your bond order up as well. Okay. Let's get on the record. This is 25 SC 000890, State versus Craig Daniels. Mr. Daniels is here in court with his lawyer, Mr. Monsiagli. Administrative point, Mr. Monsiagli, the system keeps showing Scott Smith as the lawyer. And maybe at one point he had done an entry. You're listed if you drill down a little bit deeper, but when we print our calendars and everything, it keeps showing Scott Smith. So
should I do another entry?
I think we're going to do two things. I'm going to have you do another entry. I'm assuming you're also waiving arraignment.
Yes.
And so we've got a waiver form. So if you would do the waiver form, I think that constitutes your entry also, but just fill that all the way out and we'll see if that tweaks it. Worst case scenario, I may need to do an order removing Scott Smith, just so that notices aren't going to the wrong places.
Right.
So we'll do that. Mr. Daniels, you're here for your arraignment. Mr. Monsiagli has told me that he's waiving that on your behalf, so he's entering a plea of not guilty on your behalf. I'll enter a scheduling order today or tomorrow that will set some deadlines for the production of discovery to your lawyer and for Mr. Monsiagli to file any motions, if he has motions to suppress or whatever he might see after he's read the discovery in the case. That's the easy part of today, unless there's anything you want to add about waiving arraignment.
No.
Okay. The more complicated part is this motion for bond modification. When I think I got a notice recently is how it came to my attention that maybe the battery had died on your monitor. And when I get these kind of notices, I jump into action like, uh-oh, what's someone doing? What's going on here? And then I saw how long you've been wearing an ankle monitor. And We, the county, the court really, are looking to minimize the number of instances where someone has an ankle monitor on for years and years. The point of the ankle monitor generally is to ensure for the first number of months, and that's not a fixed number, but some number of months that someone's not disappearing, that would be you. And it's often also an important safety buffer for the alleged victim in a case, because usually ankle monitors involve a curfew and a stay away. Don't go near this location, don't go near this person. An ankle monitor helps ensure that you're doing what you've committed to do in your bond. There reaches a point where if for a certain number of months someone has stayed away, then we need to revisit the necessity for the ankle monitor. And Mr. Monsiagli has filed a motion saying it's time we talk about that, because it hasn't been months now, it's been years. There may be a perfectly good reason to keep the ankle monitor on you. There also may be a compelling reason to take it off or modify that process in some way. So I think that's what we're talking about today. And I'm going to open it up to your lawyer, and he'll share with me what he wants to. Ms. Nix is the prosecutor on your case. She may have some things to say, and I don't know, let me find the indictment here. She either may have input from Ms. Short, or Ms. Short may want to be heard, and I'll certainly hear from her. She has a right to be heard in this process as well. Mr. Monsiagli, I'll start with you.
Your Honor, first of all, I've got a frog in my throat, so at the beginning, intensive PTO Linton regarded was his probation officer pre-trial, and we texted back and forth, and there's one here.
We meaning the pretrial services officer and you?
Yes.
Okay.
And it appears that he was talking to somebody else. I mean, but it says here, I'm reaching out to you as it appears that Mr. Daniels' current GPS provider, Teletrix, doesn't have the support or capacity to service him in Chicago, as his GPS device hasn't been active since 5/24/23. So
have you been paying for it? First of all, is this one you pay for, or is it one the county pays for?
Yeah, so it's one we pay for. But,
okay.
Any incident where the device, I know they came out to Chicago to change it out, but any incident where the device, so it doesn't die, what happens is it won't charge and then it'll die. But then we always in communication with each other. Like
you have the wrist device?
Yeah, the wrist device.
Okay, so you've got the wrist.
Yeah, so I always let them know whether it died or it's not charging. But anytime anything happens, which it's been plenty of times, things that happen over the years, I've always been in communication with them. They've been in communication with me as well.
Okay, and this is Teletrix we're talking about.
Yeah, Teletrix.
Okay, but the wrist monitor that you're wearing is something that you're paying for, not the county.
I want to say like the first year and a half, but then after that, the invoices stopped coming.
Okay, so no one's paying for it?
Yeah, at the moment, I think the county is paying for it, because that's what Officer Layton was saying, that they would pick up, or he put in, he sent something in where I guess they would pay for it after a while. But I'm not entirely sure, but I do know the invoices did stop coming like a year ago.
Okay, more importantly, you're not paying for it right now?
Yeah, I'm not at the moment, no.
Okay. All right, keep going, Mr. Monsiagli.
yes, Your Honor. I spoke to Officer Linton recently, and he told me that during the time he was being supervised several states away, he hasn't had any new charges that he's aware of. In regard to the victim, it's my understanding that she lives here in the Atlanta area. Mr. Daniels lives in Chicago, and I don't think he's come back until today or yesterday.
Yeah, court.
So there's not really an issue of having anything to do with the victim. In the most recent motion to modify condition of bond, in the initial one, or it may have been a second one, the court allowed Mr. Daniels, who is a landscape architect, to work in Illinois and the surrounding states. But most of his work prior to his arrest was in California, and he did very little in those adjacent states. He had lucrative jobs before the arrest, and with the conditions of his current bond, his income has plummeted. So we're asking that he be allowed to work anywhere in the United States, including California.
And tell me again, what was the prohibition on California? Or it wasn't one of the adjacent states? I see Judge Williams, who had this case for many months because it was unindicted and she was responsible for all issues of bond. She entered a bond order that said that Mr. Daniels could go to Wisconsin, Iowa, Indiana, Kentucky, and Missouri. So, like you said, sort of surrounding Illinois.
Right.
Was there a discussion about California, or that was just Judge Williams's good faith effort at saying, I'm going to give you a certain radius, keeps you out of Georgia, but doesn't limit you to Illinois?
Well, that's what it ended up being. We had asked for a nationwide, but she decided just to do those particular states.
Okay. All right. So your request is to remove the geographical restriction and the risk monitor, or just the geographical restriction?
Well, the risk monitor will not work. If he's going to be monitored, it should be the old school one. I don't think, as long as he can move out of the state wherever he's going, I don't think he would object to that. I don't think that it's necessary, but if the court does, it couldn't be what he's got now.
Okay. All right. Mr. Daniels, are you still a landscape architect?
Yeah, so I own a company called Prolific Design and Manage. And what we do is we design backyards throughout the U.S. So I have an office in Chicago, Illinois, and I have an office in Palo Alto, Illinois. But since I haven't
Palo Alto, California?
Yeah, I'm sorry, Palo Alto, California. But since I haven't been able to travel, I had to super minimize, and that was my most lucrative location. But also, because we're popular on social media, so people find us all over the United States. So I travel to different projects. So it's been very limiting. Like, even if I can't come to Georgia, that's fine. But it has taken a toll on everything, where we had to lay off employees, and just even myself, having to pay the lawyer and the rent and things like that. Being limited does take a toll.
Okay. And is this a business you own by yourself? Do you have partners?
Yeah, by myself.
Okay. So you've been able to maintain the business, but not nearly as well. It's not your fault, but as well because of these limitations on your ability to travel.
Yeah, and the only reason why I haven't been able to, because we downsized so much.
Okay. All right. Ms. Nix, good morning. I think it could be afternoon now. What are your thoughts about modifying bond for Mr. Daniels?
Yes, sir. The state does object to modifying the bond insofar as taking the ankle monitor off or the wrist monitor. The defendant has a criminal history in Illinois, including 2 felonies as well as several arrests that did not result in convictions. I do see a violation of extradition in Illinois from 2022, which shows a potential for failing to appear for court. There was also an altercation with the victim's mother in 2023, which is a concern of the state's. The defendant is the victim's cousin. There is a lot of enmeshment with their families, and so the state has a big concern about contact. And I believe that the fact that the defendant has had to have an ankle monitor is what has prevented him from having further contact and engaging in further altercations. The fact that the defendant has hit most of his work in California, it seems to me as though the court could keep the ankle monitor on and allow him to live and work in California instead of the Illinois and surrounding states provision that we have now. So we would ask that the provision of the ankle monitor and or wrist monitor remain in place. I do believe that the victim is on and would like to make a statement, Your Honor.
All right, I will certainly hear from her. Before that happens, can you help me a little bit with the timeline? The allegation here is that something happened in August of 2021. Mr. Daniels wasn't arrested until January of 23, and then the case wasn't indicted until 25.
That's correct.
And I'm not faulting anyone for any of that. I just want to understand it a bit because that means there were a bunch of years where Mr. Daniels is not in trouble. He's not arrested. There's apparently an altercation with Ms. Short's mother that you alluded to that I want you to talk a little bit more about. But otherwise, there aren't things that I see that suggest he should be wearing an ankle monitor. And he had one for a bunch of years and nothing happened with the case, meaning the state didn't do anything with the case. So I'm just trying to work through the necessity for continued monitoring. So talk to me about the timeline.
Judge, I can't give you an answer as to why this case wasn't indicted in 2023, other than we were still working through our COVID and Paul Howard backlog.
Mm-hmm.
So I don't have any better answer than that. The altercation with the victim's mother, I believe the defendant was still in Georgia at that time. The altercation occurred at a gardening nursery where they saw each other. It was a verbal altercation where the defendant made some threats towards the victim's mother, which included, I'm not going to play with you. Do y'all think this is a game? Follow me and get these problems. This was broken up by victim's younger brother, and the parties separated.
Okay. That's a reason why Mr. Daniels shouldn't be in Georgia.
Yes.
Okay. Ms. Short still in Georgia?
Yes.
Okay. Any sense of the 2-year-ish, year-and-a-half delay in Mr. Daniels going into custody for this? I'm looking at the arrest warrant was sworn out in, it looks like July of 22, and then Mr. Daniels isn't arrested till January of 23. But of course, July of 22 is almost a year after the alleged incident.
I'm not sure about that delay, Judge. The victim did report it within a day of the incident occurring.
Okay. All right. And I want to be clear, that's not my focus as to when anything was reported. Things are reported when they are. I'm just trying to put together the timeline. All right, Ms. Short, are you on our Zoom call? Oh, I think you're on mute. There you
Hello,
go.
can you hear me?
Hey, yeah, can you hear me?
Yes, I can hear you, Judge.
Okay, Ms. Short, thank you for joining us. Please share with me your thoughts about what we ought to do at this juncture.
Okay, so to my understanding, I was supposed to write a statement. So I wrote it, but would you rather for me to just speak to you as we go?
So I'd like you to be as comfortable as you can at this moment. And so if you'd prefer to read what you wrote, you can do that. I may have some questions afterwards if it doesn't get into the areas I'm curious about, but I'm also happy for you to go off script and tell me what's on your mind, having heard what Mr. Daniels' lawyer just said and what the prosecutor said. I want to try to strike the right balance between you feeling safe as we go forward with this criminal prosecution and the fact that Mr. Daniels has the presumption of innocence. And it sounds like he is trying to operate his business. I am fine saying you don't get anywhere near the state of Georgia. But if he needs to go to California for his work, I'd need to understand why that's something that bothers either Ms. Nix, the prosecutor, or you as the named victim in this case. And you may not care if he goes to California, but those are the kinds of things I'd like to hear about from you. Plus anything you want to add, this is your moment to engage.
Okay, I would like to say first and foremost, I don't believe he should be free. Secondly, I have, and please excuse me if I seem jittery, because that is the outcome of what he did to me. I am very anxious. I have very bad anxiety, PTSD, and depression, and I'm still living with it today, 4 years later. I've been calling Detective Taylor in the beginning of the case. I've been trying to reach out to the DA, which was at the time, what was her name? It's
Ms.
not
McCauley?
No, it was another woman. I've been reaching out and haven't been getting return calls. I've been reporting everything that's been going on. As far as like what's going on with the case, it's been 5 months, it's been 8 months, it's been a year, it's been 2 years. And everybody would give me the same answer. I know, Ms. Short, things like this, it is a process. I'm so sorry, I understand. And now we are in the 4th year and nobody has answers to you, who sounds like you just picked up this case. And it seems as though I haven't been doing anything. And that is very upsetting. So I wanted to say that, and I will read my statement and we can go from there.
Okay, before you read your statement, let me make one thing clear. When I was try to make something clear. When I was asking Ms. Nix about this timeline, I wasn't in any way meaning to suggest or imply that things had moved slowly because either it wasn't important or you weren't serious about this or you had not gone through something traumatic. I have handled many, many cases in this job, and they very rarely move slowly because the outcry witness is wanting it to move slowly. And so your frustration is sadly all too common. where you are the one in the end having to say, hey, what can we do about this? And the police are distracted by other things and the DA's office is overwhelmed by other things. So I don't take any of these dates that we're dealing with as evidence that this was not a big deal for you. So I appreciate you flagging that, and you should know I hear you very clearly. Now, why don't you share with me what's in your statement?
Thank you, sir. So I've waited for this day to finally be heard. And now that it's here, I feel as though I don't have enough time or paper to explain the horrendous impact this crime Craig Daniels have committed against me has caused in the past 3 years, 7 months, and 9 days ago. So many questions left unanswered, so many tears, so many night terrors, 2 suicide attempts, 2 years of psychotherapy, multiple diagnoses, including PTSD, depression, anxiety, ADD, and ADHD. Multiple medications prescribed, including Wellbutrin, Zoloft, Adderall, and Xanax. Countless days of sleepless nights, seeing shadows, hearing noises, and irrationalizing. Craig is having someone trying to kill my daughter and myself. My life has completely broken into shambles after Craig Daniels sexually assaulted me. I was unconscious in my bedroom where I belong on August 22nd, 2021, which is also my 28th birthday. This year, I will be turning 32, and I still cannot celebrate my birthday because of the tragedy. The tragedy and the constant reminder of what this disgusting man, who is my cousin, did to me. Every year, I cannot smile. Every year, I cry. Every year, I'm angry. Every year, I'm just shunned into a dark place. Just the thought of knowing he's out doing whatever, because I deleted all contact with him. I don't see pictures. This is the first time I said his name as many times as I did. That's how bad this has affected me. The damage that's been done run deeper than a dumb moon. You completely ruined my life, Craig. I became mentally ill, and now I have to take medication to manage my symptoms for the rest of my life. Almost 4 years later, exactly the same emotions I felt. Okay, I'm sorry.
Take your time. Take your time.
It's long statements. I'm trying to make it fast because I know I feel the exact same emotions I felt realizing I was raped by my own cousin, who I welcomed into my home with open arms. I am angry. I am furious. I am disgusted. I am hurt. I am sad. I am confused. I am weary. The only emotion you will not get from me today is fearful. Today, I conquered that. 4 years, I could not look at a picture or hear Craig's name, but today I stand firmly looking him right in his face. What you did to me not only impacted my life tremendously, but my daughter's as well. Guess what? I was pregnant. I was pregnant when you raped me. I found out I was 3 weeks pregnant during the rape kit, August 22nd. I could not even enjoy the news. I was just expecting again after suffering the previous miscarriage I had in April of 2021, which you knew about, which I told you on the boat at my mama's party. I had a miscarriage and I was suicidal. My fucking cousin. Because all I can think is what happened? Why would he do this? Why would he do this to me? Why did you send the girl that you had that night? You sent her home. Why the fuck did you send her home and go in my room and rape me? Why? Mentally, I could not process the news of my baby growing inside of me for 7 months. 7 months, I did not care. 7 months, I laid in the same spot. No outside contact. I couldn't work. I lost income. I lost my clientele. I lost everything. I lost my friends. I couldn't talk to my family. I trusted no one. I had no baby shower. I had no gender reveal. The love of my life that I had the baby with was so disgusted from what you did that he left me. He couldn't handle it. He couldn't handle it. And I was left in alone with the world on my shoulders dealing with so much trauma. Yes, I tried to kill myself. Till today, I'm not right. And it truly brings a deep pain and tears to my eyes knowing that my daughter knows this anxious, depressed, closed in, quiet, anti-social mom when I had such a beautiful soul and would have been such an amazing and outstanding mom, but I just can't. I just can't. I can't because I'm forever changed. I can't. And I wish I could. I swear to God, I tried to forgive you so many times. I went to the church. I went to the altar. I fasted. I prayed. I prayed so much, and I still fucking hate you. I fucking hate you, bro. You know I treated you with nothing but respect. I never showed any fucking signs that I liked you. I wanted you anything.
Miss Short, I need you to be talk. It's okay. I need you to talk to me and not to Mr. Daniels, okay?
Yes, sir. I'm sorry. I'm sorry. My social life does not exist because I don't trust people. And I have constant intrusive thoughts of someone taking advantage of me and hurting my daughter. I'm a prisoner of my own mental state for the crime that I had no involvement with. And it's 4 years later, and this man is still walking. He's still able to work. He's still able to hang out with friends. He's still able to have relationships. And it makes me so angry and frustrated because in almost 4 years, no consequences have been given at all. With the evidence and the witness statements against this man for the heinous crime he committed, I feel as though he keeps getting slapped on the wrist, and I am weary of it. My biggest mistake was not appearing to the first hearing 2 years ago because I was a broken girl, still in shock. And I ain't gonna process all of the trauma happening back to back. Today, I am a survivor, a mother, and a voice for all the women that are still suffering in silence. Craig Daniels have proven to be untrustworthy and undeserving of any options of comfort. As we await trial, he has lied to me. He has lied to detectives. He has lied to law officials. He has tampered with DNA samples. He has mocked this case completely, acting as though he is superior. I am here to oppose his request because he has threatened me from fake numbers and also violated his bond he agreed to and got into a verbal altercation with my mother, who is 55 years old with heart problems, verbally threatening her. He has texted my brothers and verbally threatened them. He is a menace to society and a threat to me and my daughter, and I feel for my safety and myself, given that I am a known hairstylist here in Atlanta and my location is easy to find. All you have to do is Google it. I just don't feel comfortable with him getting any more slaps on the wrist. I'm ready for this trial to come and end and get justice. That's how I feel, Judge. I've waited 4 years Even last year I said, I cannot let this man ruin another year of my life. I've been stagnant for 3 years, not working, no social interaction with anybody, which was unfair to my daughter. No relationship, no romance. I don't even talk to my family. I don't trust anybody. I'm taking medication every single day. I was not this girl. Even today, right now, I'm angry and I'm loud and I'm erupt. Like, I'm not this person, but this is who I became. It's who I became. And I don't want to be her no more. But I can't change it. And I tried and I tried and I tried, and it just not working. And for just to hear to say, oh, he wants to work in California. I don't see what the problem is. The problem is he sexually assaulted me. He took something valuable from my life that I'll never get back. And he can just get to live his life. I don't know what else to say to that. Because my life ended. It ended. It ended. And I'm still trying to start it over. And that's all I have to say.
Well, Ms. Short, I appreciate you having prepared those remarks and sharing with me the depth of your feelings on this. You have been heard, no question about that. You will be notified. Somehow you need to be here today. Did someone from the DA's office tell you there was court today?
Yes.
Good. That will continue to happen for every subsequent court date Mr. Daniels has. You will be notified. You have a right to be present. It won't necessarily be an opportunity to be heard at each of those. Just as an example, if there was a motion to suppress, and I'm making this up, if Mr. Daniels gave a statement to the police and his lawyer's trying to suppress that, we'd have a hearing on that motion, and you would be entitled to be in court or plug in this way like you just did. At those court appearances, I will not be turning to Ms. Nix to see if you've got any input on it. But certainly, if this case resolves in a plea, you'd be heard during that plea hearing. And then if there's a trial and Mr. Daniels is convicted, you'd have an opportunity to once again share your victim impact statement with me as I figure out what to do with sentencing in the case. But that's where we are. What I can tell you is things will now move more quickly. After today's arraignment, I'll enter a scheduling order that will set a deadline for the prosecutor to get discovery to Mr. Monsiagli, the defense attorney. He'll have a deadline to file any motions, if he has any motions in connection with this case. And if there are any, we'll work through those promptly. If there aren't any, then this case comes in for what we call a final plea. And if that doesn't resolve the case, then it will hit a trial calendar. It will be on a trial calendar this year. So the case will continue to move along. It's already taken too long. There's no question about that. And you've helped me feel that very viscerally from what you shared. So I encourage you to stay plugged in with the victim witness advocate. And I am confident that I will see you again in connection with these proceedings, and then we'll at some point reach a juncture where I get to hear from you again as well. All right?
Yes, sir.
All right. I appreciate you dialing in. You're welcome to stay on. I'm just going to mute you now, okay?
Okay, yes, sir.
Thank you, ma'am. All right. Mr. Monsiagli, as the movant, do you have anything you want to say in closing in connection with the motion?
Can I speak to him just quickly?
You sure can.
Move down.
You may want to step away from the microphone. Ms. Rios, we're not on the record right now. They can keep talking. I don't know if you knew position 10 on the calendar for this afternoon, Mr. Alexander. I think we're going to be able to get him. Oh, you know, this is the case that's being. Yeah, and we're supposing to be able to patch him in via Zoom.
Yes.
Okay, got it. Nice work. But that doesn't resolve the case.
Wait, what?
No, his it does, but not the whole case. There's a co-defendant, so
Okay.
I can't close out the case.
Okay.
You know, no pros means no pros. New rules.
Okay. Okay, 18, 18. I already had that. Yeah. A lot of people, yeah, well, that was the last thing I saw last week. They were sending the record for the brain.
That's all you're going to say.
All right, Mr. Monsiagli, anything you or Mr. Daniels wants to add?
No, Your Honor, I mean, we're just asking for the nationwide except Georgia. And then I'll leave it up to you in regard to a monitor.
Okay. Mr. Daniels, tell me why you think you would have any business in any of the states that surround Georgia? Alabama, Tennessee, South Carolina, I mean, you know, the states that are contiguous. Why do you think that you'd have business in any of those?
Because I could even show the court, you know, invoices and paperwork and contracts, or even projects in Tennessee that we took on, like even this month. But I won't have any business in Georgia at all.
Trust me, you will have no business in Georgia. So you actually have, your company has active contracts in Tennessee, just as an example.
Yes, correct.
Okay, and how does that work? You have people from Illinois who fly down and do it, or what's the process?
So let's say you're a client in Tennessee.
I live in Knoxville. I see your thing online. Man, come do my backyard.
No, the client is actually in Knoxville. But so the client will call our office. My admin will schedule a consultation with me. We'll have a phone conversation. We'll see if they qualified to work with us. And
what does it take to qualify to work with you?
So depending on the budget, the backyard, because these type of spaces, so our average project size is around 150K and up. So if you want to, so let's say a lot of people see our work and they just want some plants done in the front. We wouldn't fly out for that.
Got it. Say we don't do that, but if you can do the whole package and it's 200 grand and they can afford it, then you may have a contract.
Yeah, and then we'll fly out, talk to the client, get the project going. But I have to meet them in person. And since it's my company, you know, I can't really find somebody who has the passion for it and speaks to the clients like me. So it's usually me flying out to.
All right, but you or people on your team are actually dispatched to these locations where there are projects.
Yeah, and we design it, and then we hire companies, and that we have companies throughout the U.S. who build these projects, and they build them. But we show up to design it.
Okay. All right. I understand that. So, Mr. Daniels, here's what I'm going to do. We have not worked together yet. This is your first appearance here. I am going to allow for you, for professional reasons only, to travel to states other than Georgia. You're going to need to figure out how that works because you cannot fly through Hartsfield. That's being in Georgia. So if you are going from Illinois to Knoxville and the normal flight would be Chicago to Atlanta to Knoxville, you can't do that because that's coming to Georgia. That may not be convenient, but such is life. So if you are found to be within the confines of the state of Georgia, even if it's just the plane touched down, I didn't even get off the plane, but it was on the tarmac in Atlanta or at Hartsfield-Jackson, that's in Georgia, and that would be a violation of the conditions of your bond. Secondly, I want to address one of the several things that Ms. Short had to say, which is her perception that you've tried to contact her indirectly, as in through someone else, or anonymously during the time you've been on bond. I'm not getting in the middle of whether that happened or not, but I'm telling you this. If Ms. Short gets evidence to the DA's office that ultimately comes back to you as an effort to contact her, whether it's to say, I'm sorry, or why are you putting these charges on me? Any contact at all. None of it is welcome. None of it is wanted. Any of it will result in the revocation of your bond.
Totally understand.
I trust you do. But just keep in mind, third-party contact that ultimately was engineered by you is contact by you. So you all have shared family members. If an uncle or a cousin is reaching out to Ms. Short saying, hey, why are you doing this to Craig? And it turns out that that person did that at your request. That is, to me, the same as you knocking on Ms. Short's door and showing up saying, why are you putting these charges on me?
Yeah, this would be more so of, as far as family is concerned, a distant cousin, because none of our families are in contact or.
That's better for you, but my point is simply a third person contacting Ms. Short on your behalf is you contacting Ms. Short. So forget about whether it's a cousin, it's a shared friend, it's the Stephanie that I read about in the warrant, someone that you both know serving as your intermediary, to me, will be the same as you knocking on her door. And you can't do that, or calling her, or texting her, or using social media. So if in your mind for the past 4.5 years, you've had no contact with her, keep doing that. But if she brings evidence to the prosecutor, we'd have a hearing and Mr. Manciagli would argue against it. But you should know that if I credit the evidence that you've tried to contact her, then you'll just be in custody till we resolve these charges. I trust you understand the impact that would have. So no Georgia and no contact with Ms. Short in any way, shape, or form. While you are here, you ought to try to connect with Talatrix if that's their wristband and get that taken off. I'm not going to have that as a requirement. I'm not aware of a nationwide monitoring project, and I'm not going to require you to bear the cost of any more monitoring. The state, not Ms. Short, but the state has had literally years to bring these charges. And that ought not to impose that financial burden on you and your family. If this were moving at the pace Ms. Short wanted it to, and we were talking in 2022, that monitor would stay on. But we're in 2025. That is not Ms. Short's fault. It's not your fault. And the way I'm dividing these burdens up is that it's not necessary for you to have a monitor anymore, but you need to, don't just cut that off and throw it away, because someone will come after you saying, it's a $1,000 device or whatever it is. So figure out, ideally while you're here, because I think Talatrix is here and not in Illinois, how to get that removed. I will enter an order saying there is no more monitoring requirement. They'll probably need to see that in order to agree to take it off. But Mr. Manciagli can help you with that. I'll make sure you're clear of what the parameters are. No Georgia and no contact, direct or indirect, with Ms. Short.
All right.
Any questions about that?
No questions.
Okay. If questions come up, don't seek forgiveness. Seek permission. Work through your lawyer saying, hey, it turns out the only way he can get to this project is by flying through Atlanta. But look, he doesn't get off the plane, something like that. I'll review it, but it will be a case-by-case basis. and not, hey, look what we learned. Here's your flight manifest. And you went through Atlanta and didn't get the green light for that.
Gotcha.
Understood?
Yeah.
Ms. Nix, anything you want to add on behalf of the state?
No, sir. Judge, the only thing I would say is that except for trial, or if there is a resolution that involves jail time, I'd ask that we just go ahead and say the defendant should appear on Zoom for any further court hearings.
Should or should not?
Should.
Should, yes. Mr. Daniels, for procedural events, you need not appear in person because that involves you coming to Georgia. If we are having a substantive event, like a motion to suppress or something, you and your lawyer can talk about it. If you're not testifying and are choosing to appear remotely, I'll let that happen. You actually have an absolute right, though, to be here in court if there are witnesses who are testifying about things related to your case. And so you and Mr. Manciagli will navigate that. But otherwise, your lawyer can always reach out saying, is this the kind of thing where Mr. Daniels needs to be here in person, or can he appear virtually? And I think everyone will feel safer and more comfortable if you're appearing virtually. I asked for you to be here today. I appreciate you being here today. It was important to establish the face-to-face understanding of what your bond conditions are going to be between now and the closure of your case. Ms. Nix, any reason why discovery is going to be difficult to get to Mr. Manciagli? It's an older case, and sometimes that means that the district attorney's office has a little trouble dredging up detective reports.
Yes, sir. I've collected most of the discovery. We are still waiting on a GBI report, which I believe should be available in May. So that's the only thing that I believe I'm still waiting on.
A GBI report for what?
Which should be available in May.
Oh, in May. Okay. So they are processing it, and that would be the one thing that you might not be able to present to your discovery deadline is probably going to be before then, but you've put everyone on notice. I can't give you what I don't have. And so that GBI report would be the likely only missing piece.
Yes, but we will, state will comply with continuing discovery.
I know you will. Okay. Mr. Manciagli, any questions? You got 2 forms to fill, at least one, which is the waiver of arraignment. And then I don't think there's a separate entry of appearance. I think that will do it. And like I said, I'll fix the Smith thing if that doesn't do it.
Okay, thank you.
All right. Hold on one second while you're right there. Ms. Short, I noticed that you unmuted. Did you have any questions about anything that I just shared?
Well, no, I didn't unmute. My phone died and I had to hurry up and.
Oh, okay. You reconnected using a different device.
Yes.
All right. All right. Well, as I told you before, you should be getting notice from the district attorney's office for any of the future court dates. And if a couple of months have gone by and you haven't heard anything, you should reach out and say, hey, what's next? The scheduling order that I will issue will have the dates for certain things. A couple of them may end up not happening, like a motions hearing. If the defendant doesn't file any motions, then we don't have a motions hearing. So I don't want you to get frustrated with the DA's office if there's no motions hearing. That just means there weren't any motions to hear. Okay?
Yes, sir.
All right. I appreciate you again sharing what you shared about what you've been going through. And like I said, if there is a plea or there is a trial with a guilty verdict, you will have another opportunity, ideally here in court in person, to share with me the impact that all of this has had on you and those who are close to you. Okay?
I actually do have a question.
What's that question?
Because like I said, I've tried to delete Craig completely out of like my memory and life and sight. So I have no idea where he lived, and I've been trying to serve him for a civil case as well for this rape. And I don't know how to go about that without his
So that's not something I can advise you on, but he has a lawyer here that you might be able to look up through the docket. That wouldn't be his lawyer for civil matters, but you might need to talk with a lawyer about how best to do something like that, or that's something you could explore with the victim advocate who's reached out to you. That person cannot give you legal advice either, but might at least be able to point you in the right direction. Okay?
Actually, I have not been treated fairly because no victim advocate has reached out to me since 2021.
Well, let me ask Ms. Nix, what's a good phone number for Ms. Short to call, or an email address to use to get in touch, either with you or with a victim advocate?
Judge, I've actually been talking to her primarily.
You've been talking with Ms. Short. Okay, Ms. Short, you actually are getting even more direct access. Typically, there's a victim advocate who is sort of a buffer between the victim and the prosecutor because the prosecutor is having to go to court a ton and this and that. So if you've been talking to Ms. Nix, you've got straight to the source. So why don't you and Ms. Nix talk offline about that and see where it goes, okay?
Okay, thank you.
All right, thank you, Mr. Manciagli. Good seeing you again. We'll get that scheduling order out and see what happens from there. Thank you.
Thank you.
All right. So we're gonna take a lunch break. I think we're back on at 1:30. So it's a shorter lunch break than I had forecast. We will do that. So folks who are online can pop back on at 1:30. Ms. Nix, you're gonna have your hands full. With that case, good luck. And did you bring everyone a Mountain Dew or just you a Mountain Dew?
I can go grab some more.
Nah, it's all right. I'll go have a saltine back in chambers. So that was a waiver and scheduling order.
Judge, on this screen, it says, encrypt hard drive, you must reboot your computer one more time. I just wanted to let you know.
Scary, thank you. We will have, during the lunch break, IT come poke around with, maybe we can be the first courtroom to get the new equipment that's down in 1D. That works real well. No lag with playing the videos. All right, I will mute things. All right, we don't have Ms. Rivers, but I think we can take care of, our defendant who is in the Fayette County Jail, who is Mr. Alexander. Can you hear us, Mr. Alexander? Let me add you to the spotlight there.
Yes, sir, I can hear you.
Great, I can hear you as well. Mr. Alexander, you are charged in a case with possession of marijuana with intent to distribute and a couple other things. But I think the state has an announcement as to your part of this case. You've got a co-defendant, but let me hear, Ms. Dilligard, is this your case?
Yes, Judge, the state is going to be null crossing Mr. Alexander's case.
All right, were you able to hear that, Mr. Alexander?
No proceed.
Yeah, which means dismissed. That's lawyer speak for dismiss. So I don't know why they're doing it, but they are. The state is dismissing your Fulton County charges in this particular case, which means you don't need to come back here. I think you're headed to Department of Corrections pretty soon, but we will not be bringing you back here for this, okay?
All right, thank you so much.
Hold on, there are a couple other things we may need to cover. He is scheduled?
Yes.
For when?
It will be 18 because it would also.
Okay. So you apparently have a probation matter with one of my colleagues and you have a hearing on that probation revocation. Is it based on these charges? I don't know what will happen with that. On April 18th, you're not going to be in trouble for missing it if you're with the Department of Corrections, but I didn't want you to think you never ever are coming back to Fulton County. You may have that probation matter, but this set of charges that was assigned to me, the state has dismissed those, okay?
All right, thank you so much.
Don't thank me, thank the prosecutor. Do you have any questions about any of that?
Will I be able to, if I'm in the Department of Corrections, will I be able to go Zoom or be brought back to Fulton County?
Yeah, for that, they'll figure out where you are pretty quickly. And so the lawyer who's helping you in Judge Leffridge's courtroom may try to line up something just like this, but it would be through the Department of Corrections.
Do you have a name for the lawyer that's representing?
Ms. Rios, any sense of who might be representing?
People at Lethbridge, it's, yes, they have a three-person team.
What?
It's either Richard Marks, Mike Sclafani, or Honor Wright. Yes.
Okay, it's one of three. There are three folks who work in there, so unfortunately we can't narrow it down to which of the three. But someone will be reaching out to you either to, well, they may not reach out to you. They may just do a production order and say, bring Mr. Alexander back. It's usually more efficient to get you on Zoom like this, so we don't have to disrupt where you are, and it's just safer doing it that way. But different judge, different lawyer. I just come bearing the good news that this set of charges has been dismissed, okay?
Thank you once again, Judge and Ms. Prosecutor.
All right, Ms. Prosecutor, he said thank you. Thank you, Fayette County, for connecting Mr. Alexander. We are done.
Not a problem. Y'all have a good day.
You too. Bye-bye. I bet they don't approve of how we do business. Liberal Fulton County. All right, Ms. Dilligard, he did thank you, by the way. You were chatting with Ms. Nix, but he said, thank you, Ms. Prosecutor. All right, we have a final plea calendar. Let me find one thing out before we dive into it. I'm just trying to find out the trial dates for the people on the final plea calendar. All right, well, we're going to get started. I don't know the trial dates, but let me see. Is Ms. Cabrera, you are on? Yes, and you want to speak with
Burse.
Burse. Is Burse someone here in court or is Burse online?
I would think Burse should be physically either in the courtroom or in custody.
Oh, this is the co-defendant. This is position 9. Not in custody. Central Burse. All right, not in court yet, but I'll call the name again. We just got started. And so if, is that a Mr.?
Yes.
Okay, if Mr. Burse shows up, we will do that. If Mr. Burse doesn't show up, we've got a very different thing to work through.
I know.
Right.
And then my other person, when we get to him, he should be physically in the courtroom.
Okay. All right, great. So ladies and gentlemen, if you are here for the final plea calendar, this is your last day to resolve your case with a plea and be able to withdraw your plea if you don't like the sentence that you get. You can always enter a plea tomorrow or in the middle of your trial. But after today, if you enter a plea, I may accept it, and then you are stuck with whatever sentence you get. But today, you can test out the sentencing waters and see what happens. Position 1 is Joseph Daniels. All right. Ms. Nelson, do we know anything about Attorney Lim's whereabouts? We'll find out. Ms. Dilligard, yes?
No, Judge, I'll find out. I'll reach out to her.
Thank you. Had you had any contact with Attorney Lim?
Yes, Judge, I had a brief email exchange with her.
It's a he.
Or he, sorry,
Yeah.
my apologies.
It's all right. Former judge.
When was that? On Monday.
Okay. All right. Well, we'll see. Hopefully Attorney Lim joins us, and hopefully Joseph Daniels joins us. All right. Brian Hall, I see him online. Let's get him on the screen here. Add to the spotlight. There he is. And Ms. Wood, this is your case. So, hey, did everyone's monitor no longer say like your hard drive is corrupt and the world is ending? Is it all better?
Mine still says that.
You're still set. Oh, it's still on there. Okay. Let me add that to Ms. Nelson's to-do list. Okay. So Mr. Hall is position 2. What are we doing today with Mr. Hall?
Judge, we are doing just the final plea hearing, and just full disclosure, I'm asking to preserve the final plea rights. I dropped the ball on this one. I need a little more time to actually go over everything with Mr. Hall.
Okay.
It looks like he's already on the May 8th trial calendar.
He is. The first 3 positions are all May. We've only had 1 so far. That's Mr. Hall, are on the May 8th calendar.
Yes, so if we could just have the final plea hearing and then Mr. Hall and I will schedule time to get together. He actually lives out of state, I believe, so it'll be a Zoom session first instance.
Okay. Hey, Mr. Hall, were you able to hear Ms. Wood?
Yes, sir.
Okay, tell me where you are right now.
I'm in Chattanooga, Tennessee.
Okay, is that home for you?
Yes, sir.
Okay. Well, Ms. Wood is asking for a little more time. I think there were some things she was going to do on your behalf and connect with you a little more than she has already before she could make an announcement on your behalf. So I will preserve your final plea rights. So that whole spiel I just gave about today's the last day to enter a plea if you want to withdraw it does not apply to you. You are going to move to our May 8th trial calendar. Which means, let me see what day we're calling that calendar. Not on May 1. May 8th is when we're calling it. So yeah, May 8th. You'll probably need to be here unless the way your case is working out doesn't involve you being on probation in Georgia, which is where you'd be on probation. So you should make plans to be here in person on May 8th. That's the call of the trial calendar, but you'll still have your final plea rights if this is a case that is work outable. I'm looking at the charges. They don't look particularly serious. They also don't look like the kind of charges where usually there's a, wait, you got the wrong guy kind of defense. They're also old. We're coming up on 4 years old. So I'm going to let you and Ms. Wood connect after today. And I will see everyone on the 8th, if not earlier. If this can be resolved before the 8th, let's take the congestion off the 8th. That's more than a month from now. And we can figure out what we're going to do. Mr. Hall, any questions about that?
No, sir.
Okay, so your final plea rights are preserved. We're moving you to the trial calendar. And I will see you on the 8th, if not before. Ms. Dilligard, anything from the state?
Nothing from the state.
Your mention, Ms. Wood, of not necessarily having done everything you had hoped to do. Do you have any concerns about discovery?
I don't.
Okay. All right. So we'll do further notice, trial, final plea rights preserved. All right. Do you need Mr. Hall to stick around or can he sign off?
He's good, Judge. Mr. Hall, I sent you a message probably right as you were logging on. If you could just respond to that and then we'll go from there, okay?
All right.
Thank you.
Hey, can you just make sure you got the message?
It's on your phone.
Text message. Let's see.
Yes, it's a text message.
It's a text message.
I
You got it? Good.
Yeah, I got
Okay. Sometime later today, you write back to Ms. Wood, okay?
Okay.
All right. Thank you. You're good to go.
All right. See ya.
See y'all. Rasheen Garvin. Okay. We'll go through the calendar one more time. Amy Roney should be a plea, assuming Ms. Roney makes it here.
Yes.
Maybe there's a big line outside the building.
She texted me and said her ETA is 1:50, so she said.
All right, she got 2 minutes. All right, but your prediction is this is a plea.
Yes.
All right, negotiated or non-negotiated? Negotiated? Okay, great. And then Davario Davis?
That is also a negotiated plea. I believe I sent both the negotiated terms.
You did. I just didn't know if they're negotiated. I got your language for both those. Okay, great. So Mr. Davis, we can turn to your plea for, I want to get through the calendar, but we may do yours first if that's where we are, okay? But please stick around. Jeremy Taylor. Oh,
He's my judge. I
Okay.
expect a plea. I just need to get back there and go over all the rights.
got it. All right. He's got 2 cases. All right, that would be great. Mr. Jintao was online. Oh, that's a different Jintao. How are you, sir? All right. Ms. Wood, also your case.
Yes, Judge. I just need to speak to them and then I'll have an announcement for the court.
Okay, Ms. Wood's gonna, when we take a break, or when I'm dealing with a case that doesn't involve Ms. Wood, she's gonna talk with you and you guys are gonna figure out what you're doing, okay? Great. Then we got Sental Burse again, Mr. Burse. Oh, all right. Jarquavis White. Mr. White is here.
He is a negotiated plea, Your Honor.
All right. Mr. White, you heard that disembodied voice. That's Ms. Cabrera, your lawyer. She is often needed in about 15 different jurisdictions, but she is here virtually And we'll probably do your plea first, when we get to pleas, because she's appearing remotely and we need to get her to wherever she's going next, okay? Isaac Estrada.
Morning, Your Honor. Lisa Lanes here for Mr. Estrada. My client is also present.
Where? Right there. Hey.
I have some outstanding discovery concerns I'd like to pre-try. I also don't have an offer yet. So may I pre-try and then withhold my announcement at the end?
Yes, ma'am. Ms. Dilligard, who is at the inn there, is the person you're going to want to talk to. So when we're handling non-Dilligard matters, you guys can, matters, we can talk about, you can talk about the case. All right. Terrell Stokes. Mr. Stokes is here.
Right, this will not be a plea. I filed late, in a immunity motion.
Oh, I just read that.
Yeah.
Right. This is the stepdad of the girlfriend pulled the gun first story. Okay. All right. We need to work through that. And that might affect the state's offer and what Mr. Stokes is willing to do, depending on how that goes. It doesn't sound like it would be a super complicated hearing. I'm trying to figure out, do I keep it or do I send it to Judge Dempsey? But I have a limited number of cases I can send there.
It shouldn't be complicated. I think there was.
Complicated is the wrong word. It could be super sophisticated. I meant how long it would take. It seems like it would not be a ton of witnesses.
Correct. I think the only one besides him, that if they would be willing to be, his ex-girlfriend who was also there.
Okay. A reason to believe that that witness wouldn't be there?
No.
Okay. I'm being asked by IT, the states, you got the encrypt your hard drive error message. How about on yours? Okay. Good. Okay. So we should see if we can squeeze that in before the trial calendar. I think I got an email. Yeah, everyone is on the May 8th trial calendar. So if we could get the immunity hearing in before then, and rule on it, which probably means I would keep it rather than send it to Judge Dempsey, just because I don't control that scheduling. But I'll have Ms. Nelson talk to you and Ms. Dilligard about where we could fit that in. Mr. Stokes knows you filed that motion?
Yes.
Okay, so Mr. Stokes, we're gonna not have a conversation about final plea today. Instead, we're gonna have a hearing that's gonna be kind of like a mini trial. There won't be a jury here, but I will hear from you and any other witnesses your lawyer calls and any witnesses the state calls about what happened that day or night, back in 2022, that led to these charges. And then decide whether the prosecution can go forward. So, Ms. Rios, do you have good contact information for Mr. Stokes? All right, she'll let you know when that's going to be. Obviously, you'll need to be here for that, and we'll take it from there. Do you need Mr. Stokes to stick around? Any discovery issues?
I do not believe so.
Okay, Ms. Dilligard, anything else in Mr. Stokes's case?
Nothing further, Judge.
All right, then Mr. Stokes, you're free to go. Thank you. What I think I'm going to send to Judge Dempsey for an immunity hearing, Mr. Abate, is our long dormant deputies at the jail. Because I think one of the lawyers filed an immunity hearing. Yes. So I need to reactivate that and get it moving. So there's not a constitutional speedy. Yes, yes. Okay. What's the status of the range case? With the jury now?
We're gonna charge them at 2 o'clock.
Oh, okay. I needed to handle Mr. Pierce's situation. Did you have anything else here today or just Pierce?
Mr. Dandridge, that can be whenever.
Okay. Do we have an update on Mr. Dandridge?
I need to get back there. I have his favorite person from my office is here to join me. So if we could just get back there.
Okay, we'll do that. what's the best way to reach you? We don't want to interrupt charge. Obviously, once the jury's charged, you'll have much more free time. Okay, so we'll just know Pierce can wait. So why don't you go to 1D and then just once they're done with the charge, unless Ms. Dilligard's not going to let you go.
She will. This Williams, I think this Cabrera, she withdrew that motion.
Yes, she did. And if they can't post that bond, then we'll reconvene on dollar amount. She wanted to shift to a private bonding company, but I want pretrial supervision. So it's through 10%. That just, apparently that costs more. And if the family can't do that, then we'll get together on amount rather than format, but not today.
Ms. Dillard has given me permission tonight.
All right. Take it while you can. Okay, then that's the calendar. One last chance. Joseph Daniels.
He's in custody.
Oh, he's in custody. We're waiting on the lawyer. Thank you. All right. No bench warrant for a guy right through that door. How about Rasheen Garvin? All right. I'm always fascinated by bench warrants off of final plea. All right. Was there one? Oh, Ms. Roney, did you make it here? I'm less worried about that because you'd had contact with her. Sental Burse. Oop, all right. And okay. Why don't we, if we did Mr. White, that's Ms. Cabrera's client, then Ms. Rios and Ms. Wood are free to circulate, and maybe Ms. Wood and Mr. Dandridge's best friend from the PD's office can go talk to him, voice of reason. And Mr. White, if you want to come on up to the podium, please. Would you prefer to stand or sit? Stand. Podium it is. All right, Ms. Rivers, are you ready? Let's go on the record in State versus White. It's 24 SC 004566. Mr. White is here in court. His lawyer, Ms. Cabrera, is appearing virtually. Mr. White, I need to make sure that you are comfortable having Ms. Cabrera virtually rather than standing by your side. Are you okay with that?
Yes, sir.
If you ever need to speak with her privately, let me know and we'll let you step right outside. You can get on the phone. You have a phone with you?
Yes, sir.
Okay, you can call her and she can give you whatever counsel you need. But you got to tell me, hey, I need to take a break, and then we'll make that happen. Will you do that?
Yes, sir.
Great. Then we'll proceed in this format. Ms. Dilligard, when you're ready, if you would put Mr. White under oath, then we'll go from there.
Mr. Wright, please raise your right hand. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true and correct legal name for the record.
Jaquavis, Alexander White.
Mr. White, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
21 years old, and I dropped off at like the 10th grade. It was like a weird school. I ain't gonna lie.
You're blaming the school, huh?
No, just saying like it was like a weird school. So like we can go out to we move on our own pace.
Okay.
So,
do you have a high school diploma?
Yeah, no.
GED?
So, like, no.
Okay. All right. You don't have to bend over to talk in the microphone. We can hear you.
Is English your dominant language?
Excuse me.
Is English your dominant
Yes, ma'am.
language? Do you understand that you have been charged with the following offense? It's 1 count of possession of a machine gun and a count of driving without a valid license.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to those charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
Yes, so waived.
Mr. Wright, do you remember having been arrested for these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the possession of the machine gun, it's 5 years. And for driving without a valid license, it's 12 months, one day to 12 months. Is that your understanding of the ranges?
Yes, ma'am.
When I understand the misdemeanor one, I'm looking up the indictment first. But I'm curious, you just said 5 years. Is there no range? It's just a 5 year, we don't do a lot of machine gun counts here.
Just had 5 years.
I'll look it up also. I want to make sure we're operating off the same 123. Mr. White, we just want to make sure that we're all talking about the same sentencing range. It's not going to change whatever has been negotiated. But I need to be comfortable that whatever is negotiated falls in that range, and you need to know what the maximum is, because in theory, I could sentence you up to the maximum, although today's your final plea day, so you could withdraw your plea if I surprised you and sentenced you to 100 years in prison. But I don't think that's the maximum. It just says imprisonment for a period of 5 years. How bizarre. Okay. Normally there's a range for things. It's 1 to 5 or 1 to 10 or 2 to 10. But this one is just 5. Okay.
Mr. Wright, do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is 5 years probation on count 1, and on count 2, 12 months to run concurrent. The conditions is 50 hours of community service and to have no contact with any of his co-defendants, as well as stay away from 355 White Hall.
I missed the beginning. So 50 hours community service,
No
stay away from co-defendants, and then also the location. Oh, I didn't miss anything. All right.
Is that your understanding of the recommendation?
Yes, ma'am.
Well, how much probation was it?
5.
That's what I missed. Okay. The important part. Thank you.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to enter a sentence that differs from the plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Are you asking to be treated as the first offender?
Yes, ma'am.
Have you ever pled guilty to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
And do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status can be revoked? This means that you could be adjudicated guilty and could be resentenced up to the maximum sentence for each charge in this indictment.
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, ma'am.
Mr. White, how do you plead to the charges of possession of a machine gun and driving without a valid license in indictment number 24 SC 004566?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand for a felony charge, you only have 4 years from today to file a habeas corpus petition and 12 months from today for a misdemeanor charge?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that August 7th, 2024, officers responded to 355 Whitehall Street in Southwest Atlanta in reference to a person armed call. This caller stated that there were multiple males on the property brandishing firearms. 2 of them who were wearing face masks as well. When officers arrived, they met with a individual who had security guard on his shirt. The security guard said that they were filming a music video. Officers were advised that the guns were not real. The officers then saw the individuals then leave the scene while trying to stop them to just inquire about the firearms. They got into a blue Mercedes, which then left the scene. Officers conducted a traffic stop. The reason for the traffic stop, in addition, were the heavily tinted windows. When officers approached the vehicle, because the windows were so tinted, they asked all the passengers to lower all the windows. They were able to see a firearm in plain sight, so they detained everyone. A total of 6 firearms were recovered from the vehicle. Mr. White did have multiple firearms within his wingspan, and in an interview with law enforcement claimed that the firearm was the switch,
Which made it fully automatic.
which makes it fully automatic. Yes, Judge, and all that occurred in Fulton County, Georgia.
Okay. So this is the case involving, I can't remember if it's Mr. Key or Mr. Muse, who fancies himself as a prominent. Both are prominent musicians?
Oh, sorry, it involves both.
Yeah, no, it does. I see their name. I just can't remember which of the 2. His dad showed up and said, "You don't know who you're dealing with. This is the next Michael Jackson."
That's Mr. Key.
That's Mr. Key. Okay. Hence maybe the video they were making. Okay. All right. And you don't oppose first offender?
Yeah.
Okay. All right. Ms. Cabrera.
Yes, Judge. So I am asking that Your Honor allow him to enter his plea under first offender. Just like the state was saying, as when they interviewed him and spoke with him about what was going on, he was very accepting of responsibility, easily told them exactly what he was responsible for. That's been my experience with him as far as this is concerned. So once we reached a resolution, he was definitely prepared to go on ahead and enter the plea and to close the case out. So he's never tried to waver or, force the state to prove anything in particular. He's accepted responsibility the whole time. So I'm just asking that Your Honor grant him the opportunity to enter this plea as negotiated and allow him to do this under first offender treatment.
Okay. Ms. Jackson, do you have any criminal history information on Mr. White?
Your Honor, he does not have any prior arrests on file.
Thank you so much. Mr. White, I got a couple questions for you, and then we have to talk about first offender and we can go forward. First, what's your driver's license status now?
I'm getting it, but I gotta go get my birth certificate because I ain't have my social security. Like, I lost both of them.
Okay. So when this happened, you had no license at all, or you had a suspended license?
I have no license.
Oh, have you ever had a license?
No, sir.
Okay, so you're hoping to get one, but to get one, you need to have a birth certificate because you need to have a social.
Yes,
Do you have an ID card?
No.
Have you ever had an ID card?
Yes, I have.
Okay, where did it go?
I lost that too.
How'd you lose it?
In my pocket.
What do you mean? Like, if it's in your pocket, it's not lost?
Like, it just came up.
Oh, it was in your pocket, and the next thing you know, your pockets are empty.
All right.
Okay, all right. How are you gonna get your social security card?
People tell me I can go to the hospital to get my social security card.
Okay, I don't know. I was asking you what your plan was. All right, so, but you were driving that Mercedes?
Yes, sir.
Okay, where'd the Mercedes come from?
It's Takai car.
Okay, Mr. Key?
Yes.
Does he have a driver's license?
Yes, sir.
Okay, he was letting you drive?
Yes, sir.
Were you supposed to be his driver, or you said, hey, man, I want to try driving this?
Yeah, I just wanted to try.
How was it, a nice ride?
Yes, it was.
What kind of Mercedes?
Like I said, I don't know, it's some 300. I ain't into cars, so I don't know.
Okay, but you were enough into cars that it was nice to drive? Yes. Okay, and the gun with the switch, where did it come from?
It came from me.
From you?
No, like, hold on. You sound like the switch?
The gun that you're pleading guilty to that had the switch, so it made it fully automatic. Where did that gun come from?
I already had it.
Okay, but where'd you get it? You don't walk into a gun store and get it. Where'd you get it?
I see if you sound like where I got the piece from, but then I just got that.
So when you bought the gun, it didn't have a switch?
Right.
And then do you know did you install it, or you got someone to install it for you?
I got someone else to do it.
Okay, so you bought a switch, you bought the gun, and you had someone put them together. Where's the gun now?
They got the gun.
Okay. Ms. Cabrera, do you object to me adding a forfeiture provision that Mr. White's not going to try to go collect anything that was seized from him?
I have no objection, Your Honor.
Okay. First offender is something you qualify for. You had not been in trouble before. This was sort of a doozy for a first arrest to have a fully automatic weapon. But because you have not been in trouble before, I can sentence you as a first offender. If I do, then you don't have a conviction, which helps if you want to go back to school or for lots of jobs you might apply for. You don't have to check that box that says convicted felon. So it's mostly a benefit, but you'll be on probation for some years. And if you're not so sure you can avoid being in a car you're not supposed to be driving that has guns or drugs or something in it, you could get arrested again. And if you get in trouble while you are on first offender probation, not only do you have your new situation, but I can resentence you as a felon up to the maximum, which here would be 6 years, 5 plus 12 months. You understand the risk of being a first offender?
Yes, sir.
And some people say, you know what, it's not worth it. The lifestyle I lead, the people I like to roll with, I might get in trouble, and so I don't want to do first offender. No one's forcing you to take first offender, but you qualify for it if you think that's a smart move for you. Do you want to be sentenced as a first offender?
Yes, sir.
Why do you think that's not a risky thing for you?
Because I control who I be around.
You do. You very much do. You're young, and so you might not always be making the brightest decisions. Do you have kids?
No, sir.
So you're not balancing all that kind of stuff. But if you think you're ready to move forward in that way, then we'll do it. Do you have a weapons carry license?
No, sir.
All right. Well, Mr. White, I find there's a factual basis for your plea, and that your plea was knowing and voluntary. Voluntary means no one's forcing you to enter this plea, and knowing means that you've understood everything we've talked about so far. Do you have questions about anything?
No, sir.
Okay. I'm going to sentence you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small hiccup on probation, maybe you miss a meeting or something like that, you and probation will sort through it. But if it's a bigger deal, you get arrested for anything, to include driving without a license, that will come back to me and I'll figure out what we're going to do with that situation.
So.
Count one, I'm sentencing you to 5 years. I will probate those 5 years. Count two is 12 months. That will run concurrently with the 5 years, so the total sentence is 5 years. Special condition number one is that you get your GED, and you need to enroll in a GED course within 4 months. You don't have to start tomorrow, but in the next 4 months, you get yourself into a GED course and you provide proof of enrollment to your probation officer. Special condition number two, 50 hours of community service. Special condition number three is you stay at, what is that 355 Whitehall? Where were you guys filming?
It was like, well, at first it was at a smoke shop. Then went like down the street with like, well, it's like somebody workplace. I guess.
Okay, well, stay away from 355 Whitehall. And then the state has asked for this condition of no contact with the co-defendants. Are they any of them relatives of yours, or they were just friends?
They're just friends.
Okay. Are they close enough friends that it's not realistic to say you're going to stay away from them for the next 5 years? Because I don't want to set a condition that's going to blow up on you. I will tell you, Mr. Key and Mr. Muse have had a few cases here, so you may not want to hang with them as much. But I don't know Mr. Daniels, or I always mispronounce Mr. Beaufort or Buford. What's your situation? You think you're probably going to be hanging out with these guys?
Nah, I know how to stay away.
Well, I'm not saying you need to stay away from them if they're all going to be making good choices as well, but I don't, you tell me.
If it's a condition, I just have to do it.
Okay. You got other friends?
Yeah.
Okay, then you're all set. You won't be lonely. Then no contact with the other 4 co-defendants in the case. And finally, you're forfeiting anything that was seized from you that day. So you don't get your gun with a switch. P.S. The switch is illegal, so don't do that again. I think that's all I've got. Anything else? Oh, Ms. Dilligard, can someone in my office sign the indictment on your behalf? And Ms. Cabrera?
You can, Your Honor.
Okay, all right, if someone in the office signs your name to the guilty plea, Mr. White?
Yes, sir.
Okay. Ms. Simpson, who is seated right over there, is with probation. She's not going to be your probation officer, but she's going to give you some reporting instructions. So you and I are done unless you've got any questions.
No, sir.
No? Then I'm going to let Ms. Simpson take over.
Thank you.
Thank you, Judge.
Thank you, Ms. Cabrera. And the other guy, one last try since you're here. Cental Burse. Nope, no show. So there'll be a bench warrant for him. If for some reason he reaches out to you in the next couple of days, just let Ms. Nelson know and we'll work through that. All right.
Will do. Thank you.
All right, take care.
It was muted. Have a good one.
You too.
Judge, just so you know, for that case, the Mr. Beaufort Buford will be no processing his case.
Oh.
This could touch.
Okay, and what about Joseph Daniels? Because we had 2 people left in the case.
Daniels is in a different situation. He's was on either convicted felon or was on first offender, and so I'm not sure why he wasn't charged in that manner.
Okay, does he have a lawyer yet? Let's look. Yep. Oh, look at that. He has Mr. Lim. Is he on his calendar? Because we were waiting on. Oh, they're just not right next to each other on the calendar. Got it. So that's the same case. So Joseph Daniels? In custody, right. You've said that like 6 times. I'm just testing you because you looked a little drowsy over there. So we're looking for his lawyer, Attorney Lim. So he needs to work his situation out. I'll let Ms. Nelson know she can stamp a null pros for Buford or Beaufort. Okay, thank you. Do we have any other pleas that are ready to go? Okay, how did things go with Mr. Dandridge?
Not well, Judge.
Okay.
I do. If
I should have put him back. I just submitted my Emerson cases and I didn't include him there. I put, what's her name? Chiquita Favors instead.
Oh, thanks, Jen.
Sure.
If we could, it's a final plea, or it's more of an announcement from position 8, Mr. Gentile.
Yeah, let's do that. And then why don't we knock out some of those, please? So Mr. Gentile.
Okay.
He can maybe come right up to that space right there, as long as Ms. Rivers can hear him. All right, that's perfect. So we'll go on the record in your case, Mr. Gentile. It's 24 SC 004524. And today is the last day to enter a plea where you could withdraw that plea if you were unhappy with the outcome. Ms. Wood, do you feel like you've got all the discovery in the case?
I believe so. Ms. Clark sent over, it looks like everything she has. Full disclosure, I didn't get to go through it because I was in trial last week, and I do have a new offer. We did discuss that. This was Mr. Jordan's case. So in the fall, Mr. Jordan and I were working on this. And now that Ms. Clark has more information, I think the state's perspective may have changed a little bit.
In a way more favorable for Mr. Gentile?
Less favorable.
Less favorable.
Yes.
More information can do that sometimes.
Yes.
Okay.
So I'm just going to ask that we do the same that we did with Mr. Hall, but the final plea rights be preserved.
Okay.
I think Ms. Clark filed a motion as well.
Was this a?
Okay.
Yeah, right. So Mr. Gentile gave a statement. We will certainly address that. Is it one where Ms. Clark could simply get me a copy of the recording and we work through it? Or would you prefer that we get a detective in here and work through it that way?
I think a copy would probably suffice.
Okay. Ms. Clark, if you could, whether it's on a thumb drive or if the file's small enough, you can email it. But if you'll get that to Ms. Nelson, then I will look it over. If there's any part of it that leaves me, I'm not sure what to do, I'll email both of you and say, hey, send me an email with your arguments about X. And certainly if I just can't make something out, we may have to have a hearing. Mr. Gentile, it sounds like at one point you sat down with the police and they took a statement from you. Ms. Clark is wanting me to enter a ruling that is admissible if this goes to trial. And I have to conclude that if you did give the statement and you were in custody, that you gave it voluntarily. It wasn't coerced. Like the police didn't put you in a headlock and say, you got to answer our questions or something like that. It sounds like it was recorded. So I'll watch it and make a judicial determination if the police followed the rules they have to follow in having a conversation with you. And I'll let the two lawyers know, and Ms. Wood will let you know. And that's just another thing for you to be thinking about in terms of how you might resolve the case. It might be less good for you if the jury hears what you told the police. I don't know what's in the statement. It may be a great statement for you, but Ms. Clark wants a ruling before trial about whether she can use it or not. Okay? You're on the May 8th trial calendar, so you'll need to be back here on May 8th, if not earlier. The only reason why you'd come earlier is if you and Ms. Wood have resolved the case with the state and you're coming in to enter a plea. Otherwise, you'll need to be here on the 8th. You can still enter a plea on the 8th. Ms. Wood is preserving your final plea rights. So as late as May 8th, you could enter a plea, and I'm making these numbers up. The state might recommend 5 years to serve. Ms. Wood recommends 1 year to serve. If I were to sentence you to anything more than 1 year, you could withdraw your plea because that's more than what Ms. Wood had requested on your behalf. Obviously, if you go to trial, I say obviously, I'm telling you, if you go to trial and you're found guilty, I will certainly hear from Ms. Wood as to what a reasonable sentence is, but you don't get to withdraw anything. If a jury says you're guilty, then whatever sentence I impose, as long as it's a legal sentence, is the sentence you get. Any questions about any of that? No? Okay. Then I will look for the recording of the interview from Ms. Clark, and we will see everyone on the 8th, if not before. Does that give you enough time?
Yes, Judge.
Okay. All right. And I'll preserve the final plea rights. Ms. Clark, anything from the state?
No, Your Honor.
Okay.
That's my own case, ma'am. If you.
Yes, ma'am.
Thank you. Thank you.
Ms. Rios,
Yes.
your turn.
Can we do Mario Davis?
We sure can. Mr. Davis, come on up to the podium, please.
Oh, and Miss Ronnie is here. I'm not sure if I said that.
Is that who's in the way back? I saw someone come in. Okay, great.
I'm gonna have the case signature make a copy of that.
Wait 1 second. Okay. Ms. Rivers, you ready? This is 24 SC 001696, State versus DeVario Davis. Mr. Davis is in court. Did Ms. Rios just run out of the room?
No, I'm right here.
Oh.
Has some.
Hey, wow.
Has some proof of incarceration stuff. I was gonna see if Ms. Nelson wanted to come grab it. I was
Okay.
gonna email her.
Got it. Ms. Rios is here, and we've got Ms. Dilligard as the prosecutor. Mr. Davis, how are you?
Fine, sir.
Good. Ms. Dilligard is going to put you under oath in just a moment. Make sure you answer all her questions completely. If at any point you have questions of your own, I need you to let me know. If you need to speak privately with Ms. Rios, we can make that happen. Or if it's appropriate for me to answer the question, I'll do what I can. Okay?
Yes, sir.
All right.
Hey, Mr. Davis, please raise your right hand. Do you swear or affirm that any statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true and correct legal name for the record.
My name is DeVario Davis.
Mr. Davis, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Not at all.
Is there a medication that you normally take that you've not taken today?
No.
How old are you and how far have you gone in school?
I'm 45 and I have a GED.
Do you understand that you've been charged with the following offenses? It's 1 count of possession of a firearm by a convicted felon and a count of driving defective or no taillights.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to the charges?
I have.
Would you like any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive any reading of the formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Davis, do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the possession of a firearm by a convicted felon, it's 1 to 10 years. And for the defective taillights, it's 1 day to 12 months.
She had.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is on count 1, 5 years to serve 11 months. Credit for time served, 75 hours of community service, and to forfeit interest in the firearm that was seized. Is that your understanding of the recommendation?
Yes.
What about count two?
Oh, sorry, 12 months to run concurrent.
Okay.
That was not process.
Huh?
Not process.
You guys are gonna do your thing. I'm asking the state its recommendation.
Nick said it was not.
Okay.
processed, and I put.
Judge, count two will be a no process.
Okay.
Okay. Is that your understanding of the recommendation?
Yeah. Yes.
Do you understand that the court is not required to accept the state's recommended sentence?
I do.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, I understand.
Do you understand that do you understand that the court decides to enter a sentence that differs from the negotiated plea that you were expecting today, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
I am.
And do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
I do.
Mr. Davis, are you on probation or parole?
I'm on probation.
Okay, from Fulton County?
No, sir.
What county?
Douglas County.
All right.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
And do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
It is.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
I am.
Mr. Davis, how do you plead to the charges of possession, the charge of possession of a firearm by convicted felon in indictment number 24 SC 001696?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
I do.
Do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on December 13th of 2023, officers with Atlanta Police Department were patrolling in the area where they observed a blue Jeep Cherokee pull on the roadway with an inoperative rear passenger taillight. They conducted a verification using the license plate. The vehicle was registered to the defendant, Mr. Davis, who had an active warrant for his arrest out of Douglas County. Officers initiated a traffic stop, confirmed that the driver was the registered owner, Mr. Davis, who was then advised of the reason for the traffic stop and was detained before impounding the vehicle. An inventory search yielded a black and silver handgun, which was located underneath the driver's seat. A criminal history was conducted, and Mr. Davis was a convicted felon who was currently on probation status. And all of this occurred in Fulton County, Georgia.
Okay. I'm curious, Mr. Davis or Ms. Rios, there's a recidivist notice that I'm going to ask Ms. Dilligard about in a minute. One of them is a murder conviction. Was it something less than murder, or how is Mr. Davis standing right here?
I was not aware recidivist notice was filed.
It is, and presumably it'll be withdrawn
Yeah.
given what's happening. I'm more interested in the murder conviction. It's an old enough case, it's Fulton, that if you pull it up in Odyssey, it says final disposition, but there are no documents attached to it. So it doesn't sound like Ms. Rios was aware of this. In '01, you were indicted for murder and it was resolved somehow. Tell me about the case.
This happened in 2000. I wasn't even at a store.
Oh, I didn't ask the question well. I don't want you to get into the evidence. I mean, it is what it is. You pled guilty, so you're not in trouble for it
I didn't plead
again.
guilty.
Pardon?
I didn't plead guilty. It was dead docketed.
Oh, it was dead docketed?
Yes.
Yes, Judge, that's what my notes indicate, the 2000 murder arrest, which was dead docketed.
Well, it's listed as a conviction in the recidivist notice, not that you filed it, but George Jenkins did. He's like 8 levels above you. And there's a final disposition in the docket. I'm not doubting you. This is your situation. I was just curious how it played out, but you're saying it was, it does say way over there. It says dead docket order. Okay. All right. Any idea why they dead docketed it?
I wasn't there. It wasn't me.
Okay. Well, there you go.
It just, my name got caught in some mess.
Okay. All right. Well, that changes the recidivist notice to 2 convictions then, but it sounds like you're going to withdraw it anyway.
Yes, Judge.
All right. That takes care of that. That takes care of that. Ms. Rios, anything else you want to add?
Just that I ask that you accept the negotiated plea. He's working for Designer Solutions as a mover. He has his family here in support, his wife and children. And so I'm asking that you accept the recommendation. I did have him bring proof of the dates that he did 11 months in custody already on this.
Yeah, so let's talk about those so he can get credit for them. I see here, I think the math won't end up being that complicated. So he's arrested on the 13th of December for this, slash the warrant for Douglas. He stays here for 84 days. And it says transfer to another agency. So I assume in early last year, you went over to Douglas.
I did.
And then did you just stay there or did they send you to the state?
I went to state prison.
You went to prison, then I guess came back here because you did another 73 days?
Yeah,
Yes.
then we set aside the bench warrant because he was in custody.
Got it. So basically from the day you were arrested, which was the 13th of December 23, you didn't get out until September of 24?
No, I got out November the 17th of 24.
That's
That's
when
the
we
day I
had-
was released from Fulton County. You remember?
Oh, right, you got booked back in. You're right, you're right. Bad math here. So you basically did almost a year.
Yes.
And this is so hence the 11 months. Okay. Because you went from here to Douglas to the state, back to here, and then got released. Okay. Yeah, 11/17. There it is. Okay. Okay. Do you have any questions about anything?
No.
Ms. Jackson, do you have any criminal history information on Mr. Davis? Ms. Jackson, are you there?
Yes, I am, Your Honor. For some reason, I was having problems unmuting. I don't know what happened. I'm here.
That's okay. We got you. All right. Criminal history on Mr. Davis.
Yes, sir. He has 31 cycles. The last arrest was March the 5th, 2024, out of Douglas County for a probation violation. He does appear to be on misdemeanor probation in Butts County for a DUI.
Oh, yeah.
That disposition date was November the 21st, 2024, and the term is for 12 months. He does have prior felony convictions, one in 2009 out of Douglas County for possession of cocaine with the intent to distribute, one in 2003 for possession of controlled substance with the intent to distribute, one in 2001 for 2 counts of possession of controlled substance, one in 1997 for the violation of the Georgia Controlled Substance Act. He does have misdemeanor convictions, one in 2007 for possession of marijuana less than an ounce. And there was another one in 2007 for battery. Nothing in addition, Your Honor.
Thank you. So it sounds like Ms. Rios, Mr. Davis has already been revoked in Douglas in connection with this, or he already had a warrant from Douglas.
My understanding is that that is true, and and he's spoken with probation because he would have pled at the first hearing, but I was giving him more time to speak with probation in Douglas, and he said he's wrapped that up.
Meaning you don't have probation anymore in Douglas?
No, I still do. I report here in Fulton now.
Yep.
And I talked to them and had a discussion with Douglas, so she called me back and said I was okay to accept the plea. I've already been violated.
Okay, that's all I was trying to get at is I wanted to know if this plea today exposed you to another revocation on your Douglas case, and you're saying you've been told no, it doesn't. Okay, well, hopefully they're right. Do you have questions about anything we've discussed, Mr. Davis?
No, sir.
Okay. Well, I find there's a factual basis for your plea. You were driving, no taillight, you had a gun, definitely shouldn't have a gun. Whether you feel like you need it for safety or security or business reasons, you're not eligible to have one. And this is just going to keep biting you. You are old enough now, you need to stop accumulating cycles. You heard Ms. Jackson say 31 cycles. That means you've been arrested a ton of times. More years than you've been more arrests than years you've been an adult. So you're going to need to figure out how you're changing that around. I find there's a factual basis for your plea, and that your plea is knowing and voluntary. No one forcing you to do this, and you've understood what we've been talking about. Do you agree with that? Okay. I'm sentencing you pursuant to the Probation Options Management Act, which means for the 4 years and 1 month you're going to be on probation. If you have a small issue, you and probation can resolve that. You don't need to see me. But if you get arrested for anything, that comes back to me. I'm letting you know now, if we're together again and the charge involves you possessing a gun, I'll revoke a big chunk of your probation. Okay?
Yes, sir.
And you'll have new charges. And if they're in a county outside of Fulton, that could get extra messy. So just keep that in mind. Ms. Dilligard, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Rios?
Yes, sir.
And can we sign for you, Mr. Davis?
Yes, sir.
All right. Do you have, it's going to seem like a strange question given what we just discussed, but do you have a weapons carry license?
No, I do not.
Okay, good. Don't try to get one. Count one, I am sentencing you to 5 years to serve 11 months, and you will get credit for time served from December 13th, 2023 through November 17th, 2024. Balance probated, that's the 4 years and 1 month. Special condition of probation number 1, complete 75 hours of community service. Special condition number 2 is that you're forfeiting whatever was seized from you back in December of 23. I think I covered everything from the state. Yes? Yes. Anything, Ms. Rios, on your side?
No, Your Honor.
All right. So, Mr. Davis, you work for a moving company?
I do.
Are you someone who carries heavy boxes upstairs, or do you own the company, or do you drive trucks, or what do you do?
I do the moving part, the labor part, the hard stuff.
The sweat part.
Yes.
All right. Well, it's about to get hot outdoors, so good luck with all that. That's all I've got. You're going to need to coordinate with Ms. Simpson. She is with probation. Yours may be pretty simple. You are on probation right now. You were saying the Douglas case is supervised in Fulton. This should be pretty seamless. You should keep the same officer, and you don't have to report twice because it's 2 cases. It's just if you have future issues, you might need to go to Douglas to deal with part of it, and then obviously you'll come back to me.
Gotcha.
Okay?
Yes, sir.
All right. Thank you. All right. You good if we do another plea before we take a break? You're good? Okay, good. What's next? If we're alternating, do we do Ms. Wood now, or we're not alternating?
I don't believe that he's in custody.
Okay.
Oh, yeah, why don't we take care of folks not in custody?
And then we'll be done again.
Ms. Leos, did you get a chance to speak with Ms. Dilligard yet?
No, Your Honor, it's still.
Okay.
Fine.
All right, well, I'll tell you what, we're gonna take, Ms. Roney's plea, and then if we get our major case prosecutor back, we can bring Mr. Pierce out, which won't involve Ms. Dilligard, and may tie us up for a little while. I appreciate your patience.
Oh, my God. Truck.
Oh, I was emailed it to her. So you did on that particular paperwork.
Well,
The work, please, or.
I cannot.
Are you ready?
It's trying to confirm, trying to get it
Yesterday.
Oh, yeah.
Sure, believe.
Ms. Rios, are you ready?
Yes, I'm good.
All right. We'll go on the record then with 24 SC 001446, State versus Roney. Ms. Roney is here with Ms. Rios, and Ms. Dilligard is the prosecutor. Ms. Roney, you're going to be put under oath in just a moment, and then you'll need to answer a bunch of questions, mostly from the prosecutor, but some from me. And I am here to answer questions you may have, okay? You're gonna have to answer out loud to all the questions. You're welcome to nod your head, but make sure you answer out loud, all right?
Sir.
All right. Ms. Dilligard.
Ms. Bernie, can you please raise your right hand? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
Lower your hand. Please state your true and correct legal name for the record.
Amy Elaine Roney. And did you say age?
Not just.
We're gonna get to that.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Under the influence of medication, but I do take mental health medication.
What do you take and how often?
I take Lexapro, 10 milligrams once a day. I take Adderall, 10 milligrams once a day. And then I take alprazolam, a half of a milligram once a day.
Okay.
Or use as emergencies for panic attacks.
And those prescriptions are designed to help you with what diagnosis?
Anxiety and attention ADHD.
Did you take any of those medications this morning?
I take them as prescribed.
Oh,
So I did.
I don't know how they're prescribed. You said 10
So,
milligrams.
I just took my Adderall this morning.
Okay.
As prescribed.
So you didn't take the Lexapro or the other one
Take the Lexapro at night.
at night? Okay. Does taking the Adderall make you woozy or confused or not knowing what's going on around you?
No, absolutely not.
Great. All right. Thank you.
Ms. Bernie, how old are you and how far have you gone in school?
I'm 43 and I graduated.
High school, college, medical school, high school?
Do you understand that you've been charged with the following offenses? 1 count of theft by deception and 2 counts of identity theft fraud.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the charges in this indictment, including the facts and circumstances relating to these charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
Not unless she feels that no,
Are you satisfied with your lawyer's services?
absolutely.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
Yes.
Ms. Roney, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you the minimum and maximum sentence for each charge which you're pleading guilty to today? For the theft by deception, I have 2 to 20. 2 years to 20 years.
Is that because of the value of?
It's because of the value. That's what I have on my
Okay.
notes. Right.
I thought it was 1 to 10 years, but it's
I think
like
it's
being
because of the
changed.
value of the
Okay.
Mercedes Benz.
I'll look while you guys.
And for the ID theft, because this is a fraud, because it's your second conviction, the range is 3 to 15. Is that your understanding of the ranges, Ms. Ronan?
For the 3 to 15 for which one?
For the identity theft.
Yes, ma'am. I understand the guidelines that you are telling me what they are. Yes, ma'am.
Okay. Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? I know you're.
I'm ready.
Okay.
I'll multitask.
Okay, the recommendation is 7 years to serve 92 days. Credit for time served, to take an anti-theft course within 90 days, 100 hours of community service, stay away from all Mercedes-Benz dealerships. In the. You want to check?
You guys keep trying to change things up on the fly.
I don't believe that was in the email, but that was weird.
Take better notes.
Huh?
That's classes from completion of problem.
So the issue is, hold on one second.
Yeah, she did like all this.
Yeah, I'll do that course. I'll do that. And then, what about when I was in Fulton County for the 90 days?
Mhm.
I was, community service there, like I was on runner.
Oh, that's gonna count.
That doesn't count?
Yeah.
Oh,
So are you okay with the community service?
yes.
Okay. She's fine with that.
So an anti-theft course, or that's out now?
That's in.
Yes, okay, and you should know this, Ms. Roney, if you've taken one and you can provide proof that you took it, probation might decide, why do we have to make her take it again? But they have that discretion, because I overheard legitimately, Ms. Rios saying, I think she already took an anti-theft course. So anti-theft course, 100 hours community service, stay away from Mercedes-Benz, all Mercedes-Benz, not just Buckhead. And then what about Buckhead Village, where you weren't gonna count to? Was there anything is to count to?
Oh, I stay away from men's locations.
Okay.
And then, no contact with Courtney Clark, which I don't believe they have. Courtney Clark.
Courtney with a K.
The K, yes.
Tell me how to get anti-theft.
Okay.
Probation should have instructions about anti-theft, of course. But if you have trouble, let me know and I'll try to figure out.
Oh, well, what about these? What? Stuff.
That's number that's after.
Okay. Cool.
Okay. Is that your understanding of the recommendation? No need to apologize. Is that your understanding of the recommendation?
Yes, ma'am.
Okay. You understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court also has the right to run those sentences consecutively?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea that you were expecting, that you have the right to withdraw your plea of guilty?
Yes, ma'am.
Are you currently on probation or parole anywhere?
I am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
I do, but I've been to, it's all connected. So, like Gwinnett County was connected with this case. And then, Bibb County I've been on. So once I got, before I could get into accountability court in Gwinnett County, I had to do a production order and go there. And so, they're aware of all the.
If you've already been revoked for this conduct, the trying to get the Mercedes from Buckhead Mercedes. If you've already been revoked in Gwinnett or Bibb, you're not going to be re-revoked because you've pled guilty. But if in Bibb County, they've never had a conversation with you about, hey, look what happened. This happened a while ago in 2021. Then it's possible that this would bring it to their attention because now you have a conviction for it. So you know better than anyone else in the room if you've already dealt with Gwinnett or Bibb in connection with you getting arrested for what happened with Courtney Clark's driver's license and the Mercedes. Does that make sense?
Thank you for making that transparent for me.
Okay, I don't know about transparent, but you're welcome.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
You understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Ms. Bernie, how do you plead to 1 count of theft by deception and 2 counts of ID theft fraud in indictment number 24 SC 001446?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today to file a habeas corpus petition?
Yes.
Judge, if this case were to proceed to trial, the evidence would show that on December 2nd of 2021, officers responded to the Mercedes-Benz of Buckhead, who stated that a female walked in to buy a vehicle and produced a license with the name Courtney Clark on it. The Mercedes-Benz learned that the woman who presented the license was not Courtney Clark and that Courtney Clark had been a victim of ID theft. The officer was notified that that same Courtney Clark with the same fraudulent ID was used at an apartment at 3150 Roswell Road. Officers responded to that location. They spoke with staff at the complex who informed them that the individual living in that unit is a white female in her late 30s or early 40s with straight black hair. Officers viewed a copy of the woman's driver's license that was used on the application. The name was Courtney Clark and was identical to the one used at the Mercedes-Benz dealership. The courtesy officer said that the ID that was presented was not the person that was actually living in the apartment. Officers were made aware that the real Courtney Clark was a victim of ID fraud in Oconee County, Georgia. The sheriff there identified the suspect in that identity theft to be Ms. Roney. And Ms. Roney is currently a suspect, at that time was a suspect in other ID fraud cases from buying vehicles with fictitious name, including that of Courtney Clark. This defendant was arrested and detained, waived her Miranda rights, and agreed to speak with officers. She then admitted that she was the person in the pictures at the Mercedes-Benz dealership purchasing that 2017 Mercedes-Benz. She also admitted to using that same ID to rent the unit at the complex which she was living at, and she also listed the 2017 Mercedes-Benz as her car on her parking application at the apartment complex.
What's the theft part. I'm confused. I'm not confused by most of what you said. Ms. Roney was masquerading as Courtney Clark. But if she paid with US dollars, to get the Mercedes Benz, but just bought it under someone else's name, I'm trying to understand
The deception part.
it's deceptive, because you say you're someone else, but if Mercedes, let's pretend the car cost $30,000. And Ms. Roney says, here's the 30 grand, but she says, I'm actually Ms. Clark. And maybe it gets titled in Courtney Clark's name, all that. I'm just curious what, your sense of what, I'm not trying to undo this. I'm just, I guess I'd be disappointed if I were Mercedes-Benz because we're dealing with someone who lied about her name. But mostly if I'm Mercedes-Benz, I want money for the car that you rolled away in. And if I got paid, then I'm confused. Because it doesn't sound like what the police were saying is, or that Mercedes was saying is someone stole the car.
I think it's that they obtained the property by using deceitful means. That's was my understanding of the charge.
Yeah, that's what it says. I guess you're right that that you obtain it by creating an impression of an existing fact, which is false, and the accused knew it was false. So I guess it's just that there's this intention of depriving the owner of the property. And if you pay for it, then you haven't fully deprived the owner. I mean, I don't endorse what happened here. But I was just curious if there was more to the story that, yeah, and we've been unable to collect on the car because when we reach out to Courtney Clark, the real one, she said, well, I drive a Honda. I don't have a Mercedes.
No, Judge, and I do believe that the Mercedes was recovered in Gwinnett County.
Okay.
But
Well, then it wasn't fully paid for if they needed to get it back. So it may have been, did you?
I think it was using the credit of the person.
Financed it, and then I would made payments on it, and
Got
then.
it. But all under the name of Courtney Clark.
That's correct.
Okay.
The bank is actually who, I had the same issue in Gwinnett County where we had to come back to court during drug court to get some of the restitution taken off because the cars were recovered. And then,
There's more than one car.
yes.
Okay.
Yes, sir. All the, Gwinnett County, this county, and Oconee are all the same.
Okay.
Courtney Clark.
Okay.
You know, was lived a different life than.
Sure. No, I saw. Yeah.
So, but I financed it. So I would
Okay.
make the payments. And basically what was determined was they knocked a lot of the restitution off because the car lot didn't take the loss, even if it wasn't recovered because it got the bank paid. You know, it was through, if you get a bank note basically and you pay on it, it's the bank buying it for Mercedes-Benz for
Right.
you.
Right.
Or
But
whatever.
someone's left holding the bag if the car's not recovered, but it sounds like it was recovered.
It was
But-
recovered in Gwinnett County at the car lot where I got the Gwinnett County case. Left it there because I couldn't drive.
Okay. All right. I'll move past this. It's just, it's an interesting coupling of charge and facts. But I think we're okay. Anything else from you?
I just wanted to add that the fact that Ms. Roney had completed the Gwinnett County drug court successfully was taken into account when making the recommendation as well.
Okay. Got it. Ms. Rios.
Yes, Your Honor. Ms. Roney is 43 years old. She works now at Bonefish Grill. She has completed drug court, which I've showed, and she's been doing really well. She's got her life together since these situations. Right now, she does have probation in the other county. So I am also asking for her probation fees to be waived here, so she's not paying multiple probation fees because she still has some restitution left, correct?
In Gwinnett County,
in
yeah.
Gwinnett. And so I wanted her to be able to focus on paying the restitution. She has a steady job, but her income is not very high. I'm also asking for her to have a behavioral incentive date of 3 years. It seems like that she will not have any problems going forward since she's recovered. She's on instead of self-medicating, she's on the prescribed medications that she's supposed to be on.
Okay. The waiving of the probation fees, I don't think you pay multiple. You don't pay per. And so if
Okay.
you're already on probation, but Ms. Simpson can correct me if I'm wrong, if we're adding another case to probation, I don't think you pay that amount for each case.
I was just making sure because I believe it was 2 counties.
Mhm.
So I wasn't sure how.
Right. There's one collection.
Okay.
You could be on 10 cases and it's one. Okay.
Have those one fees waived, so she can.
So that would be a different counties. If she gets them waived everywhere else, let's come back here and talk about that.
Okay.
All right. Ms. Jackson, good afternoon. Do you have any criminal history information on Ms. Roney?
Yes, Your Honor. She has 20 cycles. The last arrest was October the 28th, 2022 in Oconee, Georgia. And that was for identity theft fraud. There was no disposition for that arrest.
Yeah.
He does appear to be on probation in Gwinnett County for 2 counts of theft by deception. That disposition date was December the 30th, 2022, and the term is for 12 years. Also, she appears to be on probation in Bibb County for identity theft fraud, 5 counts. That disposition date was September the 27th, 2017, and the term is for 10 years. Also, she appears to have an additional open probation case in Bibb County for burglary. That disposition date was February the 27th, 2007, and the term is for 20 years. She does have, there was one in 2005 out of Florida for 4 counts of possession of controlled substance. An additional one in 2005, it was a federal case out of Florida for mail fraud. And she does have 1 misdemeanor conviction that was in 2014 out of Bibb County for giving false information to an officer. Nothing in addition, Your Honor.
Thank you. Ms. Roney, what do you do at Bonefish Grill?
I'm actually a to-go specialist and catering.
Okay. Does that mean you will go out to an event and set stuff up, or you just take the orders
It's
when
in
people?
progress right now.
Pardon?
It's in progress right now with me actually transferring from WebGen to Buford for that reason. So yeah, but I've been with Bonefish for 2 years now.
Okay. And you said transferring from where to Buford?
WebGen to Buford location.
WebGen. Got it. Okay. And how long were you in drug court in Gwinnett?
21 months. I graduated
I saw the certificate.
October 11.
Okay. Congratulations on that.
Yeah.
And was your primary drug of use meth or anything or prescription pills?
It was mainly meth,
Okay.
cocaine.
Has drug court been successful? Have you enjoyed
It was-
sobriety since then?
It was absolutely the best thing that could have ever happened for me. Just due to my behaviors. If anything, you know, I know that I have an addiction to the type of past crimes that I have. And drugs also induce that behavior and the environment as well. So
Okay.
I'm sorry, I'm nervous and my mouth gets.
Don't worry about it. This is not an easy time. I'm asking you about hard things. But I'm very interested in the progress you've made to see if the sentence we're agreeing to put in place is something that will help you move in the direction you've been moving, or if we're going to see more of someone else's name and a car you really don't need to be driving in, or that you're just flipping to someone else to get money to support the way that you're self-medicating, et cetera. But it doesn't sound like that's you anymore, which is great. Do you have any questions about anything we discussed? No?
No.
Okay. Well, I find there's a factual basis for your plea. It would have been an interesting case to go to trial because I'm still not convinced 100% that the car was stolen. But clearly you deceived the dealership. And so I don't know legally how that will play out. And clearly you were using Courtney Clark's ID to do a variety of things that none of which helped her. And I'm sure she didn't say it was okay for you to be doing that. Was that a complete stranger to you or someone you knew?
Never met her.
Okay. All right. I also find that your plea is knowing and voluntary. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a minor issue, you and probation will figure out what to do with that. But if you get arrested for anything, that comes back to me and we'll figure out what to do with that. It doesn't sound like there's restitution in your case, Ms. Dilligard.
No, Judge.
No? Okay. All right. Then Ms. Roney, I will sentence you on counts 1, 2, and 3 to 7 years to serve 3 months with the balance probated. Special condition of probation number 1 is to take an anti-theft course. And as I mentioned before, if you've already done that, then you just need to get proof that you, not Courtney Clark, but you actually completed it. And then the probation folks will probably waive that. You'll need to complete 100 hours of community service. You don't have to do that all at once, but start chipping away at that because probation is not going to be interested in making your probation non-reporting or unsupervised or anything like that if you still have balance remaining. You'll need to stay away from all Mercedes-Benz dealerships. It sounds like you are pretty far away, both where you live and where you work, from Buckhead. Any reason for you to be in the city of Atlanta, or do you not come into Atlanta?
I don't really come into Atlanta like that anymore, because I don't live in Fulton County. I stayed out in Gwinnett County, where I didn't know anybody.
Yeah.
And did accountability court there.
Okay.
And it's just been better for me to stay there.
Okay. Well, I'll limit it to you just stay out of Mercedes-Benz dealerships. Obviously, no contact with Courtney Clark, who was a stranger to you, even though you were masquerading as her. I will set a behavioral incentive date of April 2nd, 2028. That's 3 years from now. If you've taken care of everything in terms of your special conditions and things have gone well on probation, there weren't revocations because you weren't going to your meetings or you relapsed or something, then probation will have the authority to reach out to me to say, could we just close Ms. Roney's case out? She's not an issue. We have all sorts of people who are a hassle, and she's not. And I will favorably consider that request.
Thank you.
Ms. Dilligard, anything else for the state?
Nothing further, Judge. Thank you.
Ms. Rios, on behalf of Ms. Roney?
Sure, Your Honor.
All right, Ms. Roney, I'm gonna have you speak with Ms. Simpson, who's seated over there. She's with probation. She's gonna give you reporting instructions. Good luck.
Thank you.
You're welcome. All right, why don't we, yes, ma'am.
Oh, I have a quick announcement from the morning's calendar, Judge.
Oh, yeah, I saw Mr. Rhodes. He's got some flashing light in the background there. He's kind of hard to miss on the screen.
He apparently had some issue, Judge, and he's been very frantically reaching out to me. So I just filed a waiver and I wanted to let the court know that he did make it to court today.
Excellent. Let's, can you hear me, Mr. Rhodes?
Yes.
Okay, what's going on in the background there? Are we about to be invaded?
Oh, no, sorry, I'm sorry.
No, you can leave it on. I'm just curious what that was.
Oh, just my little party light, my night light.
Your little party light. Good. Well, bringing some cheer into the dreary courtroom. Mr. Rhodes, you were supposed to be here this morning. Tell me what happened.
Well, we had a power outage. I woke up to there was no power. My phone died, and I had no alarm, so I overslept.
Okay, and your party light wasn't going off, so
nothing was going off this morning.
Got it. Well, you today had your arraignment, but Ms. Wood is waiving arraignment for you, which means she's entering a plea of not guilty. She'll get discovery soon. She's going to want to meet with you about that discovery. So both of you can talk about what's in the state's case and what's not. I need to talk to you real briefly about your address. So I have two different addresses for you. Are you on Shell Road?
I'm not on Skellmore anymore. I'm on 3714 Clovis Court.
Did you get something in the mail to be here? How'd you know to be here today?
Miss Wood called me.
Okay.
Mr. Rhodes, if you would just reply to that email with your current address, I'll get it updated in the system for you.
Okay.
Thank you.
All right. So you got an email from Ms. Wood. Make sure you give us your address. It's on you to let us know where you're staying. I know this case is a little old, meaning what you got arrested for happened a long time ago, but it's going to start moving again, and we need to be able to mail notice to the right address. Let me look at your bond, see if there's anything funky there. That's not it.
Oh no.
Here it is, I guess. All right. Yeah, you're just supposed to stay away from someone named Drexel Tucker. You know who that is?
Yes.
Okay. Have you been staying away from Mr. Tucker?
I moved completely from the area.
Okay, but people can connect in all sorts of ways. You could be online harassing him, shooting him in Fortnite, or who knows what. You leaving Mr.
whatsoever.
Good. All right, keep it that way. Ms. Dilligard, anything about the Rhodes case?
No, Judge.
Okay. Do you need Mr. Rhodes for anything else?
No, Judge. Thank you.
All right, Mr. Rhodes, you're good this time. You gotta make it next time, okay? All right.
Thank you so much. Have a wonderful day.
All right, you too. Bye-bye.
Bye-bye.
All right, one more quick one, and then we'll get Mr. Pierce out here. Mr. Lim has joined us. Hello, Mr. Lim.
Hi, Your Honor.
We're having a little trouble hearing you.
Can you hear me?
Now I can hear you. Yep. So you have Joseph Daniels on our final plea calendar. He is here. He's locked up in custody. Tell me what you're thinking we're going to do today.
Judge, today I did file a motion for bond as well, but as far as the case itself for the plea, I received a recommendation and I sent an email back stating that the video from the, took responsibility for the gun.
The video what?
Yeah, in the discovery,
yep.
Co-defendant Jarcavius White took responsibility for the gun that Mr.
Mr. Daniels
is charged with.
Okay. Well, I don't want to get in the middle of the negotiations you might have with Ms. Dilligard. Today is Mr. Daniels' final plea date, so he may not be interested in resolving the case right now based on the offer that the state sent. That's okay with me. We just need to get that on the record so that we can let him know he's moving to the trial calendar, which is on May 8th. So not very far away at all. And maybe between now and then, you and Ms. Dilligard can talk more about the impact of what Mr. White has talked about. Okay?
Yes, Your Honor.
All right. Do you mind if we bring Mr. Daniels out and just have that quick conversation with him?
Yes, and the bond, Your Honor?
I don't know that anyone was prepared for that. Let me look in the docket. That I don't have it on my calendar as for bond hearing. Let me look. Mr. Daniels. Yeah. So you filed your motion like 3 days ago. So it's not calendared for that. I don't mind setting it down in the near future for that, but I don't think it was on the state's radar. It certainly wasn't on my radar.
Okay. I was told that he got revoked for 6 months and has served all his time from the revocation, and that he's been held now on this charge, which he was already given bond already when he got revoked.
Judge, he has two answers. He has two permission uses.
Okay, and what's happening with the other one?
One expires in like less than 20 days, but
Yep.
the other one, he still has 9.5 years.
Okay, but was he revoked on those?
No, he was revoked on the 21 SC case, but he was not revoked on the older case.
Interesting. Okay. All right. So Mr. Lim, he had no bond from Judge Wolf in August. Here's another bond order in August. So he has a bond. And I didn't do anything to take it away. So he just needs to post the bond that he already has.
How much is that, Your Honor?
Pardon me?
How much is that bond?
$7,500, which is probably as low as it's going to get for someone who was on probation in 2 cases when he got arrested for being involved with a fully automatic weapon.
Okay.
But let's bring him out. Can we bring Mr. Daniels to the podium, please? Right on up there to where that microphone is, Mr. Daniels. Good afternoon. How are you?
Good afternoon, Your Honor.
Your lawyer, Mr. Lim, is on the screen right there. He had to be in another jurisdiction, so he was only able to patch in right now. He's been in court elsewhere. You're on the calendar today for what we call final plea. This is the last day you could enter a plea in your case and have the ability to withdraw it if I sentence you to something more than what Mr. Lim asked on your behalf. He received an offer from the state and has had a back and forth with the prosecutor. I think Mr. Lim is seeking the dismissal of your charges, or charge, it's one count, because of something another defendant has done, a co-defendant of yours in the case. But that's not where things are quite yet. So I'm going to ask Ms. Dilligard to state on the record what the offer is, and if that's not anything you're interested in pursuing, that's fine. Just means we move your case towards the trial calendar, and Mr. Lim's going to be free to continue to argue on your behalf that the state dismiss it or reduce it or whatever that is. Does that make sense?
Yes.
Okay, and we're going to talk about bond in 1 second, but first, Ms. Dilligard, what is the state's recommendation right now for Mr. Daniels?
It's 5 years to serve 9 months, balance probated.
Okay, so if you were to enter a plea, how much time have you already been in, Mr. Daniels?
5 months.
Okay, so if you were to enter a plea today, Ms. Dilligard would recommend on behalf of the state that I sentence you to 9 months to serve, so a few more months, credit for time served, followed by, that would be 4 years and 3 months on probation. That's the state's recommendation. Mr. Lim is free to argue for something different than that, something less. But it still involves you pleading to the case, and Mr. Lim may be telling you that you ought not to plead because of whatever private conversations the two of you have had. Is that an offer you're interested in pursuing, or do you want me to move your case to the trial calendar that's up in about a month?
You can pursue it.
When you say pursue it, tell me what you mean.
I accept the offer.
Okay, do you want to talk with Mr. Lim for a minute, or are you good to go forward?
Can I talk to him for a second?
Yeah, I'm trying to figure out how we work that out because he is on the phone and you're here in court. So I don't know that we can get you into a private conversation. So why don't we do this? Mr. Lim, when is the next time you could connect with Mr. Daniels? Because I am fine bringing him back here and you connecting virtually or being here really anytime this week or even early next week. So we don't need to wait a long time, but it sounds like you and Mr. Daniels should have a chance to have a private lawyer-client conversation.
Yes, Your Honor. you have court any more time this week?
So I think your question was, do I have court another time this week? You may be like in a cave or something, because we're getting a real bad reception from you. But let me look. So we have the ability to see you and Mr. Daniels Thursday or Friday morning. Most of the day Thursday and then Friday morning.
Friday morning work.
All right. I think you said Friday morning works for you. What I'm going to do is have Ms. Nelson coordinate with you and Ms. Dilligard to see if Friday morning works. Okay?
All right, thank you.
You bet. Mr. Daniels, we're just going to freeze things as they are. The state's going to leave that offer open. You and Mr. Lim can speak before then, or if he's here in court, he can talk to you back there, but we'll get you brought over on Friday morning, and we'll see if this is something that can work out. Okay? Any questions?
No, sir.
All right, I'll see you then.
May I be excused, Your Honor?
Yes, sir. We'll see you, or you get contact from Ms. Nelson, okay? Okay. Do you want to take a quick break before we bring Mr. Pierce out?
Yes.
Okay. We'll bring Pierce out and then we can, I don't know what we need to do with Dandridge. I can tell him what life is, but that's sort of it. Pierce, I have to talk to.
Yes, and then I just have the ready on Jeremy Taylor.
Great, we'll do that too. Pierce was from this morning, so I'll do that. And if you don't even want Mr. Dandridge to come out, he doesn't need to come out. That's up to you. But his best friend from your office came all the way over here. Let me see what else we've got. So Jeremy Taylor, we'll do that. And then I know we have Mr. Estrada, his lawyer is finally able to talk to Ms. Dilligard. And I think that's it. So Pierce, whatever you want to do with Dandridge and Taylor, and we'll see what's happening with Mr. Estrada. Okay, good.
FYI, there's the encrypted hard drive is back on this screen.
Yes, and I think there's a way you can drag it down. They have to, they know that, and they were supposed to make it go away temporarily, and then they have to come in here and reboot all the machines.
It did go away for a little while, but it's back.
It's back. Okay, we'll let them know. Thank you. All right, so I'll come back out in a moment and we'll handle Mr. Pierce. So the jury's deliberating in range?
Yes, sir.
All right.
Oh, no, that's.
Hey, how come you're still, do you have more cases? Oh, you have half of Dandridge if it was going forward. Oh, okay. Right, okay.
Although,
Taylor's, I'm told, pleading, so you should stick around for that at least.
hanging out, but the still work about maybe, labor meeting, if possible.
Good.
Oh, you want to do that all.
Listen, and I don't.
There's really people here though. Well, here. You should still think you can have that.
I'll talk to him. What's he doing?
No way.
I can talk to him.
Do you think that would work?
Like, he's gonna get lifelong.
I need butter.
He literally said in his statement, I did it. I invented 350 pounds. Yeah, I didn't do it.
I don't need any more, but I might want some more. I'm actually not supposed to be eating candy anymore. So I gotta go to the house to do this. It's you know, we're gonna have 4 calories. Oh, I'm so sorry. I'm so sorry. I'm not making that any better. Okay. I heard they put cavities, then I won't eat candy anymore. But I'm just prone to cavities. They need some special toothpaste. Boy, excuse me. I don't think that's gonna work. What? Adam talking to him.
You know, I'm trying. See what's gonna happen with Adam's case. We got plenty trials going on. That's it. We can go.
Other kids in life, it doesn't get dark as night. I have to take walks in the evening.
Yeah, I know. I gotta walk my dog tonight. Yeah, I gotta take mine when I get home. That's not good. I don't have any allergies, so the pollen doesn't bother me.
It doesn't bother me, but I heard
Oh. You know, she was
freezing.
freezing when I was taking her out. I forget dogs get allergies.
Yeah, my husband took him out. It hasn't bothered him yet that I noticed.
Yeah.
But then again, he's only like on his own.
Oh, you have a puppy.
And my husband took him out and then
Let me
run
see
it
the
back.
puppy.
It's my baby. My husband, I got just like my kid. My husband said I had my photos full of pictures of it. Before I had my baby, I had to clothes with all of it. I got, but it happened. Let's push this back.
Yeah,
My daughter.
very much.
Oh, goodness. My daughter loves.
When
What you do? So I bought it. That is, she loves that out. She loves that show.
Hey, Jeffrey.
Oh, is she?
Oh, it's a boy. Oh, he's
What's his name?
Teddy. Because he looks like a dad.
He's cute.
Oh.
So he doesn't look like it now. His
You let her know.
This is right now.
Hey, let her know. Yeah.
His fur is.
All right, appreciate it.
My oldest son was like, I'm back. I guess I'm back. Oh, cool. So we looked them. Oh, I got it right there. And I know I was back in his first day. And I was like, oh. So my mom was like,
Does he cry when
he used to. He used to. He's gotten so much better and so much just sits there and let me like. Yeah, trying to dry him off.
Yeah. I used to take the dryer. She'd be so scared.
He's never thought of the drawing.
Yeah.
He's still practicing out of here. I tried. And he kept on.
Yeah, so it's like, but now I just pay for the groomers. There's a mobile grooming company that comes, and like park in our lot and they take her and put the washer and put her in nails and all that stuff.
Oh, I need to try it again.
Oh, what's the name of it? Let me see what that. Oh. But I'm not sure if they would come to all sides of town. What side of town do you live in?
I'm in Harry County.
Okay, I'm in Tucker, so that's
That's opposite sides.
they can't hear me over. I'm saying let's take that. I don't know. I just want people to prefer pets friendly. From yeah, yeah, cute. That's cute. And they have a little man tracking it on. We do a really good job. It's real nice them. I was gonna stay, but I think I'm about to leave. You finished? Yeah. I just wanna stay because it's always gonna be here, so I said. Let's see what he has to say. Wait, you're gonna go to him with yours? Yeah, I was gonna stay for him, but it's taking too long. Well, I gotta leave by 4. I have things to do. But I don't know how much you actually need today, besides get traffic. Yeah. The Tucker, so if I leave out by 4, it's not bad. I was gonna say, yeah, never mind. Yeah. Well, you I did it. Yeah. I like Tucker though.
Must be a lot of, must be warm out.
Worn out.
Warm.
Oh. Yeah, it's supposed to be 75 today. And then tomorrow's gonna be like 80.
Yeah, it's supposed to be in the close to the 80s again for the week.
I love it. I hate the cold.
I'm too.
Well, it's not like 90. That's when it's too hot. But like 80 is nice.
I'm you with 80. What is Pierce doing today?
Well, who? Mr. Pierce?
Yeah, what?
I think he's doing his plea in a rain method, maybe, because now that he's representing himself.
Yeah.
Just, I don't know if judge makes someone sit when they're sovereign citizen. Like, I don't know if I'm still gonna have to sit and just not do anything at the trial. Some judges make you do that, just sit. I don't know.
Always not.
I was like, how long is this going to be allowed? He was talking about the Pope, and then he said something about 1862. I was like, what is he talking about?
My favorite was the, when it's, he said something about once it's been determined that I have been found not counted to turn on not guilty. The courts,
Oh, they owe him all this money. I just like that. It's always.
Just like, you know,
They'll be trolling.
at that point, I had to roll away because I was like, oh, okay.
That, he has a one point that when we were born, we didn't sign a contract to be United States citizens. We were just born. That was actually true.
Oh. That's a pretty hefty number, man.
Acting like he's writing it down, like for what? It's going to be a ridiculous trial.
Yeah, I used to go out work at Clayton County. We used to get, services.
Mm-hmm.
because they were coming from hundreds of thousands of documents about why you shouldn't pay for it.
But then my thing is like, have you seen someone else do it and it worked? So why are you doing it?
Okay, so in our office, we used to have this show, running show. There would be somebody somewhere is giving like classes. And we figured, because they would come like from.
They must have
We
been
figured every time they would come from that, we figured somebody graduated.
But it's like, are they telling them a success rate though? Because I would, if I was doing, I would want to know.
And every, somebody is not giving the whole truth, it's because then about 4 months later, after they found like thousands of documents, and they're on our list of your house is getting ready to be auctioned. And yes, I have had some. Now, they usually come in trying to start throwing at this. They come in angry, don't know why. And so after I used to develop or orchestra, and I was like, okay, what we gonna do today? And they would come in with $50,000 and I was like, all right, and then they would come in after realizing, yeah, the county's gonna take your house. And they come in with, oh no, I ain't still have all my stuff. Or I remember one guy came in and filed his own documents. Because that's crazy.
Ms. Rivers, you know, I have to leave to be black and sit still. She watched me move by one leg look to the left to the right. I don't know what he's gonna do.
All right. Ms. Rivers is back, so I'm back. Are we ready for Mr. Pierce? So I have this, which was from you.
Yes, sir.
Is there anything additional?
There's the digital media, but I don't think you can take that. That's
No.
it. That's all the paper.
Okay. Can we bring Mr. Pierce out, please? Hey, Mr. Pierce, come to the podium, please. Give me 1 second. Finding out about your scheduling order. Okay, let's get on the record, please, Ms. Rivers. This is 24 SC 003257, State versus Ricky Pierce. Mr. Pierce is in court. He was at an earlier proceeding. He and I had a long conversation about self-representation. I've entered an order allowing him to represent himself or honoring his request to represent himself. Today, we're going to cover 3 things, Mr. Pierce. One, we need to do your arraignment because we weren't sure if you were going to have a lawyer or be your own representative. I held off on arraignment, so we got to do arraignment. 2, I'm going to, on the record, get you the paper part of your discovery, which you can take with you. And then 3, we're going to talk about scheduling so that your case catches up with Mr. Baker's. So let's start with the arraignment.
Before we can get into that, it's a lot of issues that I had that I want to address before we get started with the arraignment. It's a lot of issues, a lot of questions that I have that I need to be answered.
Okay. So why don't you give me an example of one of the questions, and then I'm actually going to decide whether we do arraignment first or your questions first.
Well, the law state that in Hagan versus Levine state that anytime a jurisdiction is challenged, that it must be proven before the case proceeds.
Okay.
And you're trying to proceed with this case without establishing jurisdiction first. That's the law, Your Honor.
Okay. It will work better as you and I are working together on this. If you've got legal concerns, you put them into a motion. So
I
if
have
you
filed a motion already, but Your Honor.
So I'm gonna look and see what's in the docket.
It states that a court cannot proceed without establishing jurisdiction first, Your Honor. This
Okay.
is the law. I'm not saying nothing that's against the laws of Georgia, Your Honor, or United States.
She can't take down, you talk that fast. She's trying to take down everything you say.
Right. So pause. Just hold on, Mr. Pierce. I'm looking in the docket here, and I'm not seeing that you filed, and it just may not have made it yet, that you filed a motion challenging jurisdiction. But I'm happy to let you know right now, I'm real comfortable with the court's jurisdiction. That doesn't mean I won't.
Your Honor, it states that the proof of jurisdiction beyond a reasonable doubt is asserted. I'm the one asserting jurisdiction here, Your Honor. So that means I have to prove jurisdiction, but you got to give me the opportunity. If you don't give me the opportunity, you're violating my rights, Your Honor.
What's in your mouth?
Paper.
Oh, okay. I just want to make sure everything.
But yeah, the law states that the asserter establishes jurisdiction is to prove jurisdiction, Your Honor. You're not letting me do that.
Okay.
You're not.
Okay. Well, I got you. So one, we got to speak slowly, and two, now I'm better understanding. You're saying you want to prove jurisdiction?
Yeah, I'm the asserter. Can I just read my question? Just go through it's not that long.
Okay. You said a whole bunch, but if it's not that long, how about I listen to you?
Your Honor, it's a lot of things I'm not understanding right now, and it's a lot of questions I need you to answer. So I can better understand what is going on up until this point, Your Honor. Like, hey, I changed the court's jurisdiction on March the 4th, 2025, and also filed a motion that's right here I have signed by the clerk saying that it's been filed in office. This is the motion right here that I have filed. I have here something, copies back and everything. And plus, the courts are still trying to proceed with my case when you guys lack subject matter jurisdiction. Plus, it states in Louisville versus Motley, if any tribunal find absent of proof of jurisdiction over a person or subject matter, the case must be dismissed.
Okay, slow down. I'm gonna let you keep reading. Just slow down so Ms. Rivers can get what you're saying.
And also, Your Honor, once jurisdiction is changed, it is to be proven not by the courts, but by the party attempting to assert jurisdiction, which will be me. Your Honor, the burden of proof lies with the asserter.
Okay, I'm now finding, it just wasn't listed as a motion, but I do see it's in the docket right here. Something that you filed, it's entitled Pro Se.
With a prohibition.
Right, got it. So I've got that. I will rule on that. I'm gonna give the state a chance to respond. But you just filed, you filed it a couple weeks ago. And so I'll get input from the state on that. And then I do owe you a ruling on that. That does not prevent us from doing the arraignment.
Yeah, it does, Your Honor, because the law states that anytime a court jurisdiction is challenged, it must be proven before the case can proceed, Your Honor.
Okay.
So I challenged the jurisdiction last month, March the 4th. So that means that you have to set a court date for me to prove that you lack subject matter jurisdiction. That means I have to bring my evidence, the state bring their evidence, show jurisdiction, and I'm not a statutory entity, so therefore statutory law don't apply to me, Your Honor.
Is the writ of replevy, is that your challenge to jurisdiction, or is there another one?
That's to go with my writ of prohibition.
Okay. Let me see if I got
my
that.
writ of prohibition, I filed 2 motions.
Okay, let me just take a look here.
I have a lot of questions that I need to be asked.
As long as you read slowly, we'll get through that. Okay, I think I've got your writ of prohibition also. And is that the challenge to jurisdiction?
Is that for fraudulent practices, misrepresentation, and lack of subject matter jurisdiction? Yes.
Okay, I see that. It says for fraud. Yep, they're all there. All right, so you filed them. I'm making a list here of things that I need to work on, and then I'll need to let the state respond. The way it works, if you file a motion, the state gets a chance to respond. Once I have both sides, then I can rule on that, okay?
I mean, but you're still trying to proceed with the case, Your Honor, when we haven't established, you trying to get me to plead when this case is supposed to be at a standstill when I changed the jurisdiction March the 4th of last month. So that means you have to prove jurisdiction before I even make a plea on this, Your Honor.
I'm fine delaying the arraignment while we work through this. We don't have to do the arraignment today. I can hold on to the discovery and get you that another time. If you would prefer that I let the state respond and then I rule on it, we can handle it that way. Is that what you'd like?
I would like if we can just answer these questions that's had right in front of me today, Your Honor.
So then don't read the motion anymore and tell me what are your
I wasn't
questions.
reading the motion. I was reading what I have wrote down, my issues I have.
Okay, but ask questions instead of telling me about these cases.
Your Honor, I am on, let the record reflect that this is the defendant, this birth certificate, which is the person / persona, which is a legal fiction, also a statutory entity.
Okay, I need you to slow down a little bit. So, Ms.
Let the record reflect, Your Honor, that this birth certificate is the defendant. I'm physically showing the birth certificate, everyone in the courtroom, that this is the defendant and I am the defense.
Okay.
Your Honor, I am only here in this courtroom by special appearance on the threat and duress to administer affairs of the Our Cap Trust, which is this birth certificate.
Okay.
As a sole beneficiary.
You told me you had questions. Tell me.
Yeah, I'm getting to it. I'm just introducing to the question, Your Honor.
I want you to go straight to the question now.
Your Honor, is this courtroom a court of records?
Okay, what's your next question?
You can answer it? Is this courtroom
I want to know what your questions are.
I'm asking the question, Your Honor, is this courtroom a court of records?
So I thought you were going to share with me what the questions were. I didn't tell you if I was going to answer the questions. You said you had a bunch of questions.
So you're going to have me ask questions that you're not going to answer, Your Honor? That's not fair.
Well, don't ask the questions then. You don't have to ask the questions. You said you wanted to ask your questions, and I'm happy to hear them. If it's appropriate for me to answer them, I will.
So you don't think me asking is this court of records appropriate?
I didn't say it was appropriate or inappropriate. I just needed to know what your questions were. And if they're ones that I should answer right now, like what time is it? I can tell you, 3:51.
Yeah, and I'm asking something very simple, Your Honor. Is this courtroom a court of records?
All right, and what's your next question?
Your Honor, is your courtroom a court of records? I can't get
That
past
seems like the
these
first
questions
question.
need to be answered before, Your Honor. This question need to be answered for me to proceed, Your Honor.
Okay, tell me
I'm
what
trying to
you,
get an understanding. If you're not trying to help me get an understanding,
tell me what you mean by a court of records.
is this a court of records? It's simple.
I don't know what that means.
Is this courtroom a court of records?
I don't know what court of records means.
Do they record and proceed on everything that's happening in this courtroom? Do they record and document everything that's happening in this courtroom?
I don't know about everything, but as long as as long as you're speaking slowly and clearly, then things are being taken down. What's your next question?
Is this Fulton County courtroom a court of records? The same question. You're not answering, Your Honor. You're trying to dodge the question.
No, I'm not. I want to make sure I understand the question.
Is this Fulton County courtroom a court of records?
At times it is.
And are you sure this courtroom is a court of records?
If court of records means we take down what is said in court, then yes, sometimes this is a court of records.
For the record, Your Honor, I go by Ricky DeMond Pierce, all lowercase letters, nothing more, nothing less. Again, I'm here by special appearance on the threat and duress to again administer affairs of the Our Cash Trust as the sole beneficiary and a shareholder of the trust, which again is this birth certificate. Okay, I'm also the executive of this estate, and I'm not the living person, not the person or persona, which is a statutory entity. I'm not the all caps legal official on my corporation. I'm the living man, and I have proof signed by your government agreeing to the same.
So what's your next question?
Your Honor, before we could proceed with this matter, I have a few questions I need for you to answer. First, Your Honor, are you practicing color law behind the bench?
I'm not sure what you mean.
Are you practicing color law behind the bench? Because Title 18 U.S.C. Section 242 clearly states that you are committing a felony if you are doing so. Title 18 states, whoever on the color of any law, statute, ordinance, regulation, or custom willfully subject any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured by and protected by the constitutional laws of the United States shall be found under this title or in prison not more than 1 year or both. And if bodily injury results from acts committed in violation of this section, or if such acts include the use, attempted use, or threat of use of a dangerous weapon, explosive, or fire, shall be found under this title or in prison no more than 10 years or both. And if death results from the acts committed in violation of this section, and if such acts include kidnapping, attempted to kill, shall be found under this title or in prison for a term of years or for life or both, or may be sentenced to death. Now my question, let the record reflect that no legal or lawful matter can proceed without jurisdiction, Your Honor. We both know this.
Right. So we're going in circles. We're back.
Let me finish. Your Honor, my question to you is Your Honor, for the record, is this matter a criminal matter or a civil matter?
What do you think?
I just want to answer.
You're standing there in handcuffs. You're wearing a jail outfit.
Can you please answer the question for me, please?
That's my answer. I'm answering with a question. What do you think? Lowercase
I don't know.
r,
I don't know,
lowercase
Your
p.
Honor. That's why I'm asking. I don't know.
think you
That's
do
why
know.
I'm asking.
What's your next question? Ask me a question.
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Ask a question you don't know the answer to.
I don't know that. I'm telling you, how you gonna tell me what I know, Your Honor?
Well, if it were a civil matter, would you be having to use the restroom in front of everyone else?
Oh no, that's why I'm asking you, Your Honor. I'm coming to you as fast as I know how, Your Honor, and humble as I know how. I don't know. That's why I'm asking the question.
Okay. What's your next question?
Your Honor, for the record, is this matter a criminal matter or a civil matter?
Okay, that would be your next question. That's one you already asked.
Why we can't pass this question, Your Honor, because I lack knowledge to understand what is going on. And I'm telling you this, and it's my authority to let the court know when I don't understand something.
A fair point. I want you to let me know when you don't understand. We already covered that when we had our Feretta hearing. We talked about what kind of case it is and the penalties you face.
I said, is this a criminal matter or a civil matter?
How much more time do you need? Because you got about 3 minutes before I'm going to bring someone out here that we can move the case along.
Your Honor, I just want you to answer my questions because I lack knowledge to understand what's going on. I'm just trying to keep caught up to date to understand what is going on.
Okay.
There's no harm in that, Your Honor.
What's your next question?
It's the same question. Before I can get to the next question, I have to answer this question.
Go to the next question. You just said you're not gonna answer.
Your Honor, for the record, is this matter a criminal matter or a civil matter, Your Honor?
All right, we're done. I will bring you back once the state has responded to your motions, and I will likely be entering an order that lets you know my thoughts about jurisdiction. Once I've done that, you can choose to participate in an arraignment, but you do need to understand that in a criminal case, that's a clue.
So this is all a criminal matter. Why you couldn't answer the first time, Your Honor?
Why are you asking in the first
Because
time?
I'm trying to I just told you I'm trying to get an understanding.
So let me finish. So you understand that in a criminal case.
So this is a criminal matter, for the record.
Such as yours, if you choose not to participate,
This is a
participate,
criminal matter or a civil matter, Your
you
Honor.
need to stop interrupting, okay?
I'm trying to understand something. It's my right to, if I don't understand something, to bring it to your attention, Your Honor. That's the law.
Well, it's not the law, it's how you're choosing to proceed. If you decide not to participate in arraignment, I'm authorized by law to enter a plea of not guilty. And that's what I'll do. So when I see you again, we're gonna try again with
So
the
you're
arraignment.
gonna violate the laws to when it states that a case cannot proceed without establishing jurisdiction first. So you're just gonna ignore that?
Nope, I'm gonna rule on your motion, and after I've done that, then I'll bring you back for arraignment, and you can choose to participate in it or not. I'm just letting you know in advance, so you're not disappointed.
I'm not gonna participate in it until you establish jurisdiction on me first. That's the first thing first. We're not gonna skip the process. This due process of law for a reason, Your Honor.
It is, and that's why we're not.
And in Hagen versus Levine, it states that anytime a jurisdiction is challenged, is to be proven before the case can proceed. That is the law. That is not nothing that I made up, Your Honor.
Okay, you may be misapplying it, but I'm not disagreeing.
I'm not just, I done read it 1,000 times, Your Honor.
Okay, well then you know it. So that's why we're not doing the arraignment today. I'll take care of establishing jurisdiction. And once I've done that, I'm comfortable that I've established jurisdiction, we'll bring you back for an arraignment. You can participate or not, but we'll have cleared that hurdle that you,
If you haven't, I'm not gonna participate, if you can't establish jurisdiction over my case first, why would I participate?
you don't need to participate. I'll bring you out. You can say no, thank you. We take you back there. We bring the jury
I
in.
mean, Your Honor, I have issues and it's,
You do.
yeah,
You do.
yeah, and we both do, Your Honor.
And my responses, do I address them to, as Mr. Pierce has recognized to start the day as lowercase r, P, the rest of his name, because he signs all of his motions with uppercase R, uppercase P, uppercase.
No, I don't, I do uppercase or lowercase everything else, dash. I don't have an sentence, I have an autograph.
It's just different. Out of respect, I just was curious. It's different than what he.
Let me show you.
I got it right here.
Right, no, I'm looking at it. It's capital R, capital P.
No.
Oh, yes. But that's all right.
Is that all caps?
No, it's not all caps, but you capitalize each word.
This is all cap. Is this your handwriting?
What?
That's all caps.
Oh, that's awkward. All right.
Is that in all caps?
So how about this, Mr. Pierce? I'm going to agree that you have written it in different ways, and I'm really not going to get hung up on that.
I'm not all, like I got the paperwork right here signed by the government saying I'm not a part of y'all, and it's on file with the office, it's filed in office. My paper right here shows that I'm not the all caps legal official signed by y'all government.
Good.
Signed by y'all government saying I'm not the all caps.
I will not use all caps. I will not use all caps.
Signed by you guys government.
You guys, okay.
Because I'm a national, not a citizen. Y'all are citizens. I'm not.
I remember you establishing that before. We don't need to cover that again.
It was very much that I present it at every court because it's for the record. Now it's my job to put it on the record, Your Honor.
Okay, it's back on the record. We're incorporating in this hearing what you put on the record at the last hearing, and we'll do that every time. Anything else you want to cover? Because I'm happy to give you this discovery, but you can't have it.
I don't want to
until
proceed until I get my question answered, Your Honor.
All right. Why don't you do this? If you want to put them in writing, you could file them and I can get you those answers. But we're wasting not your time or mine, an important conversation, but there are a lot of other people here who are stuck while you ask questions like, is this a criminal matter or a civil matter? So.
Right, because I don't understand.
Okay.
And I just want to ask you where is the problem just answering the question, Your Honor? Because I let the knowledge to know.
Okay. I feel your lack of knowledge, and I'll bring you back after I've responded to the motions you filed. That's the way we're going to interact here. If there's something you want an answer for or ruling on, you need to file it. And you know how to do it. You did it well. Okay? I'll keep your discovery warm and dry in my office.
Well, so would you just continue this court date or something?
Yeah, we can't do the arraignment today. You've helped me understand why. You want me to
Because
establish.
you can't proceed with my case until you establish jurisdiction over my case, Your Honor.
That's right.
That's the law.
It is the law.
So what's the problem with me asking the question to better understand what's going on?
Well, I don't even have jurisdiction yet. Let me establish that, then I'll be in a position to have a conversation with you.
And we're not talking about statutory jurisdiction. We're talking about the Constitution jurisdiction.
We're talking about whatever jurisdiction I find. Okay? I'll see you soon.
Bye, Judge.
That went differently than I expected. Really? I thought just by letting him vent that first time, he sort of like he purged himself. Clearly not.
Your Honor, I have an announcement on Mr. Estrada's case.
Yes, let me turn to that calendar. This was just a fun little carryover from this morning. Mr. Estrada is right here. Yes, ma'am.
I discussed it with the state. I resolved the discovery issue. It was an email issue, but I've got it in my inbox now. So we got an offer. We got the other mitigating factors that I'm going to send to her. We're going to work on it. We are reserving the final plea. I'm just asking for continuance, Your Honor. So like I said, the link was a little different for me.
Sure. So we'll move Mr. Estrada's case to where it is, which is on the May 8th trial calendar, but we'll preserve the final plea rights. If you all sort something out in advance of May 8th, please let Ms. Nelson know because we don't need to wait that long. And May 8th will be a hectic day, but that can be when we sort it out. If it's not resolved on May 8th, then the case will be it's on the trial calendar. That's just when we call the trial calendar. But if it's not resolved that day, then we'll go forward to trial. And of course, Mr. Estrada can always enter a plea after that date. He just wouldn't be able to withdraw it if the sentence were other than what you advocated for. Okay?
I'm hopeful we can find a resolution before then.
Sounds good. Mr. Estrada, do you have any questions?
No, sir.
Okay, sorry it took so long. You saw we had sort of a crazy morning. And then afternoon. We'll see you guys on the 8th unless you reach out before then. All right.
See your email. Okay, my worksheet and
So is Taylor all that's left, or do I need to interact with Mr. Dandridge?
He's already gone, Judge.
Well, boom. All right. Yes, thank you, everyone. I can't remember if he rolled over to May. He may have to wait till June. I haven't seen May. If he rolled over to the April calendar. I don't think he's on the April calendar.
I think he is.
I think the registry case is at least.
Oh, then we would have added the other one as a supplement. We wouldn't just put the registry on. I didn't bring it out here. He was, because in theory, he was going to go in front of Judge Emerson yesterday. But that trial he has is still going. So we just cut that calendar off. So maybe it'll be ready to go in April.
Are we meeting this afternoon about the trial calendar?
Oh, was that today?
It's when?
Oh, yeah, it's right now. Huh. I guess I should get that calendar, but we need to do Mr. Taylor's pleas, and then, yes, we'll talk about that. I can't keep you long. I gotta leave at 5. I'm teaching something at Georgia State.
Judge, for Mr. Taylor, Ms. Dilligard is going to handle my portion of the plea. I've given her all the she needs. Leave about 4:15, so I'm going to go ahead and.
You're comfortable leaving it in her hands?
Yes.
All right.
He's gone.
I thought we bought.
You did. Mr. Body was very kind and spoke to Mr. Dandridge in the back.
You talked to him too? Didn't work. A hard-headed gentleman. Let's try it. Mr. Taylor, how are you?
We meet again, how are you?
We do meet again. Mr. Taylor, you've got 2 cases on our final plea calendar. Ms. Wood tells me you're prepared to resolve both of them. Is that correct?
That's correct.
Okay. In a moment, we are going to move forward with that. Ms. Dilligard just needs to reposition. We had a talkative defendant out here just before you, and people moved around a little bit. But Ms. Dilligard will put you under oath. Once you're under oath, it'll be important that you answer all her questions completely. And let me or Ms. Wood know if you've got any questions of your own. Will you do that?
Yes, sir.
Okay. You can take your time getting ready, but when you are ready, we are.
God, I'm on TV.
On YouTube. Yes.
Yeah.
Yeah, Mr. Dandridge is on for the April calendar.
Yeah, thank you.
You're not waiting on me, right?
No, I'm just
Good.
thinking this next really fast.
Okay.
Great.
No, it's all right.
I'm sorry.
I believe I can kind of get started while I wait on this.
Okay. Should we make her come back?
It's okay.
Okay.
Okay, let's see. Mr. Taylor, can you please raise your right hand to your best of your ability? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Solemnly swear.
Okay, you can lower your hand. Please state your true, correct, and legal name for the record.
Jeremy Artez Taylor.
Mr. Taylor, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Tylenol.
Okay. And that medication doesn't affect your ability to understand the proceeding, correct?
Oh, no.
Is there any medication that you normally take that you have not been taken or given today?
No, ma'am.
How old are you and how far have you gone in school?
B3, Bachelor Associates. Computer Science.
Do you understand that you've been charged with the following offenses? In one case, you've been charged with willful obstruction of law enforcement officers by use of threat or violence. Then there's a misdemeanor willful obstruction of law enforcement officers, criminal trespass, and certain acts bus rail station prohibited. In your other case, ending in 5415, you have one count of state sex offender registry violation.
I understand.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I understand.
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
I understand.
Have you had enough time to speak with your lawyer about all the charges in both of these indictments, including the facts and circumstances related to the charges?
I have.
Would you like any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes. Actually, can I get like 30 seconds?
Sure. Do you need to go back there or is it okay? Just take a couple steps backwards. They'll deal with it. If you turn away from the microphone, take one step.
Put it on the record. When it's my turn to talk, I'll explain to the judge. Okay?
Got action.
We're good? Okay.
So are you satisfied with your lawyer services?
Completely.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
So waived.
Mr. Taylor, do you remember being arrested on these charges?
You say so. Yeah, I do.
You do. Okay. Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For the willful obstruction by use of threats or force, the range is 1 to 5 years. On willful obstruction of law enforcement, the criminal trespass, and the certain acts, bus, rail station prohibited, the range is 1 day to 12 months. And on the state sex offender registry violation, the range is 5 years to 30 years.
Yes, I understand.
Okay. Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence? Judge, to resolve both cases, the recommendation is 5 years of probation, a mental health evaluation and treatment as recommended, and to maintain his registry.
Understand.
Okay. Do you understand that the court is not required to accept the state's recommended sentence?
Unfortunately, yes.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Understand.
Do you understand that if there are multiple charges to which you're pleading guilty to today, that the court also has the right to run those sentences consecutively?
I understand.
And do you understand that if the court decides to enter a plea that you were not expecting today, that you have the right to withdraw your plea of guilty?
I do understand.
Are you currently on probation or parole anywhere?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, I understand.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes. I presume I'll be given a list of those.
What was the,
Yeah, I missed it.
I think he's asking a list of his special conditions.
yeah, I'll be spelling those out, but you already heard them. It's that you'll submit to a mental health evaluation, and if any treatment is recommended,
Those were the special.
those were the special conditions, and that you maintain your registration on the registry.
Yes, sir, I understand.
That's it so far. I'm always free to add one if I hear and think, oh, this would be helpful as well. But I will spell them out when it gets to the sentencing part of the conversation.
Okay.
Do you understand that you are not allowed to possess or use a firearm while on probation?
I understand.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
I understand.
Is it your decision to waive these rights and enter a guilty plea today?
It is.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No. No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Okay. Mr. Taylor, how do you plead to the charges of willful obstruction of law enforcement officers by use of threats or violence, willful obstruction of law enforcement officers, criminal trespass, certain acts, bus, rail, station prohibited, and indictment number 24SC 002533?
Guilty is charged.
And Mr. Taylor, how do you plead to one count of state sex offender registry violation and indictment number 24SC 005415?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
I understand.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes,
You understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you have 12 months from today to file that petition?
I understand.
Okay. Judge, I'm going to start with the 24 SC 002533. If that case were to proceed to trial, the evidence would show that on December 3rd of 2022, while officers were patrolling the Marta Lindbergh station, they observed Mr. Taylor smoking a cigarette on the platform in an area that signs posted "No smoking." Officers instructed Mr. Taylor to put the cigarette out. However, he continued to smoke the cigarette. He was asked to provide ID. He refused and walked off. Officers instructed him that he had to leave the station and issued him a verbal criminal trespass warning. As he was exiting the station, he began using profanity, saying the F word, and officers continued to explain that he had a criminal trespass warning. He also stated to the officer to take the camera off. I bet I'll pop your PUSSY ass. Okay. And all that was captured on the officer's body worn camera. And Taylor was checked, and he had a MARTA suspension, an active MARTA suspension that was issued on September 23rd of 2020.
It's a MARTA suspension. Meaning you're not supposed to be on MARTA property?
Yeah, they restricted me. Prior to that, they restricted me from coming in because I just walked through the
Okay.
like, whatever it is, I just walked through.
Okay, so suspension means you're not supposed to be here.
I wasn't supposed to be there.
Okay. All right.
Okay. And then for the other case, Misc, that the defendant did not report within 72 hours of his birthday of October 19th. Sounds like after being convicted of sexual battery of a minor on 12/16/2009 in Spalding County, which is a conviction that requires him to register.
Okay. And so this would have been an October 24 violation? I don't have the indictment in front of me, but.
Yes, Judge.
Okay. Got it. Okay. Thank you. I think that covers everything. There's an unindicted case. That's going to stay out there. We're not resolving it today, obviously.
I'll
but
tell you about it, Judge.
Okay. I mean, I've read about it.
Yeah.
A cigarette lighter at a Home Depot, but it's out there. I just don't want anyone to be surprised that it's out there. It's got your name on it. And obviously Mr. Taylor's, but not mine. Okay. All right. Let's hear from Ms. Jackson and then get her on her way after this long day. Ms. Jackson, any criminal history information on Mr. Taylor?
Yes, Your Honor. He has 40 cycles. The last arrest was May the 30th, 2024 in Chamblee, Georgia, for theft by shoplifting, a misdemeanor. He does have felony convictions. It's one in 2016 out of Spalding County for a failure to comply with a register. One in 2015 out of Henry County for a failure to comply with a register. And one in 2009 out of Spalding County for the charge associated with the CWAC. And he does have misdemeanor convictions. It's one in 2024 out of Chamblee, Georgia for theft by shoplifting. One in 2022 for criminal trespassing. He received a nolo contendere sentence in 2019 for a fray. There was one in 2015 out of Spalding County for driving without a valid license and disorderly conduct and giving false information to an officer. Nothing in addition, Your Honor.
Thank you, Ms. Jackson, and thank you for your help throughout the day.
Thank you. Have a great day.
You too. Ms. Wood.
Yes, Judge. So those two unindicted cases, we had hoped that we would be able to get those indicted and wrap it all up globally. We were unable to do that. I've explained to him, he does have a bond on those two cases. I'm not sure if he's going to make it or not. But I've explained to him, our office works with our justice partners to try to work something out for nonviolent offenders who have low reasonable bonds. He has been in collectively on these two cases 387 days total. I sent Ms. Dawson the breakdown, but for the 2533 case, it was 283 days total, and then the 5415 case, it's 104 days total. I don't know if Your Honor wants to structure it so that that's included in the sentence, which might mean more probation. I will leave that to your discretion. We're just asking that you accept the state's recommendation in this case.
Got it. Okay.
Your Honor?
Yes.
If I may?
It's your turn. I was about to turn to you to ask you if there's anything you wanted to say. Don't talk about these new charges?
I won't.
Good. Okay.
I just want to like give a brief factual basis on something.
For which?
For all this.
For everything.
Just what's going on in my life, okay?
Okay.
Because you're presiding over things right now, and I don't want you to get the wrong idea about me. If you are, I don't,
Assume that I have very little idea because I barely know you. I hear all the worst about you. You've got this sex offense. You haven't registered. But I don't see you with horns over your head. You're human, and you made some choices that got you in trouble.
2009, I was 17, and I was involved with a girl who was 15.
Okay.
And because of that, her parents went crazy. They caught us having sex. I got a sexual battery against a minor. Because of that, the registry, they told me to register. Yeah, it's been a burden my entire life for the last 15 years.
Yep.
So, and because of that, I've been exposed to drugs because I haven't had anywhere to go. And I'm just being as honest as I can. Like, so if there's any rehabilitative services you can offer, I need those.
Okay.
I need help.
When did you go to college? After the situation in Spalding?
In prison, I attended college services to Marshall University.
Good for you.
So
you're going to drive the court reporter crazy if you keep jingling the chains. So don't jingle the chains anymore.
It's a nervous ticket.
That's okay. All right. I appreciate you sharing that. That's helpful context. But you should know, unless, like I've already heard the trial and seen pictures of someone chopping someone's head off, I don't look at you as anything other than probably someone in need, because that's how you got sideways with what's going on. There's a limit to the kind of support I can provide, which is a frustrating part of this job. But the fact that you are looking for help is a good sign. Some people come in angry, they don't want help, and they're going to take it out on themselves or others. You seem to be self-aware in a way that is good.
I just don't want to fail the court again, or the court fail me.
All right, you're not gonna be failing me. If we come back, I just like, all right, there are consequences. So yeah, failing you is what you want to avoid. When you get out, where do you go? Do you have a safe, stable location?
I have two.
Okay. Is it family or friends?
Family.
Okay, that's good. And is it in Georgia?
It's in Georgia.
Okay, good. All right. Mr. Taylor, I find there's a factual basis for both your pleas. You got to figure out the registry thing. This is your third time. And I bring that up not to say, oh my gosh, the sky is falling, but you will fail to register in some jurisdiction where they say, great, 20 to serve, because we're scared that we don't know where you are. That's not happening today. It's just me letting you know that if you compile a few more of these, some prosecutor and some judge are going to agree that you need to be out of commission for a long time. And it's so easy to avoid that one. You just got to register. And it's your birthday. It's a easy date to remember. I also find that your pleas are knowing and voluntary. You're very aware of what we're doing here, very intelligent, and voluntary just means no one's forcing you to do this. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you're on probation, if you have a small issue on probation, you and probation work through that. You have a little administrative hearing with them. But if you get arrested for anything, like failing to register, that comes back to me. Not the new charges necessarily, but that issue while you're on probation. Ms. Dilligard, can someone in my office sign the 2 indictments on your behalf?
Yes, Judge.
Ms. Wood?
Yes, Judge.
Mr. Taylor, can we sign on your behalf indicating your guilty plea on the 2 indictments?
Yes, you may.
We'll do that. Do you have a weapons carry license?
No.
All right. Anything more you want to add?
Thank you for helping me. Thank you.
I wish I could help you more, but I am going to do the following. In the case ending in 533, I am sentencing you on counts 2, 3, and 4 to 10 months to serve. You will get credit for 200, I was gonna say, well, I did math wrong, 284 days. You were in for, actually it's 283 days. You were in for 103 days before you bonded out. And then most recently, you've been in for exactly 6 months as of today because of the bench warrant. So you'll get credit for 283 days. You'll do a little bit more. And then count 1, the sentence is 5 years. That'll run consecutive to count 2. 2, 3, and 4 are running concurrently with each other. That's 5 years. It's probated. Special condition of probation number 1 is that you submit to the mental health evaluation, and probation will help you line that up. And then number 2 is that if there's any treatment recommended, whether it's counseling or the doctor says, here's your prescription, you need to take this, that you follow that prescription. Or follow that recommended treatment, not prescription. And then condition 2 sort of goes without saying, but that's that you continue to register. I encourage you to look if addiction remains an issue for you, to support probation can connect you with addiction-related resources. I don't feel comfortable saying you must do that because I don't know enough about your situation. But certainly an example of how this Probation Options Management Act works is if you are testing positive with probation, they don't run to me and say, lock them up. They say, oh, maybe you need to go to the day reporting center or get some drug treatment. So it's a graduated approach before I get involved. In the case ending in 415, the sentence there is 5 years, 5 years to serve 10 months with the balance on probation, and you'll get credit for 284 days in that case. The balance will be probated. It's a little less probation in the case ending in 415, but that case will run concurrently with, at the same time, with your probation in the case ending in 533. And it'll be the same 2 special conditions. Get that evaluation and follow any treatment if it's recommended, and then make sure you stay current with your registry requirements. Ms. Dilligard, anything else from the state?
Nothing further, Judge.
Ms. Wood, on behalf of Mr. Taylor?
No, Judge, thank you.
All right, Mr. Taylor, you will be out soon. You will not be transferred to the Department of Corrections. You'll do a little more time. I'm assuming you're at Rice Street, and then you'll get out. And before you go, you need to get some probation reporting instructions from Ms. Simpson. You stay right there. She can talk loudly.
So, I received your evidence from Ms. Wood. So my understanding, he's not going to be released today or.
Correct. He's got a few more days to get to the 10 months, although the sheriff is able to adjust that. It won't be much longer, but it's not today.
So we're going to report to 276 Memorial Drive. That's about 5 minutes from here. You need to report within 48 hours of your.
Okay. All right.
Thank you, Ms. Simpson.
Thank you, Ms. Simpson.
All right. I know we've had a long day. If you don't mind, Ms. Rivers, thank you. You're good to go. If we can talk for just like 5-ish or minutes about the trial calendar, that would be great. We don't have to be as detailed because it may just be the 3 of us. Ms. Nelson may come out. Is there anyone else back there we haven't talked to? Pierce, want to come back out? Good. Oh, hold on 1 second. All right, so thank you, everyone. And